matter until 2014. But it's equipped to your lordship as a lead matter today. But in a connected matter which has been initiated by ARG Outlier, which is the holding company of Republic of Bangla, well, that is also pending today. But it's not in a position where it can be taken up. But the report which is to be filed by the state regarding other cases against the anchor uh, was to be filed today before your lordship. I was only praying if your lordship permits us to pray that both may be taken up together and will inform the state. Otherwise, they will say that we did
Inform the state.
And well, there is another matter which is very urgent. Well, the ITC had taken over the Wimco factory. Well, certain members of the local club, they are constantly encroaching into the property of the factory. Well, where there is a temple.
Have you filed that? What is that?
Yes. Well, if your lordship only permitted to be taken up on Friday in the first half, I'm led by the.
When is your matter fixed?
Well, it's not appearing as of now.
So let it be listed. Friday it will be listed.
Come on Thursday. That's why.
Huh?
It will come on Thursday.
When is your date fixed in your notice?
Thursday. Well, as per the CIS, Thursday.
So Thursday it will.
Well, if your lordship takes it up on Friday.
So let's see how it moves, or you pray for accommodation on that date.
Well, Thursday it won't be taken. It would appear. It's supposed to appear only in the list.
So let it appear in the list.
Well, your lordship permit us to give
that on that date we'll see what is the position.
What contempt application?
Contempt application tomorrow you mentioned. Tomorrow. Inclusion. Tomorrow.
My lord, may I seek leave to move this petition, my lord? The urgency is, my lord, the petitioner wants to conduct a sit-in demonstration, my lord, from 16th of this month, my lord.
Have you filed that?
My lord, I am seeking leave, my lord.
So file that.
My lord, without leave, my lord, the matter.
File and mention. Thereafter I'll ask them to
my
file it.
In urgent circumstances, my lord, I am paying for your lordship's kind leave. My lord, what happened, my lord? The difficulties, certain properties, I am the owner and occupier in respect of certain properties. Private respondents were trying to taking the forcible possession, against which I approached before the civil court. Civil court decreed the same in my favor. It restrained them from taking forcible possession. Now, my lord, on 20th to 22nd May, the private respondent are trying to holding the Rukkha Kali Puja over my property by dispossessing us, my lord.
It's a lot of time. You file it.
My lord. Great.
Inclusion tomorrow you see it. Release the account.
My lord, I am for the state, my lord. In pursuant to my lord's order, our officer has visited 3 police stations at Puri, and ultimately he was arrested.
So purpose served or what? চলে আসুন। Pursuant to the direction dated 11/4/2025, police authority is took appropriate steps, and the reports today submitted on behalf of the Superintendent of Police, Barigui Police District 8 reflect that on 17/4/2025, now on 16/4/2025, the warranty was arrested. On 17/4/2025, a transit remand prayer was presented before the CJM, Cuttack, Orissa. And on 18/4/2025, the arrested warranty was produced before the ACJM Baripur Court. Also, having regard to the steps which have been taken by the police authorities, I am of the view that the purpose for which the writ petition was preferred has been subserved. Accordingly, WPA 6076 of 2025 is disposed of. Reports were submitted, be kept with the record server copies.
May I have a copy of the report?
Copy of the report we handed over to the learned
Item number 3, I appear.
Yes. চলে আসুন দীপঙ্কর বাবু।
Petitioner has taken a loan, but he did not repay the loan. So the possibly bank people from the bank came to his house and he lodged a complaint, page number 10, my lord. No cognizable offense, nothing has been. And here's the report, man. It is reported.
The writ petition was preferred as the officer in charge, Harwood Point Coastal PA Sundarban Police District did not take any steps. I find that the said representation was made on or about 26th of November 2022. The police report reflects that a loan was taken by the petitioner from the respondent number 4 and the genesis is of the dispute arose from the same.
Allegation has not been substantiated.
The police
During
report
inquiry.
reflects that the allegation made in the representation is not substantiated. Accordingly, I am of the view that no interference is called for. WPA number 664 of 2023 is accordingly dismissed.
No.
Report so submitted be kept with the record. Chalo.
Mal, grateful one.
Item number 4, I am for the petitioner, my lord.
Yes.
The affidavit of service, my lord. Although it is a long service was done, my lord. My lord, petitioners, my lord, kindly come to my lord the page.
Come you appear. Yes.
Kindly come to the page 18, my lord.
Yes.
The land was given to the mother-in-law of the petitioners
Very good.
and my lord, grandmother of the petitioners. Number 2, my lord. My lord, the under section my lord 4 of the West Bengal acquisition of home.
What is your problem? Tell me. I don't want to know.
The private respond. I am constructing the my house, my lord, over the land, my lord. But the private respondent continuously, my lord, threatened it, my lord, to evict from the land, my lord, without, my lord, this
That is
my,
in November 2022.
till, my lord, till then, my lord,
Where
the
is that
encroaching-
last
encroaching-
representation? Where is the last representation?
Last representation, my lord, only 2023, my lord.
So, ठीक है, चले आशो. Petitioner.
At present, my lord, your lordship give me be granted to file a my lord, the representation, and my lord, that will consider.
Petitioner is aggrieved by the fact that in spite of the petitioner is aggrieved by the fact that in spite of the representation made to the police authorities on or about 14th of December 2022, the grievance of the petitioner was not addressed by the concerned police station. Full stop. The basic allegation
Page
is that
23 FIR also, my lord, page 26, my lord, GT, my lord, page 26 GT, and my lord,
ठीक है जी.
my justice also 27, my lord.
Very good. A civil case was pending. Huh? The basic allegation is that the petitioner is being threatened at the behest of the private respondent. I find from the representation that for recovery of possession, a suit was preferred before the London Civil Junior Division, wherein the court was pleased to pass a restraint order. Having considered that the civil court is already insisting of the issue so far as the issues relating to property are concerned, the same would be considered by the civil court. Police authorities would only ensure if, as on date, there is any issue relating to breach of peace. To the full stop. To that effect, petitioner, if he faces the same inconveniences, would inform the police authorities.
Yes,
Full stop. With the aforesaid observations, as none appears on behalf of the state. What is your good name, sir? What is your good name?
Lordship, Benazir Ahmed.
लिखे देना है. Is elected to represent the state. His appearance may be regularized by the concerned authorities. चलो. WPA 234 of 2023 is disposed of several copies. Next. Yes, yes. Five, চলে আসুন. Yes, Mr. Chakraborty, come. The writ petition was preferred. As the representation made to the officer in charge, Cornoshi Police Station, on or about 2/12/2022, was not addressed. Full stop as none appears on behalf of the state. Mrs. Zubsha Chakraborty, learned advocate, who ordinarily appears on behalf of the state, is directed to represent the state. Her appearance will be regularized by the concerned authorities. The accusations in the representation made was to the extent that the petitioner was attempting the private respondent. Actually, yeah, private respondent number 4 was trying to encroach upon the property of the petitioner. To the effect, he was threatened. Considering the nature of the accusations, I am of the view that if the petitioner faces the same inconveniences, a fresh representation be filed before the police authorities would consider the same in accordance with law. With the aforesaid observations, WPA 369 of 2023 is disposed of. Server copies next.
Lordship, kindly give the direction that I can get the copy, Lordship.
কপি যারা যারা আছে একটু দিয়ে দেবেন, হ্যাঁ বলে দেবেন।
Respectful Lordship.
I am a cultivator in possession and of my piece of land, but the private respondents have been disturbing from time to time. I have got section 144 orders in my
Very
favor.
good.
Appear at page
চলে আসুন,
55.
চলে আসুন। Yes, any more junior over here? Mr. Ghosh, any more junior? Any more junior advocate? Petitioner is aggrieved as the representation which was made to the authorities, being the officer in charge, Potashpur Police Station, on or about 20/12/2022, was not addressed. To that effect, petitioner also filed an application under section 144(2) of the CRPC. The main grievance of the petitioner related to possession in respect of the property referred to in the writ petition, as also the crops which are being taken away after the petitioner cultivated the land, and to that effect there was abuse and threatening at the behest of the private respondent. Having regard to the fact that the representation was filed, having regard to the fact that the representation was made on 20/12/2022, I direct that if the petitioner faces the same inconvenience, he would inform the concerned police station afresh. The police authority would consider such representation in accordance with law. You continue to give them as none appears on behalf of the state. Second paragraph.
Abdus Salam.
Mr. Abdul Salam, London advocate, who ordinarily appears on behalf of the state, is directly represent the state. His appearance may be regularized by the concerned authorities. Chalo. The type of accordingly, WPA 628 of 2023 is disposed of. Server copies. Chalo next. Yes,
About the statement.
please, sir.
I hold a certain property, my lord.
Hmm.
And now, since 2022 itself, certain private respondents are trying to encroach my property and subsequently oust me of the same as well. Now, my lord, one of the private respondents, that is respondent number 11, my lord, he is holding a certain power in the entire area because he's a part of the Gram Panchayat, my lord. He holds a lot of power. So I preferred a 124, my lord, and the order is in my favor. Subsequently, I also tried to launch.
Where is that? You have been thrown away. Page 21 doesn't say that.
No, I have not been thrown away yet.
Oh, ঠিক আছে, চলে
I have
আসুন।
not been thrown away yet.
File fresh representation.
My lord, representations are not being taken by the police department at this point.
Last time, how did you give the representation?
My lord, even then, even
How
if the one-
last time? How did you give the
My lord,
representation?
right now the respondent number 11 is using his all the tactics under sleep, which is why my
So that also not allowing you to enter the post office.
my lord, I had
All those reasons you give somewhere, sir. As a learned advocate appearing for the petitioner allege is that the private respondent in number 6 to 11 is trying to encroach upon the property of on the petitioner, and to that extent they had been threatening and using excess force. I've considered the representation which was adverse to the where is the representation to the police authority?
another page.
22 to the officer in charge, Domju Old Police Station. Full stop.
18, my lord.
Learned advocate appearing for the state has submitted a report. The report reflects that at the relevant point of time, police authority is drew a case being Domju PS case number 179 of the 23. Subsequently, charge sheet has also been submitted in connection with the said case, and it has been categorically observed that no construction work is going on over the alleged property. Full stop. Having considered the time period which has lapsed in the meantime, I direct that in case the petitioner face a same inconvenience, he would be at liberty to approach the police authorities. Full stop. The police authority would consider the said representation in accordance with law. With the aforesaid observations, WOPA 1364 of 2023 is disposed of. Several copies. Sure, next.
8.
My lord, in this matter, Ranjan Saha is appearing for the petitioner. Due to his brother's accidental death, he is not coming to the court. My lord, last occasion I have mentioned this, and my lord was it kept it on 19th. Somehow it kept his.
It is there to keep these matters pending before the High Court. You will never have time to do these matters. Is somebody appear for the state? The content, the accusations in the grievance of the petitioner is in regard to a representation which was adverse to the different administrative authorities, including the petitioner, including the officer in charge of Techno City Police Station as well as Rajarhat Police Station. The said representation was sent on or about 12/1/2023. The contents of the representation are in respect of a playground which over which uh, an electricity wire was taken, which the petitioner apprehends may result in an accident. Acha. It has also been represented that the private respondents had been trying to create a terror over the private respondent number 7 and his associates tried to create a terror in respect of encroachment and over the said property, and also threatened the petitioner. Also, having considered the nature of the accusations, I am of the view that if the same situation so persists presently, petitioner would file a fresh representation before the concerned police station. Full stop. The officer in charge, the inspector in charge of the officer in charge of the concerned police station will consider the fresh representation in accordance with law. Full stop. Next. ওই মধ্যখানে ঢুকে দেন, as none appears on behalf of the state, Mr. Kopil Guha, learned advocate who ordinarily appears on behalf of the state, is directed to represent the state. His appearance will be regularized by the concerned authority. Accordingly, to application according to WPA 1620 of 2023 is disposed of. CN 1 1 of 2025 accordingly is also disposed of.
I beg to appear for the bank has initiated steps under the SURFACE Act. An order has been passed by the district magistrate directing the police authorities. There is an order upon the Commissioner of Police, Boshirhat. Lordship will find the order at page 35. Lord, we have deposited the police cost. Lord, police has not rendered the assistance.
My lord, I beg to appear on the respondent number 5, 6, and 8. My lord, there are two essay applications that are pending pertaining to this matter, my lord. My lord, there's an application pending challenging the sections 14 order of the DM.
Where?
My lord, before the learned tribunal, my lord, DRT. My lord, there was already an order passed pertaining to this matter. My lord, regarding my lord interim injunction, which is still subsisting, my lord, and that has been, my lord, continuing till date. Order. My lord, I am handing over the case status, my lord, and matter is fixed on 2nd of July 2025.
To file an affidavit.
My lord.
File an affidavit along with the order. Sure. Let them file an affidavit. Learned advocate affidavit. Learned advocate 8 appearing for the respondent numbers
5, 6, and 8.
5, 6, and 8 submit 8 that already an interim order has been passed by the tribunal. Full stop. Then an advocate for the petitioner is on cost deposited or no?
Cost has been deposited. I have annexed the receipt.
Advocate 8 for the petitioner submit 8 that in spite of deposit 8 of the amount with the police authorities, no steps have been taken. Since the tribunal is already insisting of the issue, learned advocate appearing for the respondent number 456 is directed 568. It is directed to submit 8 to file an affidavit 8 in opposition to the writ petition. Let the same be filed by I. Before the vacations, you can file.
Kindly after make it up.
On 10th of June 2025, affidavit in reply, if any A be filed by how much date? By 18th of June 2025, release the writ petition under the heading for orders on 24th of June 2025. You also bring up all the orders.
My lord. Grateful.
The affidavit of service may be kept on record.
Affidavit of service file be kept with the record. Next.
Grateful.
In.
Yes,
please.
Lord, I seek your lordship's kind indulgence to appear online, my lord, for the private respondents. My lord.
Evident reply, my lord. Because my lord, evident in opposition has been filed by the order of private respondent.
At any point of time, state did not appear in this matter.
Development is my lord. The investigating officer submitted the final report. The petitioner challenged that final report before the landed court below, my lord. Investigation, my lord, directed to be conducted.
But there is nothing remaining in a police inaction writ petition. But the police have taken steps, and it's a purely private dispute. They have taken steps, my lord, and
My lord, the petitioner, my lord,
Even the petitioner to enjoy the absolute lawful return to his. There is a case records. Have you enclosed that what you are submitting?
No, my lord, recently, my lord, it has been developed, my lord, after, my lord, during pendency of the
Where- When?
the-
Recent means when?
I have to take my-
The restaurant is closed, Your Lordship.
Restaurant is closed for 1.5 years.
It was,
It's lying closed.
they did not pay electricity. Electricity was disconnected. Applied for the electricity. Lordship, the court
can
refused to
dispose-
pass such order. They went up to the Supreme Court, Your Lordship. Till Supreme Court, this honorable court's order was confirmed that they should not be given electricity because of the reason, Your Lordship, they are not paying rent. Now their lease is expired, Lordship. They are claiming now the gas bank has been, let them show from the agreement where there was a
I'm not
gas
bothered
bank.
about agreement. Is there a criminal case?
No, I don't.
Huh?
Criminal case means the FRT was filed by the,
Where is the criminal records of the criminal case?
that is not there.
No, on the-
They have a loss. The
Sir,
state
what are
can
you
give.
wanting? I don't know. This is
You
police
want a reconnection of a gas bank which was not there.
don't know. What are your prayers over here?
My lord, my prayer is, my lord, to, my lord, appropriate investigation, because, my lord, I was done.
Where is that? Show me.
That has already been done. So, my lord, there is really nothing remaining in the writ petition. Your lordship will kindly have a look at the prayers once. Kindly comes to, my lord, page 20 of the writ petition.
You have no reference to case number, nothing.
No.
My lord, I have, my lord, annexed, my lord, complaint, that is at page, my lord, 78. Several complaints were, my lord, lodged with the police
So
station.
whatever it is, the case you according to you, this is a 2018 complaint.
That's
Case was registered. Final
Yes.
report was submitted.
My lord.
Yes.
What remains in the writ petition?
Great, my lord.
nothing.
Sir, only what is my prayer in this, my lord, writ petition, so that I can run the business of bar.
That you run the business, that police will
We are
not
not-
allow you.
Yes.
You
No,
go-
my lord, what happened, my lord, I tell you, your lordship, my lord. First of all, my lord, there is a, my lord, my lord, the landlord, my lord, file eviction suit, my lord. That is, my lord, before the commercial court. My lord, there was, my lord, arbitration clause, the matter has been referred to arbitration. Now, my lord, forcefully, my lord, they have, my lord, removed all the air condition outlets. And that is, my lord, another writ petition is also pending before your lordship, my lord. That is also appearing in the list.
What will police do? You tell me.
Sir, they are
So
taking,
police will investigate only.
my lord, they are taking law in their own hands, because, my lord, they
I
are,
think for that investigation was done too.
Yeah.
What is your subject matter over here? You cannot create a.
my lord, the gas bank, my lord, I had a gas
Job.
bank that was forcefully removed by the private respondent. My lord, I lodged complaint.
You have lodged complaint. So the police will take steps in accordance. 2018, we are in 2025.
But the only thing, my lord, kindly direct the should see that, but I can, my lord, run the business properly, my lord.
That is
No,
not.
no, my lord, I am joining issues with that submission of
That-
PDS.
You can say police authorities will see how you can run the business. You tell me.
No, they cannot take law in their own hands, my lord. They cannot, my lord.
That
use
you take
court.
up before the civil court. What
But
they
they are
can do, what are their dues,
Already-
whether you have paid the landlord or not, that is to be subject matter.
My-
You have proper license, you run. If you cannot, then come to the court. Court will see to that. But if you don't have the licenses, and the High Court will say, let him run the
I've got
business.
licenses, all licenses.
No,
there.
that is not a
No,
submission. That is to be considered by the authorities.
I've annexed all the licenses.
চলে আসুন, চলে আসুন।
Only, my lord, my humble submission before lordship, my lord, that, my lord, they are using force.
In 2018,
No, it is force. I have been compelled for, my lord,
So very
running
good.
business, my lord.
you all your licenses are cancelled. Go to the authorities. You have
License have not been cancelled. License
Yeah.
have-
they will not make any payment. There are dues in excess of 2 crores, which is outstanding on account of rent and maintenance charges.
And
Their
Lord,
agreement is terminated. It is in 2019. They are trespassers in the suit property because the rent is more than 10,000 under the transfer property.
filed
They
by
are
the
trespassers in the suit property.
respondent number.
Lordship, private respondent, 5 and 6.
5 and 6.
Respondent number 5 and 6, and evident reply filed on behalf of the petitioners. Be kept with the record. The subject matter of the writ petition and relate to issues of 2018. Learned advocate for the petitioner basically complains that the landlord has forced him to close the business by taking law in his own hands. On the other hand, learned advocate for the private respondent submits that the agreement has expired and the petitioner presently is a ranked trespasser. Is a
And
trespasser.
business is also closed,
Full
Lordship.
stop. That is, I am not
Lodge,
entering.
lodge,
I am not entering into that.
Lordship,
zone.
Lordship.
it has also been submitted that the civil court is already insisting of the issue. Acha. So far as the information which was furnished, it has been submitted. Some steps were taken by the police authorities. Also having regard to the fact that steps were taken by the police authorities and the civil court is already insisting of the issue. I'm of the view at this stage, after a lapse of 6 to 7 years, no interference is called for by the AS court. Petitioner would ventilate his grievance before the appropriate forum, be it the civil court or the criminal court, who are in CCE of the cases in respect of the complaint or the civil case which has been filed. Chalo. With the aforesaid observations, WPA 1835 of 2023 is disposed of. Connected applications, if any, is consequently disposed of.
The affidavits are filed, Lordship will record.
Written that.
My lord, one humble submission possibly I need to point out to your lordship is possibly would not be 6-7 years because the complaint is dated 2022. That correction, my lord, possibly is required because this is the the complaint was dated.
First of the complaint was of 2018.
Yes, first complaint.
I've not referred to any criminal case. I've said that is continuing.
Great. I'm sorry. Great. Deeply obliged.
Eleven, my lord, I beg to appear for the petitioner in this matter. Dear my lord, again, my lord, the sufficiency action initiated by the bank culminated in an order being passed by the District Magistrate South Chobbish Pargana, directing the Commissioner of Police, Kolkata, to render assistance to the bank in taking possession of the secured assets. But thereafter, my lord, there has been no movement.
Which police station?
This is, my lord, Entally and respondent numbers 3 and 4.
Have you no?
Yes, I have made them a party. This is Beniapukur and Entally.
Requisite costs have been deposited or no? That is not been
heard back from the authorities.
Police authorities. Ke appear korbe ki ache? Serve upon her letter submit a report. Then advocate for the petitioner is directed to submit to serve a copy of the petition upon the learned advocate appearing for the state. Tapre as none appears on behalf of the state. What is your good name, madam? Third learned advocate is directed to appear on behalf of the state. Her appearance will be regularized with the concerned authorities. Acha. In view of the fact that the bank is aggrieved regarding the police authority is not having informed in respect of the requisite cost to be deposited pursuant to the direction passed by the district magistrate, South 24 Parganas, naki? Whom? DM South 24 I'm of the view that a fresh report be submitted by the learned advocate on behalf of the state. Please the writ petition under the heading for orders. Shamne সপ্তাহে দিয়ে দিন 2 মিনিটের কাজে আজই কত 13 20 28 for orders on 28th. চলুন next.
I'm the state respondent.
Yes. Or affidavit service. Jane private respondent. What's the problem?
Complaint of 2000 regarding the petitioner was allotted to the Pasha by the government of West Bengal. There are cultivator.
What happened?
He has been disturbed, my lord, and by
Disturbance. Report is there?
Yes, my lord.
Yes, what is
My
that?
lord, as per written complaint, my lord, 107 proceeding has started against the both
Yes.
party, my lord.
Petitioner
and my lord, you'll also kindly see that my lord, complaint. There is no allegation with regard to my lord. There have been my lord.
Whatever it is, petitioner go now again file afresh.
Yes.
Petitioner is aggrieved in respect of the act and action of the private respondent number 9 and 10 as
In my complaint,
the state respondents had been has been in trying to encroach upon the land allotted to the petitioner. To that effect, information was furnished to the police authorities, police on or about 15/1/2023, and the police authority, learned advocate for the state has submitted a report. Report reflects that there has been a long-standing dispute over the land.
They've been allotted by the Patta by the government of West Bengal, being a
That I will not say, sir. To the effect in respect to that in respect of the nature of the dispute, police authority is have drawn up proceedings under section 107 of the CRPC, having regard to the fact that at the relevant end point of time, police authority is taken steps. If fresh inconveniences are faced by the petitioner will submit a written communication to the yeah, officer in charge of Mathura Police Station, who would take steps in accordance with law. With the aforesaid 8 observations, WPA 1983 of 2023 is disposed of. Reports submitted. We kept the copy of the report behind your appearing for the petitioner. Chalo.
Yeah.
Well, I'm for the state respondents.
Yes.
13.
Yes, sir. What is there?
Recorded owner.
Where is the representation to the police authority?
My lord, nothing is annexed in the writ petition.
GDA
Huh?
is there, my lord. GDA
Where is
there.
that? Where is that?
Lord.
Where is the contents of that? What is your problem?
GDA page.
এটা খালি সিভিল কোড করে যেটা রেকর্ড অফ রাইটস দিয়েছে, ম্যাপ দিয়েছে, ছবি দিয়েছে জমির।
My lord, only page 24.
Forcibly, my lord. The private respondents are forcibly holding religious festival on the plot, my lord. Only out of 2 plots, my lord. One plot has.
What is your problem? Tell me, sir. Use the microphone.
My lord, I have. Kindly have a look on page 24, my lord. This is the GDA, my lord.
And what is the contents of that?
My lord, I am the owner of the 2 plot, my lord. People of the major committee, my lord, forcibly holding the religious festival on my land, my lord.
Forcibly
holding the religious festival.
That was at the relevant part of that year.
Each year.
So petitioner, the civil suit is for what?
Civil suit for
At your instance.
Yes.
He
wants to cultivate the land. There is an order of injunction till 25th of January 2023. It appears from record. But after that, my lord,
after that, there is a change of circumstance. Petitioner approached the court.
Every year, the petitioner has been facing the same problem.
Every year you have got to come, sir. Or go civil court, you inform, file an execution case to the petitioner. As the information which was furnished on about 28/11/2022 with Jangirpada police station was not acted upon. The grievance of the petitioner further is that in spite of the London Civil Judge Junior Division, Sirampur passed an order in TS 655 of 2022 for not creating any disturbance in the peaceful possession of the property and for not changing the nature and character of the property. The private respondents had been organizing their programs over the land of the petitioner, and as such the petitioner was unable to cultivate his own land. Full stop. Learned advocate appearing for the state submits that the basic grievance of the petitioner related to the year 2023. Full stop. Learned advocate for the learned advocate for the state. Submits korbe, to this learned advocate for the petitioner replied that the same disturbance is still being continued at the behest of the private respondents, having regard to the fact that the information so furnished was of November 2022 and more than 2.5 years have passed. Petitioner would file a fresh representation with the police authorities. Police authorities would consider the representation of the petitioner in accordance with law. With the aforesaid observations, WPA 2158 of 2023 is disposed of. Server copy. लैंडे झमेला पुलिस नहीं है Yes.
Property, and I was trying to build a construction over there, and the private respondents have drafted a copy of the same for the 1.2 million that order.
Where is your representation? Only GD entries. Only GD entries.
Only GDA.
Yes, who is there for the state? Ask somebody. Give him a copy. Huh? Petitioner is aggrieved by the fact that the representation earns dated 7/1/2020 representations dated 7/1/2023 and 11/1/2023 addressed to the officer in charge, Dadpur Police Station, Hooghly, were not addressed properly. And as such, the petitioner had to face the inconvenience as no construction could be raised in his own land. Full stop. Be that as as none appears on behalf of the state, Mr.
Gaurav Das.
The Gaurav Das, learned advocate who ordinarily appears on behalf of the state, is directed to represent the state. His appearance may be regularized by the concerned authorities. Having considered the nature of the dispute, so far as the issues relating to construction are concerned, if the petitioner faces inconvenience, he would be at liberty to approach the civil court. If any direction is passed by the civil court upon the police authorities at that stage who would respect, obey, and implement the order. In the meantime, if the petitioner is faced with fresh inconveniences so far as breach of the peace and tranquility is concerned, fresh representation be filed by the petitioner, which the police authorities would consider in accordance with law. With the aforesaid observations, WPA 2221 of 2023 is disposed of. Server copies.
Grateful to them.
15.
Yes, anybody is there, Mr. Ghosh? এটা দিয়ে দেবে, পরে কপি দিয়ে দেবে।
15.
আচ্ছা, petitioner is petitioner approached the EA's court as the police authority did not take any steps pursuant to the investigation having been registered. Pursuant to the FIR having been registered on or about 17/11 and 2022, 17/11/2022, ঠিক আছে? Records reflect that the petitioner filed an application under section 156(3) of the CRPC before the learned ACJM Bongaon, and consequent to which Gaigata PS case number 1080/2022 was registered for investigation. Having regard to the time period which has passed in the meantime, আড়াই বছর হবে তো না? Which is more than 2.5 years, I am of the view that if similar inconveniences are faced regarding the progress of the investigation, petitioner would be at liberty to submit a fresh representation before the superior officer of the police, particularly the SDPO/oblique DSP or the oblique additional SP in charge of Bongaon, Gaigata, in charge of Gaigata police station, full stop. With the aforesaid observation, WA 2464 of 2000 disposed of. Second paragraph একটু দিয়ে দেবে. As none appears on behalf of the state, Mr.
Amurtha Pal.
Amurtha Pal, learned advocate who ordinarily appears on behalf of the state, is directed to represent the state. His appearance may be regularized by the concerned authorities. Okay.
Grateful Lordship.
কি হলো গো? এরপরে এই দেশের অবস্থা দেখছো না? হ্যাঁ, আর মরা মামলাগুলো ঘাম ঝরিয়ে করতে হচ্ছে তোমায়। হ্যাঁ,
আপনি কোন গ্রুপে আছেন? ঠিক ভাবে দাঁড়ান।
yes. বলো কি বলবে বলে দাও। 16 আচ্ছা, petitioner approached the court as a representation dated 20th July 2023. Address to the officer in charge, Bhagwanpur, 20th July, 20th January. To the address to the officer in charge, Bhagwanpur Police Station, was not did not yield any result. From the representations so made on 20th January 2023, I find that there was a dispute relating to construction of steps at the house. Full stop. Having regard to the nature of the dispute, now I am of the view that the same is a civil dispute. Full stop. As none appears on behalf of the state, Mr. Kartik Chandra Kapas, an advocate who ordinarily appears on behalf of the state, is directed to represent the state. His appearance may be irregularized by the concerned authorities. So, taking into consideration on the subject matter which has been referred to is a dispute arising out of certain constructions between the petitioner and the private aid respondents. I am of the view that if there is any any violation of law and order, police authority would interfere and try to prevent any breach of the peace and or tranquility. Full stop. So far as the other issues are concerned, the civil court would be the appropriate forum for dealing with the same. With the aforesaid observations, WPA 2582 of 2023 is disposed of. Server copies. Next.
Date for my lord. I am for the petitioner, my lord.
Yes.
Sekhar Pal is my senior. He is appearing also.
Huh?
Of his relative, he could not come. I am praying for not to.
For how many years this will be pending, sir?
I will not.
Nobody appeared on. This was called on earlier Thursday. It was called. These matters were called on Thursday. Nobody took time on his behalf. Otherwise, I could have fixed. What is there in this matter? Land matters. You are coming for police in action. Against the opinion. I'm disposing of the matter, sir. These are representation of about 2022, October 2022. I'm just giving that if you have same problem, you file a fresh representation, police will take steps in accordance with law. Egress and ingress problem, basically. If you have the say 2025, information was of 2022, October 2022. So if the same situation persists, you file a fresh representation, police will take the steps in accordance with law. I find the subject matter of the re petition refers
Copyta.
to
Copyta. Petition copyta.
free to obstruction in respect of free egress and ingress of the petitioner at his property. To that effect, information was furnished to Kolaghat police station. The same was in the year of October 2022. Full stop. As none appears on behalf of the state, Mrs. Zupsha Chakraborty, learned advocate who ordinarily appears on behalf of the state, is directed to represent the state. Her appearance will be regularized by the concerned authorities. Having regard to the nature of the issue concerned, particularly with regard to the free egress and ingress being blocked by stacking bricks, I am of the view that if the situation still persists, petitioner will file a fresh representation with the officer in charge, inspector in charge, Kolaghat police station, who would consider the same in accordance with law. Full stop. With the aforesaid aid observation, WPA 2782 of 2023 is disposed of. Server copies.
Grateful lodge.
The state respondents kindly have a look at the report, my lord.
It's a trust property, my lord, and attached to the, my lord, second page of the second paragraph of my report, my lord.
রিপ্রেজেন্টেশনও দেয়নি 144টা করে চলে এসছে
But second page,
এনি
third paragraph.
রিপ্রেজেন্টেশন মেড
Actually,
নাথিং
but third paragraph of my report, your lordship kindly looks at.
petitioner approach the court.
Third paragraph, my lord. And is, my lord, complaint to the police station, my lord, on the next page, my lord.
Who has complained this petitioner?
My lord,
Indu Singh.
yes, Biplab, Indu Singh.
This is February 2020.
Indu Singh, my lord, made the complaint, but my lord, Biplab Roy, my lord, member of the judicial service, he, my lord, made a complaint before the police station. The next page, my lord, your lordship kindly sees his.
No, I'm not. Indu Singh is the petitioner.
Indu Singh is the petitioner.
This is a government servant who has sealed the shop.
Yes,
I'm not bothered about the government servant.
lordship.
The petitioner, what was that difficulty? 140 को ছাড়া তো কিছু করেইনি।
No. Kindly see the next page, my lord. This is the written complaint of the government on behalf of the government. Next page.
And you just want to address this and just close the chapter. Acha, petitioner, the petitioner was aggrieved regarding apprehension relating to her forceful eviction at 41 by F1 by 1 Block C, first floor, New Alipur, PS, New Alipur, Kolkata. Full stop.
No, kindly looks at the attached complaint.
Coming. Petitioner further apprehended that she was under threat and physical force may be applied to evict her. Full stop. State has submitted a report. Report reflects that the Administrator General and Official Trustee West Bengal had taken over had sealed the property subject matter of the has sealed the subject matter of the property, which is situated at 41 by F by 1 Block C Police Station, New Alipur. And the same was done after informing the police station. Having regard to the steps that having regard to the fact that the steps have been taken by a government servant in accordance with law, I am of the view that the police authority had no option for exercising their powers. Full stop. Accordingly, WPA 2796 of 2023 is dismissed. Reports are submitted. Be kept with the record. Server copies next.
Grateful.
You are there.
19, I am for the petitioner.
Yes.
I am for the state respondent. The petitioner lying with me.
পাওয়া যায় এতদিন পর।
My lord, the case is that the custody of the child. My lord, the police has inquired into the matter and found that he is in custody of his father and well maintained. Apart from that, there is a unnatural death of his mother. Unnatural case was started and final report was filed with an observation that she died due to kidney disease, not from. This is the report.
Who are these petitioners? Ranjit Karan, these are grandmother and
My lord, regarding the final report, my lord, I have the copy, but it is not annexed.
So the prayers over here in the writ petition are for custody.
Custody of the- My lord can get it, my lord, from
Leading to this instance for effective adjudication. Application to issue a writ of
second page, third paragraph.
Petitioner has approached the court as the information furnished on or about 30th December 2022 to the officer in charge Chondipur Police Station did not yield any result. Petitioner's grievance is that the custody of the minor child was taken away by his father and the death of the petitioner's daughter. State has submitted a report.
Second page, third paragraph. Accordingly.
Curriculum
Correct.
report which reflects that the petitioner's grandson was in the custody of the father who is being taken care of. So far as the other subject matter is concerned, relating to the death of the petitioner daughter,
That has not been reflected in
Dr.
that.
Tickle.
The final report was filed 19/7/2024.
Curriculum that it is reflected in from the postmortem report that death was due to effects of diseased condition of kidney as as noted above, antemortem in nature. Inverted এখানটাই পুলিশ রিপোর্ট এখানটা পেন্সিল দিয়ে আন্ডারলাইন করে দিয়েছে having regard to the fact that the incident complaint is of the year 2022, and so far as the custody is concerned, the child is under a lawful custody. If the petitioner intends to invoke any jurisdiction, petitioner would be at liberty to invoke the jurisdiction of the civil court under the relevant provisions of law. So far as the issue is relating to death of the child death of the daughter is concerned, the UD case number 68/22 dated 13/11/2022 was already registered, and the report of the medical expert is there. Full stop. Considering the fact that considering the same, I am of the view that no interference is called for, as the police authorities had acted adhering to the provisions of law. So, with the aforesaid observations, WPA 2797 of 2023 is disposed of. A report submitted be kept with the record. A copy of the report be handed over to London Advocate Appeal for the
Grateful.
Anybody with the state? Yes, what is your grievance, sir?
Petitioner is a owner of
Our landed.
the properties, my lord. Which
So what is your property is there? Your property you enjoy.
My
Where is the difficulty of?
my lord, if my lord sees page number 96, my lord,
96.
the stay has been passed by the
So
appellate
where
court.
is the representation to the police authorities?
My lord, page 97, my lord.
97.
My lord, they are violating this order, my lord, which was passed by the appellate court, my lord, and also passed by this executive magistrate. They are destroying my cultivation, my agriculture.
Petitioner is agreeing by the fact that the representation which was addressed to the officer in charge Pandu police station did not yield any result. The grievance, the further grievance of the petitioner is that the private respondents are trying to. কতজন আছে?
My lord, three, my lord, 5%.
The private respondents are trying to encroach upon the petitioner's property and also destroying the cultivation. It has also been submitted that the civil court in title appeal number 17/2018 was pleased. Where is your direction?
My lord, 88, my lord.
88 is what?
My lord, 88 is the order passed by the appellate court.
Execution has not been allowed.
My lord, there's an order of stay, my lord.
Stay for
the preliminary degree was in their favor.
for
You know, the
execution.
stay of order.
কি বললাম? 18 has been pleased to stay the execution of the preliminary decree since the since the appellate forum of the civil court is already in session of the issue. And the petitioner further apprehends that there may be continuation of the illegalities earlier committed. Petitioner would be at liberty A to bring the same to the notice of the officer in charge.
My lord,
Pandua, officer in charge, Pandua police station. Full stop. Officer in charge, Pandua police station, if he finds that the same dispute, same inconveniences are faced by the petitioner, would act in accordance with law. With the aforesaid observations, WP 3026 of 2023 is disposed of server copies. Give your name.
Amit Kumar Ghosh.
State give your right.
Amit Kumar. I am giving. The direction upon the petitioner to serve the copy of the petition.
Don't have. Please give me. So the yes,
21.
Yes, please.
My lord, I am beg to appear of the on behalf of the respondent, my lord, private respondent.
My lord, petitioner is the senior citizen person, my lord.
Huh?
Petitioner is the senior citizen, my lord.
Ah.
Petitioner enjoy the possession freely, my lord. And the private respondent forcefully trying to occupy the petitioner plot of land, my lord.
My lord, this is purely civil dispute. The dispute is regarding the physical charge distribution of the fishes in the pond. My lord, due to excessive heat and
My lord, 23th matter, my lord.
Petitioner approached the court as the information furnished to the officer in charge, Purchura police station, did not yield in result. Records reflect that such information was furnished on 9th of January 2023. Also, Mr. Ami Aid, Lane Aid advocate appears on behalf of the state. Lane advocate Aid for the private respondent numbers.
my lord, all private respondent.
Private respondents are represented having regard to the fact that the dispute is in respect of the division after a rearing of the fish at the pond. Division of rearing of the fish at the pond. I am of the view that the nature of the dispute is a civil dispute. So far as the threats which were given to the petitioner, if the same continues, police authority would assess whether there is any breach of peace and tranquility, and on a fresh complaint, if so filed, would act in accordance with law.
My lord, one more thing, my lord, they are accepting the money. The petitioner also refused the.
With the aforesaid WPA 3566 of 2000.
My lord, only one line may be added, my lord. The police will not look into the shares and rights of the parties.
Police authorities will not obviously address on the issues regarding the rights of the party, right, title, and interest of the parties, as also regard in relation. Right, title, interest, and shares. Right, title, interest, and shares of the property. Police authorities would only assess regarding the issues relating to breach of peace যেটা বলা আছে এটা একটু কনসেপ্ট করে দেবে ঠিক আছে
Great.
3566 of 2000 disposed of চলো
I am for the respondent number 6 and 7, private respondent.
I am appearing with the petition. Then application claiming for a police posting. Protect my right, which was declared in the civil court.
In case of 23, my lord,
Kindly allow.
civil matter is pending with the Honorable High Court, my lord.
I will kindly study. I find a this case. That is a failed presumption case and got a TB. That is page 21. Thereafter, they preferred an appeal. They have lost it. Thereafter, I filed an execution case in my position. Deliver. They filed a one petition application that is pending and interim order was refused. That means as per belief positions, I am in position. Thereafter,
you come to page 42, sir.
Yes, my lord, this is my representation, page 41.
23/12/2022.
Yes, my lord.
You file a
Page 41, I am praying for according to demarcations by the belief, I want to fancy enough by a posting a cement pillar and others. Thereafter, my lord, the police are not, for this reason I am praying for police posting at my own cost.
because civil court has declared my right.
So ask the
But
civil court to
composition-
give that. Why should I give that?
Well,
23rd December 2020, my lord.
Yes, yes, that position that
বাউন্ডারি ওয়াল তো সারা জীবনই করা যায় বাউন্ডারি ওয়াল কি থেমে থাকে
well, kindly see page 21.
What are your prayers, sir?
Yes, prayer for posting for a police. brigade,
Where?
my lord. That is
Where?
my prayer.
Where? Which one?
Yes, that is D.
ইস্যু এন ইনজাংশন এগুলো কি করে করবো আরে কোর্ট তো এখন এলেন 12টার সময়
পুলিশের যাচ্ছে
Learned advocate appearing aim for the petitioner. হ্যাঁ কাজ শেষ তো আপনার আমি বসে Learned advocate appearing aim for the petitioner is aggrieved by the fact that the representation which was addressed to the officer in charge Nandakumar R police station on or about 23/12/2022 was did not yield any result. Learned advocate for the private respondent and submits that the petitioner and the private respondents have contested a long-drawn civil proceedings. Learned advocate for
application is pending before the honorable court.
Pending interim order was not passed in the honorable high court. They have
what is pending?
Civil division application is pending before the honorable court. my lord.
Learned advocate for the respondent further submits that the revisional application is pending
CO 838 of 2020.
is pending before this honorable court. Full stop. Civil revisional application is pending before this honorable court. Learned advocate for the state submits that the nature of the dispute complaint of is absolutely a civil dispute. Police authority will not be able to
Hello, believe was
act.
deliver position in my favor. I have annexed those documents. My lord, straight away come to page 35. In
The
terms of the civil court's order, delivered positions in my favor, page 35. For a moment.
How will I assess the property is concerned?
No. Question of no assessment of the property. What positions I have delivered? That should be protected.
Police
Because
authority.
High Court has refused the interim order
Police.
in their favor. Only I am helping my lord police. Otherwise, I will not be able. My life will be danger.
No, my lord. That's a completely false statement, my lord.
Yes, yes.
Wait, please, sir. Can't hear him. Until and unless there are appropriate directions from a court of law, be that as it may, since the representation which was made is of 23/11/2022, 11 or 12,
That is 12,
23/12/2022. I am of the view that if inconveniences are faced by the petitioner, fresh representation be submitted before the police authorities. Police authority would act in accordance with its lordship.
Taking into consideration by the civil court's order.
That civil court
A citizen,
W-
it will be, entire order will be civil court will be frustrated.
WPA 3603 of 2023 is disposed
Well,
of.
only, my lord, kindly, only be, my lord,
Grateful,
only, kindly, it will be acting on in terms of the civil court's order, my lord.
So why keep the civil procedure, sir? We will from the first day say
The
a
civil
week.
procedure, I am taking the all recourse. By and through an execution case, I have delivered positions.
23, I appear for this case, my lord. And the fresh wakalatnama has yet not been filed. And also we have to file a reply to the counter affidavit.
What happened to this case? A criminal case?
My lord, this is a case, my lord, where incident has happened at Bihar, my lord. There is a doctor and wife's problem, my lord. There's a matrimonial dispute, my lord. The gentleman is a doctor, and my lord, the matrimonial dispute, my lord, relating to the matrimonial dispute, my lord. One case has been lodged at the matrimonial house area by the wife of the wife of the my lord read petitioner, and another case has been filed since the father's house is at Calcutta at Waterganj police station. Another case, according to the
What happened to this Watganj police station?
the police started a case and investigation has been started.
And it is 22 now.
Now there is a stay, my lord. Your lordship kindly peruse the last 3 orders, my
Since
lord.
to investigation into one crime or not permitted as an agent, the court is inclined to stay both.
My lord, may kindly see 30.
Both the FIR stayed.
Yes, my lord.
You are petitioner.
Yes, my lord.
Their contention that they refer TT Antony and they say they, from the self-same cause of action, self-same complaint, 2 cases cannot be registered. This is their contention.
That is all right. Then one case must go on at least.
Yes, well, 2 cases. Well, first case, there at Patna, first case was started. First FIR was registered, and the next month the second FIR was registered in the Watganj police station. That we are doing, my lord.
Inform the de facto complainant. Where is the respondent made a party?
Yes, my lord.
Inform them. I'm keeping this matter. Bring the case diary, whatever you have done, and whatever information regarding Shastinagar.
Yeah,
May I only request, my
You
lord?
have filed
Something
the affidavit.
progress, my lord, since the stay has been granted, my lord.
Have you filed the affidavit in opposition?
No, I have not filed a.
There was
They are supposed to file affidavit in
respondent.
opposition.
You are
Private
respondent.
I
respondents,
am
my
the
lord.
petitioner, my lord.
The petitioner.
The private respondents should have filed. But it is the litigation between they have challenged
They
the
were
things.
directed to file, my lord. They have not.
And directed to file.
Our part is very limited. We received complaint, we have registered a
Inform the
FIR
respondent.
and our
Inform
investigation
the
started.
respondent number file. I'll take up. Because there's no use of keeping 2 matters pending, but one investigation.
My lord, may I only request, my lord? There's an outstation counsel from Patna who conducts the matter. He has gone on Hajj. Only the last week of June or first week July, my lord. Any time, my lord, may.
That's too long a time.
Only because of the personal difficulty of the counsel, my lord. And also the lawyer has changed in the matter. We have not filed.
Investigation stay. You have some urgency.
We have only filed it for quashing of the subsequent FIR at Watganj police station, my lord.
So I'll open up the other case, sir. Something is to be done. On second FIR, both cases cannot be stalled, sir.
Accommodate us for some time after vacation. We will also file our
Not accommodation with
They may
investigation.
file a affidavit. We'll file a rejoinder only
That's a
1
different
week.
issue. Inform next week. I'm keeping for let them come what they want to say, whether they intend to pursue the case.
Their presence is necessary.
My lord, we then have it after vacation only. Request, my lord. After vacation, my lord. It's my humble.
Let them come first.
The council.
They are not before the court.
There's a wakalatnama already in the case's status, my lord.
You are holding not brief for both the sides.
No, my lord.
The other side is not over here. When I will fix the date for the other side, that cannot be at the dictate of the petitioner.
My deepest apologies, my lord.
State is directed to inform the respondent number 5 to the Watganj police station. Let a report be submitted to that extent on 20th May 2025, when the writ petition will appear under the heading to be mentioned. Let that be first.
Much obliged.
Thereafter, I'll fix a date.
Well,
Kuri, 28 ছুটি to be mentioned.
My prayer would be, my lord, on the next date, my lord will fix the date for final hearing.
24 minutes after the state responded.
My lord, the matter of, my lord, forgery, my lord, and cheating.
What happened? What you further investigation?
Further investigation has been done. Charge sheet submitted again, my lord.
My lord, may I submit?
Again, they have.
May I submit? My lord, the matter of 2020, my lord. Initially, my lord, we preferred a revisional application. Your lordship was seizing of the matter, lordship. Your lordship passed an order, my lord, directing that the learned magistrate would consider the application as well as the further investigation at that point of time, which was going on before the Behala police station, and will direct, if necessary, for specialized investigating agency. Subsequently, specialized investigating agency started up with the investigation. At that point of time, my lord, they were continuously delaying the matter.
Yes.
A writ petition was filed. They filed a
High
court, my lord.
has been submitted.
Secondly, my lord, thereafter,
what is your grievance now?
At present, my lord, a further investigation has also been directed, my lord, again for the second time upon the detective department.
That has been done, my
That
lord.
has been done.
That has not yet been concluded.
10/5/2000 trial এ পাঠিয়ে দিতে বলেছে জানি না।
My lord, that is, my lord, because, my lord, the matter has been mentioned before your lordship.
যা হবে হবে ওসব
And then notice has been served, my lord.
লালবাজার আমার কথা শুনবে চলে এসো হ্যাঁ। Petitioner is aggrieved by the petitioner approached this court being aggrieved in connection with the investigation of Behala police station case number 297 dated 6/10/2020. 5 বছর ধরে only investigation করলো।
My lord, this is the situation of Kolkata police, my lord.
First, you could not find any case. Then also could not find any case.
No, third,
The
same thing,
detective
my lord,
agency,
these
my lord, is
instances-
required to investigate twice to
Acha,
conclude an investigation,
uh,
satisfy the London magistrate.
6/10/2020. 297, 6/10/2020. State has submitted a report. Report or reflects that although initially EE Police Authority did not find any offense, however, in course of further investigation, when the case was transmitted to the anti-cheating section, right? Detective Department and Lal Bazar, a prima facie case has been found to have been made out under the relevant provisions of the Indian Penal Code and the Information Technology Act 2000 against the accused persons.
During further investigation, my lord,
আর
second
দরকার
accused
নেই,
person-
হয়ে গেছে, আর হবে না, 5 বছর ইনভেস্টিগেশন go up for trial. আচ্ছা, the prayer which has been advanced, full stop, the prayer which has been advanced before the jurisdictional court is for sending the accused persons for trial.
Not only once.
Just 1 minute.
চলছে না।
Mr. Boshu Malik, what is this type of drafting? In the report, what is this type of drafting? You see, in the first part of the paragraph, you intend to submit the prima facie charge under section 120B.
Lordship.
Last page, last
page.
paragraph.
Yes, my lord.
Further investigation of the case under the provision of section 173(8) is complete.
My lord.
All right. From the available facts and so, collected during a prima facie charge under so and so sections have been established.
Lordship.
Very good. Against Sinjoy Chatterjee, Otoshi Bhomik. All right.
My lord.
Now you come to the next.
Yes.
Accordingly, report in final form is to be submitted.
Who is not arrested, accordingly, report in the final form is to be submitted against both the accused persons under section so and so. Trial may be come up. Because this person, one person has been arrested. That's that
No,
part, but
that I am not bothered. But then, if we have filed a charge sheet already, and you want the trial to proceed, then when will the subsequent issue of filing a charge sheet come? Final form means report in final form means what? Report in final form?
My lord, is to be submitted, my lord. That has been stated by them.
no, my lord, this is, my lord, after twice, my lord, if lordship comes to the other 2 pages,
No,
my
no,
lord,
other 2 pages নাই, আমি এটুকু বুঝি, ক্যালকাটা পুলিশের এটা আমি ভালো করে বুঝি, রিপোর্ট ইন ফাইনাল ফর্ম এ ডিসচার্জ করে দেবে পরে। Accordingly, report in final form is to be submitted against both the aforesaid accused person means কোথায় কাট পেস্ট করেছে না এটাই
sure, not arrested,
as
thereafter.
the officer to be present, to be mentioned tomorrow, 2 মিনিটের কাজ করে দেবো কালকে।
Well, I'm grateful, man.
এই অর্ডারটা একটু বাঁচিয়ে রেখে দেবেন, একটুখানি বাকি আছে, tomorrow to be mentioned. Nothing is there, sir. Either you say you file a final report,
Yes.
or you say charge sheet, this part of the sentence inadvertently it's a copy paste.
মনে হচ্ছে
The thrice, my lord, London magistrate took up the pen, my lord, to clear out and to
With the
dispose of
case, ask him to come
Karachi
tomorrow.
application.
To be mentioned.
And my lord, they are playing, my lord, with the investigation.
থাক, যেরকম আছে এটা রেডি করে রেখে দেবেন, কালকে টু বি মেনশনে ফাইনাল অর্ডার পাস করুন। এটাকে এই অবস্থায় রেখে দাও, কালকে টু বি মেনশনে এমনি দিয়ে দেবে, টু বি মেনশনে কালকে রিপোর্টটা না হারায় না, রিপোর্টটা থাকবে। লালবাজারে খুব লালবাজারের রিপোর্ট তৈরি হয় এইভাবে। চলো,
I'm great.
আমি লিখিনি।
I am appearing for the private respondent. 25. আপনি আছেন?
ওটা একটু বাঁচিয়ে রেখে দেবেন, বুঝলেন তো, কালকে সকালের জন্য। Petitioner approach the court being aggrieved
না
in respect of the inaction of the police authorities The main grievance of the petitioner
রিপোর্টটা ফাইল করে দিন
was in respect of a property. To that effect, petitioner informed Degonga police station, but no steps were taken, and a general diary entry was recorded on 12/10/2022 as well as on 18/11/2022. Petitioner apprehended that his life and property would be at jeopardy at the behest of the private respondents. Also, learned advocate appearing for the private respondent 5 and 6 draws the attention of the court and submits that the civil court is already insisting of the issue, and to the effect, attention has been drawn to the records of the petition so far as TS 921 of 2015 is pending.
This
The
is a
appointment
totally
is
civil
required.
dispute, my lord. Matter is pending before the LRTT.
Report আছে?
হ্যাঁ, my
দেখি। Learned advocate for the state submits a report reflects that the nature of the dispute with petitioner and the private respondents were adjudicated by the civil court. However, apprehending in breach of the peace, the police authorities drew up proceedings under section 107 of CRPC. Having in regard to the steps taken by the police authorities, I am of the opinion that they have acted by adhering to the provisions of law. As such, no interference is called for. However, if there are fresh disturbances, police will further act in terms of the relevant provisions of law. With the aforesaid observations, WPA 4595/2023 is disposed of. Reports are submitted.
I appear for the petition.
Wait to appear on behalf of private respondent, my lord.
May I file my affidavit, serviceman? In this matter, lordship, the petitioner purchased.
Yes.
The petitioner purchased a piece of land. After purchasing it, he obtained sanction plan, recorded his name in the LR record of rights. When he started to construct, as in terms of the sanction plan, the private respondents, they created trouble. Their contention was on the basis of a.
Yes, what is your problem?
My lord, kindly see page number 26, my lord.
Yes.
26, my lord. Plot information, my lord. On kindly see page dag number.
Dag number problem.
7483 Sali. Total land of 1 acre. 42 decimal, my lord. Kindly see, my lord.
What is the dispute?
My lord, kindly, my lord, one thing, my lord. Dispute regarding my lord. Kindly see the pair for representation, my lord. Kindly see his pair the representation of.
What is your claim now?
My lord,
I want to construct in terms of the
my
sanction
lord,
plan. My record of right is there. The private
petition
create trouble, lordship. The
petitioner
take steps against them. I have
petitioner
total land number.
Petitioner and the private
decimal, my lord. As per plot information.
Claim to be owners of a piece and parcel of land. Full stop.
Different. Their land is different. The boundary declaration is
petitioner, on the other hand, claims that he intends to construct a boundary wall as the land belongs to him. To that effect,
sanction plan.
In terms of the sanction plan, to that effect, learned advocate for the petitioner refers to the information unfurnished to the inspector in charge, Jonago police station, along with other administrative authorities dated 5/1/2023, having considered that the police authority would only act pursuant to directions passed by a court of law or the appropriate authority is under the West Bengal Land Reforms Act 1950. I am of the view that the police authorities in this case would only restrict themselves to the extent that there should not be any violation of any law and order. Full stop. Accordingly, if representations are filed at the behest of the petitioner or the private respondents, police authorities would ensure that there is no breach of the peace and or tranquility and or any untoward incident results. Full stop. So far as the dispute relating to property is concerned, the right title, interest, usage, occupation would be only considered by the civil court or the land authorities, and if directions past police authority is would respect, obey, and implement such order. With the aforesaid observations, WPA 4865 of 2023 disposes of survey
The
commission.
petitioner is otherwise entitled to construct.
Kindly see the prayer for representation.
কিছু নয় এখানে তো। তাতে দাও, তাতে দাও।
My lord, I'm for the petitioner.
Yes.
My lord, the petitioner was a minor girl when she was 13 years old in 2021.
Yes.
My lord, then after that, in 2025, she is 17 years old. But the father of the petitioner, grandfather of the petitioner forcefully married the petitioner minor girl in 2021.
Who is the petitioner over here?
The petitioner is.
Yes, yes, yes.
My lord, the police office state, my lord.
Yes. Who is this Shapon Kumar De?
My lord, he is the uncle of the petitioner.
So what is his interest, parents?
His prayers are that the Sonamukhi police station, Bankura, has not taken any steps regarding the petitioners. The petitioner is still in the at his in-laws, at her in-laws house, and the custody of the father and the grandfather.
So father is a lawful guardian. How do uncle come in over here?
My lord, she was forcefully married during 2021 when she was only 13
Where are the
years old.
documents? She is minor. You are taking up or asking the police to
Yes.
set the law into motion. You must have documents in your favor to show she is a minor. Father automatically is a legal guardian. Nobody can.
My lord, and grandfather was also forcefully married her when she was only 13 years old.
Grandfather is a separate. Father is also involved. Father is a legal guardian.
My lord,
How do I have no issues. How do an uncle have a much more interest regarding a girl child rather than the father? What is the reason?
yes, the father. Yes, my lord, the father is alive till date.
Then you have got to have documents to show she is a minor. বুঝলাম না, এই সম্পত্তি নিয়ে ঝামেলা, যে যা ইচ্ছা মামলা করে দেয়।
My lord, the father and the grandfather are not still arrested till date. The police has not taken
Where
any
is the case
actions.
number? Arrest. There must be a case registered. Where is the case number? Where is the case number in your petition, madam? Just show me. Learned advocate appearing for the petitioner is aggrieved by the inaction of the police authorities, particularly with regard to the information furnished by the officer in charge of Sonamukhi police to the officer in charge Sonamukhi police station.
My lord, and to the district magistrate also, they have written a representation,
Name is not
and
authority.
also to the Human Rights Commission.
Is a what a legal aid matter?
No, no.
Huh? এগুলো কি করে করে? একটা ওয়াকালাতনামা নিয়ে ফাইল করে দিচ্ছে মামলা, দেখো।
Wakalatnama.
Huh?
My lord, I'll file the Wakalatnama in the course of the
How
day.
can a petitioner file wakalatnama now? How without a how this writ petition was filed without a wakalatnama? Questionable সব। বাবা থাকতে কাকা এসে মামলা করে দিচ্ছে। ফাইল হলো কিভাবে বুঝতে পারছি না। তাই is this a legal aid matter?
No, my lord.
একটা সব only 2023-এর মামলা, যে জেরা মতো ফাইল করিয়ে নিয়েছে। বললে খারাপ হয়ে যাবো আমি। চলো, কি বললাম? in course of the day. কি বললাম? No, which did not yield any result. Full stop. Petitioner claims to be the uncle, and the grievance which has been addressed is against the father and grandfather of the minor child concerned. Alleged minor child concerned. Full stop. There are no documents to support the contention of the petitioner, which has been enclosed along with the writ petition, and it has been claimed that the victim happens to be a minor girl who has been forcefully married. Be that as it may, there is no reference to a case which has been registered. Having considered the period of time which has lapsed in the meantime, liberty is granted to the petitioner to file a reminder in respect of the communication which was sent to the concerned police station. The concerned police authority would send appropriate reply or response to the petitioner, as also the father and grandfather of the minor child referred to in the writ petition. You are already there or no? We were as none appears on behalf of the state. It is second paragraph. Good name, madam.
Neelam Singh.
As none appears on her appearance may be regularized with the concerned authorities. Writ petition disposed of. WPA.
28. I am appearing on behalf of the
Yes, what are you wanting? কি দাঁড়া স্টেটে হয়ে কি রাজ্য সরকার থাকবে না? কি হলো? Where is the representation? Page 34.
Case is police inaction, non-action. I'll kindly see the prayer.
Because the petition is a poor permanent in the Baba was given to the petitioner to go to the office because the notice was served by the OC. Where is your representation? What is your grievance?
Well, nothing is there. Nothing.
Abruptly, the opposite party respondents to my plot of land and demolished all my
Construction. Where is that? Where have you informed that?
I informed my not next date I have
Where over here? Read petition. Page number. Where is the police being informed? Page number you show from here.
My lord, earlier occasion, my lord, Honorable Justice Shompa Sarkar, my lord, directed to the police.
Let him complete the yes.
Lordship was happy to direct the police personnel to see the matter.
To see, so thereafter?
Thereafter, my lord,
Well, it is this.
the police is 34, 38.
38.
Then they took the police all for me and the other side.
That is dispose of.
The matter take to
That is for then. What are you wanting now?
then my lord, the police they want to put my but all the that has not been considered and has not been by the police.
What? Deployment of police in disputed place under supervision.
Now, my lord, the respondents
After the SP passed to continue of deployment of police in the disputed place. After that,
My lord, kindly see the prayer. My lord, kindly see the prayer.
Petitioner earlier approached the court wherein a coordinate bench in WPA 10542 of 2022 by its order dated 26/7/2022 directed that the issues raised in the representation would be considered heard and necessary order be passed by the Superintendent of Police with regard to the prayer for protection. Consequently, the Superintendent of Police Paschim Mednipur would pass the following order. এখানে 1 থেকে 5টা সেন্টেন্স আছে দেখে নেবেন ফুল স্টপ having regard to the order as passed on 24/9/2022 the officer in charge which police station what is your OC officer in charge Pashkura police station would assess whether the order dated 24/9/2022 is still in existence and in case the same has been withdrawn he would ensure that OC Dashpur in case the same has been withdrawn he would ensure that there is no breach of the peace and or tranquility and or any untoward incident in taking place in view of the earlier directions passed by a coordinate bench of this court in 10542 of 2020. Sure. With the aforesaid observations, WPA 5366 of 2023 is disposed of. Have a copy. Sure.
Kindly direct the petitioner to supply me a copy.
ওনার নামটা দিয়ে দেবেন আর একটা give a copy to her. ঠিক আছে ঘুরে আসি আপগ্রেড So I appearing for the state respondent. Yes.
My lord, I am for the private respondent. Number 3. Complaint
The
is
complaint is
baseless,
at
at
page
45
under the
denied all allegation, and I have
Yes,
rejected all
petitioner.
the things.
At
which
page
petitioner
45,
said.
my lord, there are
Yes.
two complaints at page 45 and 25, my lord. Cruelty after marriage, my lord, and the fact that
Yes, Mr. Yusuf. Lordship, in the month of December 2023, she has filed a complaint, Lordship. Again, January 2024, she submitted a letter that she did not want to proceed the matter against her husband, Lordship. It also further comes to our knowledge, Lordship, that 10 years back, she had already filed 2 cases in 2 different police stations.
My lord,
It
the
has been
petitioner- my lord, the petitioner is a school teacher, and he not only desperate, but a dangerous lady. And earlier,
So
she was
charge sheet has
married.
been submitted then.
Till now, she is paying the amount as per her demand.
Petitioner approached the Jadavpur police station for registration of the FIR against the respondent number 3. Who is a husband alleging commission of offences of criminal intimidation, physical and mental torture, including physical assault and attempt to murder her. Full stop. State has submitted a report. Report reflects that after such information was furnished on 10/12/2023, on 3/1/2024, she submitted another letter in which she mentioned that she did not want to lodge any criminal case against her husband. Full stop. The report of the officer in charge Jadavpur police station further reflects that earlier 2 cases being Shonarpur PS case number 913 of 15 and Hirapur PS case number 137/14 was registered pursuant to the information furnished by the petitioner. Learned advocate for the respondent number 3 submit that he is a school teacher and is being implicated in a number of cases at the behest of the petitioner. Having regard to the steps which have been taken by the police authorities, I am of the view that the same is adhering to the provisions of law. As such, no interference is called for. Accordingly, WPA 6769 of 2024 is disposed of. Reports are submitted. Be kept with the records. Our copies next.
My lord, copy of the report.
Copy of the report be given to both the parties. Yes.
My lord, I am for the state respondent.
Yes.
Land disputes, my lord.
Not in respect of the plot in question, that is annexed P1.
Admittedly, the respondents were creating disturbance.
Jurisdiction, my lord, having any right title, they are causing disturbance.
Thereafter, what happened?
107, 116 initiated, my lord. My lord, we have made inquiry and admittedly the respondents were creating disturbance.
Petitioner informed the officer in charge Golshi Police Station on or about 19th of February 2024 as the petitioner claiming to be owner of the property was being disturbed by the private aid respondents, and to that effect they were trying to encroach upon the property and also interfering with the peaceful enjoyment of the property. Full stop. Police authority is conducted an inquiry. Inquiry reflected that the private respondent and the associate respondent number 4 and his associates were creating disturbances. As such, a proceeding was drawn up under section 107, 116 oblique 116(3) of the CRPC. Full stop. Grievance of the petitioner is that there were much more than a proceeding relating to 107/116 CRPC being drawn up. Full stop. In case petitioner is aggrieved by the act and actions of the police authorities, petitioner would be at liberty to approach the jurisdictional magistrate under the relevant and provisions of law. Chalo. With the aforesaid observations, WPA 70048 of 2024 is disposed of. Reports are submitted, be kept with the record. A copy of the report be handed over to a learned advocate appearing in for the petitioner. Chalo.
Grateful, my lord.
Yes, my lord, I beg to appear on behalf of the petitioner, my lord. Here, my lord, 8 January 2021, my lord, the decree has been passed in favor of the petitioner. My lord, where, my lord, if your lordship kindly come to page 34 bottom. Page 34 once. Page 34. My lord has got it at bottom. Decree has been passed for the recovery of possession. Now, my lord, page 42, my lord will get by 7th December 2022, bailiff appointed and he has given the possession. Page 42. And he has submitted the report. My lord has got it. My lord, the 7th December 2022, I have been given possession just, my lord, 13th December. Again, my lord, just the next day, under the aegis of the police authority, my lord, I have been ousted from my possession. Now, again, my lord, the possession has been given by the police authority to the private respondents herein. And not only that, say they have filed section 47 to that effect, but till today, no stay has been granted.
My lord, my first objection is with authority of the police authority. We have reinstated them. This is an allegation that has not been made anywhere. Now these statements are being made from the bar. There is no allegation against the police authority for that. They made a complaint, inquiries were made, 107 was done. Look at
107, what will do, my lord, I have got the, again, my lord, I have to file and recovery of cash possession, again 10 years. For 10 years, I have to run.
But we'll see their prayers. They want what? That we will vacate the premises and hand over the possession.
Exactly. That has been done by the civil court.
On their property. They have taken an ex parte decree.
Yes, absolutely. That has not been challenged.
My lord, which has, my lord will see the order at page 51.
My lord, property belongs to irrigation and waterways department.
Assist the police authority. Any old.
And my lord, they are the unauthorized encroacher. And they have got, my lord.
My lord, all this disputes is not subject matter for the police.
Give me this.
My lord, but there's this allegation that with the assistance of the police authority, this is not done. Let him prove such assistance.
And receipt which they have annexed with these writ petition, my lord, all are manufactured documents.
All are, the decree has been manufactured. Bailiff document has been manufactured. My lord, what my learned friend is saying.
Truth will come. They have not made a party to the irrigation and waterways department.
And has no authority to challenge the land ownership of the land.
Unauthorized encroacher.
নিজেদের মধ্যে ঝগড়াটা আর কোথাও করুন না এখানে কেন রিট কোর্টে কেন
Petitioner complains that after obtaining after the civil court passed a decree in his favor on or about 15/5
Under section.
Let me The 15/5/2023 is the order passed in your execution case.
Yes, my
lord. My lord, it has been disposed of.
And the police representation is which dated?
No, my lord, decree has been, my lord, bailiff possession has given, my lord, page 42, 7 December 2022. Page 42.
The private respondent file another suit, and my lord order the 9 Rule 30 for cancellation the ex parte order.
No, but the
That has been disposed, my lord, since
you did
my
not.
lord, you see the order at page 51.
Yes, and you did not inform it to the court. It was the decree was execution case is with full satisfaction.
My lord, that was done, my lord, if your lordship can see 7th December 2022. Page 42. Page 42.
Please see the order at
But
page
you should have
51.
participated when the execution case was accepted.
My lord, execution based, my lord, at my instance it has been done.
You were on 15/5/2023. You did not point out to the court that that has been reoccupied also.
No.
No, that was not done. I believe I cannot make the untrue statement.
And the with full satisfaction
Did not press the application for
Yes.
execution.
তাহলে কি করে হবে?
At that point of time, the police, they had filed their police complaint, but they did not think it necessary to mention it in court. And the police have done the investigation, filed their whatever needed to be filed.
কি বললাম? The position was handed over by the bailiff and subsequent in there too. In the private respondents forcefully occupied a portion of the property. To that effect, information was furnished on 13th of December 2022 and again on 12/2022. Full stop. Records reflect that in OEX 01 of 2021 on 15/5/2023, the execution case was disposed of with full satisfaction. No information was furnished to the learned civil judge, junior division, additional court, Tomluk, Purbo, Mednipur, having in regard to the same that on 15/5/2023, no information was furnished to the concerned civil court. And the report reflects that only informations was sent to the police authorities by postal means. I am of the view that no interference can be made until and unless the issue is until and unless the petitioner until and unless the petitioner is can satisfy the court his participation in the execution case on the last date of proceedings.
I'm grateful, Virat. I'm grateful.
What's the contents of the order dated 15 May 2023?
Have full satisfaction, I have said.
My lord.
Learned advocate for the private respondent and submits. You have challenged the decree. Whatever.
But my lord, by that same order, everything has been disposed of.
The application was filed, it is accepted, and my lord, hearing was not made.
My lord,
Where is it pending? What is the status of the case?
My lord will see at that same order at page 51, petitions filed by the judgment debtor after delivery of possession do not demand any disposal before this court. It's recorded.
What is the date?
16/10/2023.
Learned advocate for the you have prayed for setting aside of the ex parte degree. Learned private respondent submits that they have preferred an application before the civil court for setting aside of the ex parte degree and the same is pending. Be that as it may, since the civil court is already insisting of the issue, I'm not inclined to pass any directions upon the police authority is at present. Full stop. We therefore say 8 observations. WPA 8534 of 2024 is disposed of. Reports are submitted, be kept in the record. Server copy next.
I'm grateful. I'm grateful.
Obliged, madam.
Wait, please, Lord.
Yes.
On the basis of my complaint, my lord, a PS case has been started under section 448 and the below 336.
That's of 2020.
2020. Subsequently, my lord, no steps has been taken This matter has been taken up on 3 occasions, my lord, take time for the filing the report.
Okay, file a report. Let me go through 1 minute. 1 minute, sir.
Kindly have a look at page 20.
26. Hello. Your charge sheet was submitted in the year 2022, sir.
There are two cases, my lord.
Cases are there.
One case filed against the petitioner and her husband. The petitioner filed a counter case against the persons who lodged the case against the petitioner and the husband on the charges of that rape was committed on her. my lord.
Under the one. But you have got to give an outcome.
My lord, kindly come to the last page of my report, my lord. Second paragraph, my lord.
Obtaining permission from superior as a case is special report case.
The allegations has found to be, my lord,
Then
false, my lord. My lord,
we have got to either close the case or
my lord, that permission is required, my lord. We are getting permission from the superior
not-
officer, my lord. My lord, we are.
That is your internal department problem.
That is there, my lord.
17/7/2020.
My lord,
It's almost 5 years you are not going to give a report.
that is there, my lord. That thing is there.
Submit a report. Submit a report. I'm keeping the matter pending.
After effect is this on the my lord, the 15th of April 2025. My husband has been attacked by all the accused.
There's a
persons.
subsequent change.
There's a subsequent.
This has already been filed, my lord, on the basis of
That material is not before me, sir. This report is before me. I'm dissatisfied. I'm keeping the matter pending. Let them come up with a fresh report.
my lord, let there be direction to give me my lord advance copy so that I can peruse and I can argue on the next day. My lord. Thank you.
That argument will be before the court below. That not way. Over here, I want to see what they want to do. Right. Petitioner is aggrieved by the manner in which Horischandra Opu Urpi case number 448/2020 has been dealt with by the police authorities. State has submitted a report. Report do not reflect the till date. State has submitted a report, comma. The report do not reflect that the police authorities have reached their finality in the form of a report required to be submitted under section 173 CRPC. Full stop. Accordingly, as almost 5 years are approaching since the initiation of the case, police authorities are directed to take steps in accordance with law and submit a fresh report before this court. List the read petition under the heading for orders in the monthly list of June 2025. Report submitted be kept with the record. So next.
I beg to appear on behalf of the petitioner, Lord.
Yes.
The old matter, Lordship. Subsequently, the representation has been considered, FIR has been registered, and after that FIR, Lordship, charge sheet has been submitted. We are agreed with the charge sheet, Lordship. We have filed a PRR in this regard.
Well, report is there on 7th of May 2024. Lordship, can he dispose it of? Well, he has filed an RIG petition before the learned court.
Learned advocate appearing
Let the
in
court
for
below
the
dispose in accordance
petitioner.
with law.
Submit is that being aggrieved of the inaction of the police authorities
report আমি জজ সাহেব
of Amta police station and
ভালো করে বেঁধে রাখি
the petitioner approached the court, however pursuant to the writ petition being filed and during the pendency of the writ petition, steps have been taken by the police authorities. Consequently, and in course of investigation also, finality has been attained so far as investigation is concerned. Petitioner is taking steps before the jurisdictional court in accordance with law. Learned advocate for the respondents who are
Respondent number 7. Why?
I am for 9.
learned advocate for the respondent number 7 and 9 is present. Mr. Basu represents the state. Having regard to the stage of the case, I am of the view that no interference is called for at least.
Lordship, since I have not used any affidavit, Lordship, all the allegations.
State that since no affidavits have been called for, the accusations made in the writ petition are deemed not to have been admitted. With the aforesaid observations, WPA 8695 of 2024 is disposed of. Several copies. Next.
My lord, I appear for the respondent number 4 to 10.
I appear for the state. I appear for the petition.
Petitioner, yes, what is your problem?
The
restraining the petitioner from my lord using the tube oil and my lord the toilet.
High Court, tube High Court.
property, my lord.
My lord,
তাতেও পুলিশ জল দিতে
You
গেল
lordship, kindly come to page 22 first. Page 22, your lordship, kindly. Entire thing will be clear, my lord.
and my lord the inquiry
আজ কাশীপুর দক্ষিণ পাইক এত কেস নাম্বার এত তদন্ত থাকাকালীন আমরা উভয় পক্ষ হাজির ছিলাম, হাজিরা দিলাম। আমরা উভয় পক্ষ সম্মত হইয়াছি যে আলোচনার মাধ্যমে আমরা আমাদের সমস্যা মিটিয়ে নেব। আমরা নিজ নিজ বন্টননামা দলিল করে সমস্যা মিটিয়ে যে যার জমি ভোগ দখল করব।
তো ডেট কোথায়? Where is the date? চলে আসুন চলে আসুন।
Date is there at the top, my lord. 5/1/2020.
my lord the
Where?
inquiry report shows that the
First line,
opposite
first
party-
line.
5/1/2000. Petitioner approached the ISCO or being aggrieved by the inaction of the police authority is as, in spite of information being furnished, no steps were taken by the inspector in charge, Horipal Police Station. Full stop. Learned advocate for the state has
My lord, 4 FIR. In fact, 4 FIR has been registered.
and
4 FIR has
my-
been
as per
calculated
the
into charge sheet, my lord.
inquiry report, my lord, the opposite party is very
And the
dangerous in
response
nature.
also, my lord. They have lodged
But
2
all right.
complaints and that also
it
calculated
submits
into
that
FIR.
4 FIRs have been
FIR and
registered
charge sheet, my lord.
in respect of the disputes, different disputes
And my
between
lord,
the petitioner and the private aid respondent. In respect of the cases, so registered police authorities have already submitted a charge sheet. Learned advocate for the respondent number
My lord, 4 to 10.
428 is also present and denies and disputes the contentions advanced by the petitioner. Records also reflect that the petitioners on or about 5 petitioner and the respondents on or about 5/1/2023 entered into a mutual settlement, be that as it may, since the police authority have already registered cases.
Page 4, my lord. 4 FIRs after
inquiry
5 lines,
report
6
in page
lines.
18, my lord,
Page 4
report
after
itself, my
fifth,
lord,
lost
speaks
3
that
cases.
petitioner's
they are,
daughter-in-law.
my lord, the
No.
very much dangerous in nature, my lord.
3 cases are against them.
Dangerous.
There are 4 cases
In the
registered.
year 2023 and 24, I am of the view that এখন ঝুট ঝামেলা চলছে তো 354 be minimum, 76 is maximum.
Only my
I am
source
of
of
the
drinking
view
water.
that the police authorities are well aware regarding the nature of the dispute existing between the petitioner and the private aid respondents. Since a case was registered also in the year 2024, police authorities would ensure that no untoward incident results as an inimical relationship is existing between the petitioner and the private respondent. Chalo. With the aforesaid observations, WP 8706 of 2024 is disposed of. Reports submitted 8BE kept with the record server commission.
Get.
আর দিও না, এটা দাও, ওই যে ফিক্স ম্যাটারটা দিয়ে দাও।
Grateful, my lord.
এটা বন্ধ করে দাও, ফিক্স ম্যাটার যেটা আছে 2 নম্বর দিয়ে দাও।
1 PM fixed matter, item number 2.
I am for the petitioner.
এটা বন্ধ করে দিচ্ছি।
My lord, in this matter, I'm for the state led by Mr. Shapan Banerjee, my lord, learned AGP, my lord.
Mr. Bandyopadhyay is appearing. This, have you gone through the petition? Sir, the difficulty over here, you come to page, you got a, that is what I want to tell him actually. Come to page 44, sir. 44. There are 3 grounds of arrest which have been given.
Any further offense, you may tamper
Tamper with-
the materials of the evidence.
So these three reasons which have been assigned, if you see the two judgments of the Honorable Supreme Court in Probir Purokayasto's case and Bihan Kumar.
Yes. Your Lordship is speaking about this last one, 2025.
No, 2000,
Referring to?
Vihan Kumar is 20.
Bihan Kumar.
And the other one, 2020, Prabir.
That's right. That has been relied upon here.
Now, these are reasons of arrest. That these three things which have been stated are not grounds of arrest according to the classification made in those judgments.
Okay, I'm just coming. I was looking with this. See, first paragraph 8 is very important. In this case, a commission of cognizable offense punishable with imprisonment for a term which may extend to more than 7 years has been alleged against the appellant. I don't know what is the allegation.
376, sir.
376. Then the allegation is there.
More than 7 years.
Now, protection against there, Article 22 first. No person who is arrested shall be detained in a custody without being informed, as soon as may be of the grounds for such arrest, nor shall be denied the right to consult and to be defended by a legal practitioner of his choice. First is, no person who is arrested shall be detained in custody without being informed. That is for information. This arrest, as soon as may be of the grounds for such arrest and also grounds for such arrest. Now the grounds of arrests have been given. First, let us go one by one. First of all, Miller, 1, 2, 3 grounds for arrest have been given. This is the main crux of the matter. Why these grounds of arrest would be given? And also section 50 is said, every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offense for which he is arrested or other grounds for such arrest. Here, either information or other. But constitutional provision will prevail over the statutory provisions. Now, is power to arrest. In this, you may note that this quoted paragraph 30. In this regard, we may note that Article 21 of the Constitution provides inter alia that no person who is arrested shall be detained in custody without being informed, as soon as may be on the grounds for such arrest. This being the fundamental right guaranteed to the arrest person, the mode of conveying information of the grounds or arrest must necessarily be meaningful so as to serve the intended purpose. It may be noted that section 45 PMLA never so and so. Let us go. Then the 42. In this said decision, this court in paragraph 42 and 43 observed in that being so, there is no valid reason as to why a copy of such written ground of arrest should not be purposed to the arrested person as a matter of course and without exception. There are two primary reasons as to why this would be the advisable course of action to be followed. As a matter of firstly, in the event such grounds of arrest are orally read out to the arrested persons or read by such persons with nothing further, and this fact is disputed in a given case, it may boil down to the word of the arrested persons against the word of the authorized officer as to whether so and so, so and so. Then the 43. The second reason as to why this would be the proper course to adopt is the constitutional objectives underlying such information being given to the arrested person. Conveyance of this information not only to apprise the arrested person of why he is being arrested, but also enable such person to seek legal course. There were two parts. Arrest reasons have to be given, grounds have to be given so that he can take a legal step. Now these are similar. That not the so many grounds have to be given, so many reasons have to be given. Kindly take a practical things. Practical, suppose a offense is being committed, preventing it. Now that on the spot, no one can expect that the details grounds have been given, can be given by anybody, nobody. A small ground is helpful for that because he has to take a recourse. Constitutional mandatory provision is complied with, and second reason. Now here you see it, you may abscond from the area. This is a formation of opinion.
So just 1 minute, sir.
My lord.
Either in this judgment or in Probi Puroka's judgment.
Pardon?
Two judgments are there. You are following Vihan Kumar.
Vihan Kumar has followed that
Probi
Pawan
Purokas.
Probir and Bansal.
Bansal, it was a PMLA case.
PMLA, right.
So PMLA, you have other provisions. I'm not bothered with that. Now, there a distinction has been made between what is reasons of arrest and what is grounds of arrest.
Para 49. Which judgment, Miller? That
just give him, no, please.
নাম বল
প্রবীর প্রকাশ
প্রবীর প্রকাশটা কোনটাতে আছে প্রবীর প্রকাশ yes
it may be reiterated
para 49 আছে
para 48
para 48 আছে
48
it may be reiterated that
48 sir 48
কোথায় পারলে আবার তুই কি করলি এখানটা yes it is it may be reiterated that at the cost of repetition there is a significant difference in the phrase reason for arrest and grounds of arrest. The reasons for arrest is indicated in the arrest memo are purely formal parameters, that is to prevent the accused person from committing any further offense, for proper investigation of the offense, to prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in any manner, to prevent the arrested person from making inducement, threat or promise to any persons acquainted with the facts of the case as to dissociate him from disclosing such facts to the court or to the investigating officer. These reasons would commonly apply to any person arrested on charge of crime, whereas the grounds of arrest would be required to contain all such details in hand of the investigating officer who is necessitated the arrest of the accused. Simultaneously, the ground of arrest informed in writing must convey to the arrested accused all basic facts of which he was being arrested, so as to provide an opportunity of defending himself. Correct, my lord. I was coming to that also. See, my lord.
Mr. I just want to, since I am dealing with so many
yes,
cases,
yes,
I've got to regularly update.
Yes.
Sir, two things. Along with that, don't complete the argument today. You please
yes.
apply your mind, sir, because this has got a far-reaching effect.
Far-reaching effect.
There's one judgment of Radhika Agarwal. Whether a writ court can see this, paragraph 87 and 89, Justice Bela Trivedi's judgment.
My lord, without reading this, I can say, as a counsel, writ court can look into the matter. No doubt. Without reading into this, My lord, I am not this only. I will not my knowledge of the constitutional law confining with any judgment on any single judgment. There are a number of judgments. I don't know what are the judgments are there. Anyway, the question is exercises of such a discretion. See, my lord, if the grounds of grounds or reasons which are not at all there, why the magistrate will not look at it? It is an alternative remedy in that case. It is not an absolute remedy. I am not saying that the court has no power at all. I am saying so. Suppose, my lord, what is the duty of a magistrate or wherever the appropriate court? Suppose, let's assume I have not given the memo of arrest or not the ground of arrest. Then magistrate has to set him free on bail. That is the pure and simple thing. Let's assume that there is a ground, my lord, a 24 hours is a very important time. Suppose, my lord, I am catching someone, I am holding someone, I am saying that, yes, this is a position. Yes, you are arrested, this is a memo of arrest. Let's assume for doing some illegal acts which attracts, my lord, the cognizable offense more than. But immediately it is not possible for me to write down a ground, entire fact there. It's not possible. My lord, I am not arresting a single person. When a law is will be settled, try to, my lord, appreciate also with the difficulties. Suppose one I have arrested. I have to arrest another 3 persons. I don't have any time. What shall I do? I will be busy with the giving this, or to prevent the person or to arrest the other persons. I will spend myself. There are some times, my lord, which are very important times are there. You can't spend any single moment there. There cannot be, my lord, a straitjacket formula. Rather, if I say so, my lord, I will make the argument. I was thinking about that. I was that there is cannot be straitjacket formula. My lord, here only one aspect of the matter, my lord, with great respect to the Supreme Court. With great respect to the Supreme Court, only one aspect of the matter has been looked into. My lord, never, judiciary never be overzealous to the, my lord, the police administration. But the work of the judiciary is not also to confront with the police administration. These are the, my lord, one exists for another. Otherwise, it cannot be. Therefore, it's a 24 hours time you have given me, because I have to produce an accused who has been arrested to the. And more particularly, my lord, here under the Constitution, it has not been said within which time. Therefore, a reasonable time has to be read down there. A reasonable time, according to me, reasonable time is 24 hours.
That's 167 or 187 or CL.
Reasonable time is 24 hours. Therefore, I can give the full fact and the reasons. What are the facts? But if the full facts are given there, that is not also expected. In a constitutional law, in an administrative law, there are other branches of thought. This is not only the one thought. Thought is that court will not, it is not for the court to enter into the sufficiency of reasons. A reason is there, one single reason is there. That is enough. It is not for the court's duty to look into the sufficient, whether sufficient reasons are there given or not, sufficient facts are given or not. Kindly appreciate this, Lord. Why I am ঠিক আছে তুই পাঠালি করে অ্যাকসেপ্ট করে না আমি একটা আর্গুমেন্টের মধ্যে thinking is something where I am. Lord, kindly what I was thinking to দুম করে ডিস্টার্ব করে দিতে, that I was thinking something different.
You think?
No, I am saying, my lord,
one thing
practical view has to be taken.
One thing I am telling you, with my experience in criminal courts, I've worked criminal court for. On the first day when the accused is produced, a forwarding is usually given to the
Yes. Oh, yes, I was coming to that. He has detracted me. Now, my lord, in the kindly see, when within 24 hours, when a person question is the reason, how it is to be communicated. Let's see. I was just going to tell your lords, he detracted me, that when it is produced within 24 hours, then someone comes, either of the counts, my lord, accused, any lawyer, or there grounds are being communicated to the magistrate. Communicated to the magistrate. And the point is here, my lord, what I am submitting on. Point is here that if the reasons have been pointed out, or the grounds, whatever I say, I have pointed out to the magistrate, then the magistrate will apply his mind. Magistrate is seasoned over the matter. Magistrate can understand what are the problems are there. Whether in that case writ court would interfere or not. But I am not saying at all that writ court has no power. I say writ court has power. But whether the writ court will exercise that power or not. Because this is all magistrate functions cannot be taken by the court.
This is becoming a very headache, actually. Another thing which has been said in one of these judgments is that prior to the bail application being preferred by the accused in the court, these grounds of arrest must be there so that he may know the case against it.
But I agree with that.
Observation of the.
I agree with that. What I am submitting, that may be a possible way to think about that. What I am submitting, at the time of the arrest, you give an arrest memo. If you give a reason, simple reason, or it's all right. But a little more reasons. I am not saying sufficient reasons. Little more reasons can be given within 24 hours.
That is what has been said. But prior to the bail application being preferred.
No, now
so that is what is
that there is no disagreement so far my thinking and this other is concerned. I have not read it. I have not read. Now, naturally, bail application would be moved.
What will the
Within-
lawyer say?
on the, and it will be, normally it is moved. Now, the point is when the bail application is moved, I hand over the entire case diary. I hand over the entire case diary. Reasons are there. Who is point there? Who will go into the reasons there? High Court, Supreme Court, or the magistrate? When, let's assume when a bail is not granted by the appropriate court, I have to accept that the whatever the reasons I have given, that's enough. Let's assume the bail has been granted. Two things may be to the magistrate. This is not that much of offense that he is required to be kept in custody. Or secondly, importantly, the reasons which has been cited, that reasons is not acceptable. Therefore, kindly just, your lordship, I am grateful that your lordship are giving. I have read this judgment. Of course, in the yesterday night, someone told me that possibly for this matter, I have been asked to appear. So naturally, I wanted to know what is the case. Then said Mr. Shishwana Bandyopadhyay also told me. Now he also told me another one thing, that all these matters have gone to the larger bench.
Where is that? I'm not getting that.
Where is that?
Larger bench, na, there is another decision which is pending on 22nd of April. Justice Gawai has made a reserved the judgment. I mean,
Oh, sorry, not the larger bench. Another matter has been heard. But if he disagrees, he has to refer. 22nd April, that has been. But my point is anyway, lordships, I will let me argue in these matters. Fully, let me argue all that constitutional side, this side, that side, what are the difficulties. But with great respect, the Supreme Court has not taken the difficulties of the police administration also. Let's assume, my lord. Let's assume. Today I was coming, I have seen a video.
And the other part, there is another part which I am to be hearing in the ED matter today in the evening hours.
ED matter?
There is state is not connected, enforcement directorate. There the point is much more interesting. There the accused was produced on the basis of a production warrant.
Achha.
And they say production warrant means a person is already in custody in another case, he is brought into
another case.
Case. Then how will this be handled?
How
will these grounds of arrest? On the first day, he has a right to move a bail.
Correct. There I have another. There I have one submission, although I am not there. This arrest or this production arrest or what may be the power, this power cannot be exercised capriciously. Let's assume, my lord, that one person has been arrested for committing an offense under the Indian Penal Code. Correct. He is there. It is within my knowledge. Everybody's knowledge in that. Now, when he is going to get a bail or he has got the bail, then another department is coming. This is, my lord, harassment. If you want to arrest, what is the purpose of the arrest? To interrogate. One of the important part is to interrogate. That if the person has been interrogated, when you had a chance to interrogate, if you didn't interrogate, why the court will allow him to interrogate further? This is a vindictive attitude. From the constitutional law, I am saying, not
because all on a sudden difficulty which I am facing is that these were all preventive detention concepts.
Yes.
Which has been brought into regular arrest cases.
That has been brought by the Supreme Court. Now, my lord, question is, one is two law. One is a statute law, one is judge-making law. Which law will prevail? Statute-making law, even the constitutional law. Just read the constitution once. They can give me the constitution 22. আজকে কিছু হবে না, জাস্ট জজ সাহেব আমার এটা শুনতে কনস্টিটিউশনটা দাও না, আনলাম তো।
Stating that within 24 hours, a ground of arrest should be submitted before the court. Bhiyan Kumar, if this actually ground of arrest is informed to his wife, court take the ground of arrest should not be afterthought of the arrest.
No, not after the ground of arrest, not after the. This cannot be established by the prosecution. This cannot be established. My lord, another, I was reading the judgment. Just 1 minute, please. You have to communicate in his language. Let's assume one Tamil Nadu pupil has been arrested. What shall I do? Or I don't know Hindi. If I arrest, so what shall I do? It has to be taken a balance. Balance has to be created, my lord. It is a one way, sorry, with great respect.
That is why I am facing
Yes,
the
yes.
problem, sir.
Yes, one way gets it as this. The kindly see 22. No person who is arrested shall be detained without being informed. As soon as may be of the grounds for such arrest, not shall be denied the right to counsel and to be defended a legal practitioner of his choice. No person who is arrested shall be detained in custody. The no person shall be arrested, not at that time I have to give it. Who is detained in custody? When, how long he detains in the custody? 24 hours. Then 24 hours, within 24 hours. Now, inform. Inform has not been said to be in writing.
That is clarified, sir.
No. Clarified why? Clarified why? Clarified why? Because the prosecution, the defense may say, no, it has not been, to establish the case. There are so many now, the methodology has come. No, over telephones, one can
digitally also.
and can call it, save it or anything. Anyway, I am not trying to dilute these things. With a protection which has been given to a citizen under the constitution, I'm not. But the protection which has been given, that should not be exploited.
This is what is
that should not be exploited. Therefore, shall be detained in custody without being informed, as soon as may be of the grounds for surrender, not shall be denied the right to counsel and to be defended by a legal practitioner of his choice. Now, my point is, the moment, let's assume I have arrested someone. I told him he wants to consult a lawyer. It is often happens. It often happens. And lawyer comes to the police, asks what is the ground of arrest. There are more clarification rather is needed. Tell me, my lord, the date I will come and argue. Next week, is it possible? This is the order.
Next week possible.
As the bail has been rejected.
Here,
in his case, bail has been rejected or not?
Bail has been rejected by the learned magistrate. Bail rejected by the learned magistrate.
Bail rejected, no? Bail has been rejected. Therefore, counsel, there's no.
That is what I am saying, sir. That in Radhika Agarwal's case, it is what I followed is this. That is why I posed the question whether the subjectivity of the contents of a ground of arrest can be gone into by a writ court or the regular criminal court will go.
Well, it is not, I have argued that all that, it is not absolute bar. I am not, but it is not proper for the writ court to exercise the power.
This is the second point. Because suppose these grounds of arrest which has been given, this format is given, grounds of arrest to him. But the grounds which have been given over here are actually not grounds. They are reasons of arrest.
One thing.
Can I interfere with that?
No, this is at the first. Whether the second stage anything has been. Let me inquire about this matter. But the reasons have been given. Reasons. Court cannot interfere with the reasons. Court cannot say no. These reasons are non-existent reasons. It is not that they kindly see what has been given. Or reasons are down. To be anytime. It's a case of 376 is saying. I don't know how to read. You may abscond from the area. This is also. Now, you may commit any further offense. That's not very important. You may tamper the materials of the evidence. What more could the court will see?
That these they classify, the Honorable Supreme Court, these are reasons of arrest. These are not grounds of arrest.
Okay. Now, they therefore take 24 hours as needed. 24 hours are needed. One has to appreciate this. In our country, as I am telling, that is not being appreciated. In our country like us, you see this police force, they are very much subjected to criticism everywhere. But they put a hard level. Now that everyone is not so much learned, Had it been so learned, they would not have become constable, they would not have become sub-inspector, they would have become lawyer. That practical things have to be taken care. I was coming and I have seen a video. What is the video about? Yeah, I was coming from home just 1 hour back. Video was that 500, 700 people, nearly 500, 700 people were raising slogans against the India government and against the Pakistan government. Police have arrested him. Now, is it feasible for the police to give the arrest memo? Is it feasible? 500, 700 persons. And police has to prevent that because that was against the country. Now, a practical approach, practical thing is needed to be looked into. Anyway, Miller, kindly tell me, Miller, next week.
Because earlier it was under the special acts, we understood that. PMLA, this started from Pankaj Bansal, which is a PMLA. PMLA section 19 is
now
there.
It has been incorporated in
the
BNS.
Indian Penal Code. Vian Kumar has come to 406, 409 cases.
No, also BNSS Act, section 36 na কত দেখতো?
47 is there.
Yes.
36, 47, 50. ঝামেলার পর ঝামেলা করে।
Judgment reserve করেছে on this point.
হ্যাঁ ওটা বলেছে Mr. Dotto was submitted before your lordship on that case that Latka, that a matter was heard by Justice Gawai and Bian Kumar has been considered but the judgment has not been delivered. PC numberটা জোসেফ চাইছিলেন
I'm providing the
চাইছিল SLP. Your lordship was asked for the
but Mr. Singh, you find out that Radhika Agarwal's case, please.
We have given
Paragraph 87 and 89, so that Mr. Banerjee can go to that. Because I believe there is an obstruction created over there in interfering under Article 226.
এখানে কি বলে এখানে রিজার্ভ ইন অ্যান অ্যাপিল অ্যারেঞ্জমেন্ট টু আনসার দি ফাইল commercial time between the charge sheet has already been filed and the accused has been hard the documents. The question that we are called upon for constitution is whether in each and every case, if arising out an offense under Indian Penal Code would be necessary to furnish grounds of arrest to an accused either before arrest or forthwith after arrest. Another question that this court is required to consider whether even in exceptional cases, where account of certain exigencies, it will not be possible to furnish the grounds of arrest either before arrest or immediately after. The arrest would be vitiated on the ground of non-compliance with the provision of Section 50 of the Code of Criminal Procedure. Hearing concluded, judgment reserved. It's better to we should wait. Let's see. Let's see.
SLP, what is the SLP number?
SLP number is
1713
কই পেলি এই তো এখানে
SLP criminal 171.
হ্যাঁ SLP criminal number 17132/2024 এটা আমাকে পাঠিয়ে দিস
But now the 2 months vacation is there.
Your lordships can keep it. We are having another 2 weeks. A judgment will come very shortly. He has kept it for becoming Chief Justice.
Difficulty person is in custody. Everybody, this is the difficulty of the court. I have got no issues.
No, but this.
I am also agreed by the arrest memo.
Is under consideration.
Arrest memo is page 43.
Is under consideration.
No, may I submit one thing? When the bail has been rejected,
I think the statutory courts would be.
Yes, when the bail has been rejected, they can come to the High Court also in the criminal side.
That is what I am on. That is why I said that Radhika Agarwal is a bar for considering this.
Okay, I will see to that.
Whether this would be a judicial overreach.
It hardly needed to be reiterated. The power of judicial review over the subject is that opinion of the statutory authority would be different fact depending on the facts and the criteria of parameters of judicial review over the subject is applicable in service-related matters cannot be made applicable to the cases of arrest made under the special acts. It is special. The scrutiny on the subjective opinion or satisfaction of the authorized officer to arrest the person could not be a matter of judicial review as much as when the arrest is made by the authorized officer on having been satisfied about the alleged commission of the offence. The matter would be a very nascent stage of the investigation. That is also very important. Very, very
A very
important.
prudent approach which has been taken.
Yes, that's a nascent stage of or inquiry. The very use of this phrase, reasons to believe, implies that the offence should have formed a prima facie opinion of the so and so. Sufficiency or adequacy of the material on the basis of which such belief, that is also I have submitted, that your the authority would not be a matter of scrutiny by the court at such a matter. Subjective satisfaction and objective basis was the criterion in the service jurisprudence, not pure subjective satisfaction.
That is why I am saying, even if the grounds are wrong over here, let me presume the grounds are wrong.
Yes.
Can I, under Article 226, consider this?
No, my lord, may I just here also can think about another thing. Let's just think. Arrested, ground of reason has been given. My appropriate court did not grant the bail. 15 days have gone. In the meantime, has come to the High Court. Within 15 days, certain developments have been taken place. New materials in the investigations have come, which may establish his involvement. So what the High Court will do? The principles which are taken in the quashing proceeding, that no, you can't go into the, just see whether allegations are there or not. That's a simple thing. If this is the nascent stage, you can't expect more. That's the reason I said, Miller, there are a number of judgments in the constitutional law, in the administrative law. Sufficiency, inadequacy of the reasons are not to be looked into by the High Court. Muller, now one has to think, are we running after the overstretching of the protection or legal provisions or not?
These paragraphs I have got to overcome also, since this is also a Supreme Court judgment.
Judgment, yes, Muller, I will. What was it?
Judgment.
Three judges. 200449. Oh. Three judges judgment. Sanjeev Khanna, M.M. Sundaresh, and Bela M. Trivedi. 3 judges. এটা কারটা তোরটা?
That part is Justice Trivedi's 87, 89 is
আমি তো
Justice
আরেকটা
Trivedi.
দিস না, ওটা কোথায় গেল? ও আচ্ছা, এটা তখন আমার কাছে ছিল না. It was not there. I was up to that. This was not with me.
I have got to frantically search for judgments in order to, because morally, one is that I am bound by certain things. One is that a far-reaching consequences of the orders of the court. This is also very much disturbing me. And another thing is that in each and in every step, if writ court interferes, what will the statutory courts do, sir?
That's right. Exactly.
When it's V.N. Kumar judgment, there is a direction to the magistrate under Article 141. If ground of bail is ground not available in the arrest memo, with the arrest memo, give them the bail. But the lower court is not looking the.
So against that, you file 439.
Yes.
As simple as that. Why under 226 I will in? That is where I am on, because I don't want to open the floodgate.
The arrest is illegal. Detention is illegal.
No.
But you have prayed for bail. Your prayer was under 437 before the learned magistrate.
Yes.
Now 437 rejected on the grounds you have taken. You have taken reasons of arrest were not furnished, grounds of arrest were not furnished.
Yes.
On that grounds, whatever is that magistrate considered or did not consider it, it was rejected. Now, will it be 439 CRPC or 226 of the Constitution?
That's right. Muller, question, Muller, I'm just saying, it is not an exceptional case, it is a normal general cases. In that case, in general cases, can the writ court nullify an order passed by a criminal court, appropriate criminal court?
That is what is judicial overreach.
Judicial overreach.
But we are not telling that this writ court will nullify the order.
No, prayers are
What
for
is
release
that?
of the petitioner, sir.
Petitioner released from the
Obviously, then if it is,
because his detention is illegal.
so this has got a far-reaching. Numbers are multiplying over here, so as these cases are.
That case that I said so,
It will be a flat ground of arrest. We are also aggrieved by the arrest memo also. For page 43.
Ah, that was before the magistrate. Both these papers were before the magistrate.
Yes.
These were your grounds in the application also, which you filed for bail. Your 437 was rejected. Ah, so will it be a 439 application or 226?
My lord, if we think in this way, suppose we go before the magistrate for the bail, but when he's taken into custody, his custody is illegal. Detention is this illegal. This illegality comes before this rich court.
Milord, kindly see section 36 of the BNSS also does not require any grounds. Prepare a memorandum of arrest which shall be attested by at least two witnesses who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made. Number two, countersigned by the person arrested. C, inform the person arrested unless the memorandum is arrested by a member of his family. Memorandum is attested by a member of that he has a right to have a relative or response. The Constitution, the Constitution 22.
In 47(1), sir, of the BNSS.
47(1). 47. Person is, yes. Every police officer or other arrested any person without warrant shall forthwith communicate to him full particulars of the offence for which he is arrested or other grounds for such arrest. Now, particulars of the offence, no difficulty. Or, kindly see, if he is arrested, I have given this is the offence under section so and so, so and so, so and so. That is sufficient. Or, not both. Therefore, and kindly come to again Article 22, Subarticle 1. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall be denied the rights to consult and to be defended. Now, here, what are the grounds? If I say for committing an offence under section so and so, so and so, so and so, that is also ground. That is also ground. Requirement of the constitutional provisions are not there. The elaborate facts, elaborate reasons have to be given.
But this has to be read along with the two judgments.
Correct. Two and also three.
Three. Three judgments. Mr. Nondi is there. Is any matter pending before the division bench?
No, not before my Lord Justice Mukherjee, my Lord. 1429.
বলবি যেখানে আমি আর্গুমেন্ট করছি কোনটা বোম্বে হাইকোর্ট কি বলেছে বোম্বে হাইকোর্ট হ্যাঁ ওটা তো দেখেছি মানে কাইন্ডলি ফিক্স আপ এ ডেট ওখানে ইন্ট্রিম বেল দিয়েছিল এখানে বেল রিজেক্ট করেছে ও জোসেফ বেল দিয়েছে এই কেসটা তবে এই any matter 22nd
22nd towards the end.
Then
but the thing is that you first address me on the whether 226 I can, and because many matters are coming, floodgate is being opened, sir.
I will not be here on 13th, 14th, 15th. I will not be here. 16th I have to come. Then I have to go again. 16th, would it be possible?
Virtually, you argue now. You continue with the argument, sir.
Okay. Can it be on 14th at 14th tomorrow? কালো হবে না 15th আমার okay 15th can it be done my lord after 4:30 4:30 because up to 4:15
এই 15 তারিখ কি মামলা আছে দেখো না
হ্যাঁ ওটা তো 4টে পর্যন্ত হবে তারপর তো ফ্রি হয়ে যাবো তো এই রিজেন্ট
ও 15th আরজি কর ইজ देयर
ও 15th আরজি কর ইজ
দেখো তো 15 তারিখে আরজি করা আছে 16 তারিখে আরজি কর না দেখো একটু হ্যাঁ 16 তারিখ না 15 তারিখে কি আছে আছে মামলা একটা হ্যাঁ কোনটা লতিকা ঘোষটা আছে নাকি? হ্যাঁ লতিকা your Lotika Ghosh is fixed on 14 then we can hear
Also, I have finished it.
the state would submit that.
Because I think they will not take much time. If it is, what is the time it is fixed by? Brother?
4 p.m.
2 p.m.
4 p.m.
4 p.m. Keep it at 4:30, 4:45, no difficulties.
Let the hearing of the writ petition on Mr. Bandyopadhyay, senior advocate, appears on behalf of the state. Let the hearing of the writ petition continue on 15th May 2025 at 4:30 p.m. Keeping at 4:30, fluctuating.
Yes,
Once,
yes.
once
5, 10 minutes, 10 minutes. I have no difficulty. 15th, I have to do it. 15th, I have matters. 15th morning, I am the walk off. 15th, but all will be finished by 4:30. That's the reason if 10, 15 minutes, I am late, kindly accommodate.
Yes, yes, definitely.
15th is very hectic day for me. 15th, such a
Unfortunately,
walk off matter is there. Murshidabad matter is there. Oh God. 2 o'clock it will continue.
2 o'clock, no, 3 p.m.
3 p.m. Yes, 3 p.m. It will continue for 15, 4:30. Then another big appeal is there, MR. Although I have finished that, I don't. There's no. I have to 4:30. And of course, I will be busy.
After 4:30, I'll take because let Mr. Shamunto continue.
If it is 10, 15 minutes late, kindly accommodate because 15th.
15th. Because this requires addressing number of matters are coming.
My lord, I will go both all this and the reasons and the alternative.
And in the meantime, training to the police authorities also. For training to the police authorities.
Yes, I am saying where case legal. You have understood the problem which we are facing. Now tell the DG to communicate to all the SPs and etc. to give a brief reason, grounds at the time of arrest. Correct. A format, make a format and give it. He is the ADJ law, Additional Director General Law. He is very good.
Of the Supreme Court.
No, you specific. I will tell you. I am telling. Okay. No, I have taken up the matter with the DG earlier also, and on that basis, circular has been issued. Let me talk and let me again.
In tune with paragraph 48, basically. In tune with paragraph 48 of that Purokayasto's judgment.
Radhika.
না পুরো পুরো কায়স্থ
বিবেক
পুরো কায়স্থ যেটা দেখালো ল্যাঙ্গুয়েজ
Language.
গ্রাউন্ডটা আলাদা রিজনস এন্ড গ্রাউন্ডস ডিফারেন্ট
তারপর যা হবে
I'm for the I'm for the petitioner, Lordship.
Yes.
Lordship, it is a matter of a very unfortunate widow mother, Lordship. Her two sons and her daughter-in-laws have forcefully thrown her out of their house, and they have forcefully made her sign the property, and they have also physically and mentally tortured her. Lordship, later on, when petitioner wanted to transfer the rest of her property to her daughters, then also her sons and the daughter-in-laws tried to abuse her, and then she was hospitalized. Lordship, kindly come to page 22. There's a written complaint.
May I, Your Lordship? First thing, Your Lordship, kindly comes to page 18 once, then I will hand over the report. Page
20?
Page 18.
Yes.
Yes. So this is a GD of 19/5/24 before Boranagar police station. Boranagar police are not made a party, Your Lordship. I am unable to get instruction because Boranagar police is not a party. Second, Your Lordship, kindly comes to page, this is page 21, the material report. I'm not standing in the way, Your Lordship, just I'm pointing out, then I can get the instruction. This is of 31st March 2025. She is stating that she has filed a complaint after that. Your Lordship, I don't find any signature, Your Lordship. In page 2023, there's no signature, and the GD entry she is relying on at page 25 is of December 24. Now we regard anything has happened, Your Lordship. I have got the instruction that a FIR has already been.
FIR has
Let me submit. Kindly see the report, Your Lordship. This is from.
Lordship, from private respondent number 6 and 8. Lordship, on the basis of the FIR which has been lodged and a charge sheet has already been filed in this matter.
When you send this information, page 22?
Lordship, page 22, there's a written complaint, but right now.
When did you send this?
Lordship, on 10th June 2024.
10th June 2000.
So what are your contents of this GD entry, which you claim to be of December 2024?
Lordship, the GD entry is of December.
So what is the contents of that? Number one. Number two, what happened to page 27? You have already approached the concerned SDO.
Lordship, petitioner has filled a form before the SDO tribunal for the maintenance, but she has not been called for any hearing and she has not been given any opportunity. And no steps have been taken.
The Lordship, in that maintenance, Lordship, they have been appearing for last few days. They are not appearing in the matter. They have been so caused by the learned.
Why are you not appearing?
Huh? Right now, I don't have instructions.
How do you expect the court to pass orders? So far as your page 22 is concerned, that refers to incidents of 19/5/2024.
Yes.
See the contents.
And 19/5/24 GD is at page 18.
Now, so far as the case is concerned, which has been registered by the police authorities, this is of 12th of September 2024. Yes. Hazy applications, how do you expect the court to pass order? I don't know.
Lordship, the petitioner cannot enter her house. Lordship, kindly pass an order, Lordship. So
This
that
is not the domain. Already the tribunal is in Sizin. That's the domain of this tribunal. Under 226, if you want alternative remedy is there, you have approached the court. Now you want the High Court to override that.
Lordship, already in respect of the FIR which they have lost, a charge sheet has already been filed by
It's
the.
different totally. Yes, Mr. You are in this matter.
Yes, madam.
You have approached the tribunal already.
I have approached the tribunal.
And you are not participating in the proceedings.
Lordship, the question that I will participate.
So they get the order from them directing it to be disposed of. Your all remedies are over there. If you want to enter the residence,
And at this
cancel the
name-
gift deed, everything is under the act. Acha, petitioner
Lordship,
complaint.
kindly also direct the tribunal to consider everything, every player.
You are not appearing actually.
I
This
will
is-
appear.
Acha, petitioner has approached the court claiming that she has been thrown away from her residence and was physically assaulted by the private respondents to the ad effect. State has submitted a report. Report reflects that.
Lordship, another aspect, charge sheet has already been submitted. That means police has also found something.
I'm not saying that.
So
This is
kindly
nothing.
record that.
So, Kulam, which reflects the ad Boranagar case number 374/24, dated 12/9/2024, was registered for investigation under the relevant provisions of the Indian Penal Code. Subsequently, on completion of investigation, charge sheet has been submitted before the jurisdictional court. It is also reflected that there is a GD entry GD entry number 877 dated 12th of December 2024, and the petitioner has also approached the maintenance tribunal under the relevant provisions of the Maintenance and Welfare of Parents and Senior Citizens Act 2007. Full stop. There are certain prayers already advanced in respect of the claim of maintenance, issue relating to the property and transfer of the property concerned, and the said application apparently seems was filed on 5th of February 2025. However, the outcome or the day-to-day regular proceedings are not reflected in the writ petition. Learned
So we
advocate,
have also, we don't know, let them.
you can come to High Court, you can't go over there. This is believable.
Let them intimate us.
Why
it is
will
not fixed.
why will I intimate your lord?
How can state do that?
It's the duty of the.
No, he
carriage
of proceeding upon him. He has initiated. He should.
I
be-
have how can I? This is a proceeding I have initiated before the concerned officer. They will fix the date for the hearing.
Who? The state will fix the date. The officer will fix the date.
Officer.
So that's a
So he's telling that no date has been fixed.
How come if you go to a court of law, court intimates that? Magistrate intimates.
Date is
You have been issued a show cause. Go over there. That
Appear
much
on a show
information
cause
you
date.
must be having. You have been show cause for not appearing.
That is, there is no instruction to that effect, my lord.
So how can that's your and your client's problem, sir?
I don't know.
So I don't know doesn't mean that you.
That was not served upon me, lord. So otherwise I should have
Wait,
revealed it before this court.
Acha. Learned advocate for the private respondent and submit aids. They have appeared in connection with the criminal case which is pending, have been granted bail, and has been adhering to the
Lordship, another thing, lordship, this one prayer.
the learned
I am
magistrate.
presently staying with my daughters at Howrah. Kindly, I am furnishing the address to them. Kindly direct them to serve every notice to my that address, because since I am staying there.
Who are they to do that? That's the statutory authority.
The statutory authority will do that.
No, the statutory authority, you go approach that. If you have furnished an address, which address you have furnished in the form, and you want to change it, High Court will change it.
Presently, I was not.
So you inform that particular authority.
I will do that. Kindly, kindly.
Whatever you do that, sir. Petitioner complaint also submit is that he is not aware regarding the proceedings. Be that as it may, petitioner would approach the maintenance tribunal on the next date. Learned aid officer would pass necessary directions by adhering to the provisions of the law under the Maintenance and Welfare of Parents and Senior Citizens Act 2007 at the earliest. What is your age?
My lord, my age is 77 years.
Acha, the concerned tribunal will keep in mind that the petitioner is about 77 years old, and as such, the remedies sought for, if any, in the ambit of the law be considered as expeditiously as possible by the concerned tribunal. Chalo. With the aforesaid observations, WPA 9661 of 2025 is disposed of. Reports are submitted. Be kept with the records. Server copies. Chalo.
One observation to the effect the police will also provide the assistance if necessary.
No
After
complaint,
that,
nothing.
tribunal
undated
passes order.
complaint.
There is a complaint.
Undated.
My lord, this is, Lordship, kindly see one thing. That there is a complaint. This submission has been made. There is no complaint. My lord, kindly direct them that if I go and approach, they will provide the assistance.
You have approached. Had you not approached, I would have considered that.
I have approached them. I have approached the police.
You have approached the tribunal. Tribunal is insisting of the matter.
My lord, so far the protection is concerned, I have approached the High Court.
Protection, you are staying somewhere else in Howrah, not at Boronapur.
That's why I have kindly, if I
No, sir,
approach them,
no,
they will
don't
provide.
mix up all the forums, sir. Please don't do that. Yes.
Otherwise, Lordship, this will.
These are not the area where I should interfere. Chalo, so next.
My lord, only one vigil will not create any.
At Howrah.
So, for this Barrackpur commission,
Complaint, house of nothing, undated, no plead in your lordship. I've already pointed out.
these are the strategy. Please don't follow this strategy, Mr.
Come. Next.
Don't do this.
I'm for the
Don't
petitioner.
make all these submissions here.
My lord, I am for the petitioner. My lord, the petitioner is the owner of 65 decibels of land, my lord. The petitioner, my lord, petitioner has purchased.
What are you wanting? জমি purchase করেছে আমি কি করব?
Adequate spending.
What are you wanting?
My lord, 151 order is there, my lord. The order has not been followed by the, my lord,
ওইটাই করবে আর কি করবে এত হাইকোর্ট
my lord,
কেস
I am 58 years age of aged person, my lord, the my lord, constantly threatened and my lord,
Respect of injunction order, there should be no steps to be taken by both the parties. That has been intimated by the police authorities. That is a principal order, 14th January 2025. That is the second page. Now, their subsequent, they have taken police help. That order has been annexed. But can you see the communications? There is no hearsay of the order.
So what happened to you after the injunction? Nature character changed.
my lord, the nature and character, there are some food bearing trees, my lord, that trees have not been taken care by, they are obstructed, my lord, to taken care by the food bearing.
এটা কাজ হলো?
Lord, I am disputing such and
Petitioner is aggrieved by the fact that in spite of the directions passed in TS 25/2023 by the learned civil judge, junior division, first court, Jongipur, Murshidabad, on incomplete order দিয়ে দিয়েছে এই হচ্ছে মুশকিল।
Lord, the 151 order is on page 33.
তো ফার্স্টে হ্যাঁ কি বললাম? In TS বললাম, in TS 25/2023, wherein the learned court was pleased to direct status quo to be maintained in respect of nature, character, and possession of the suit property, and the subsequent direction on 3/4/2025 by the same court by the officer in charge of Raghunathganj Police Station. No steps have been taken by the police authorities. Petitioner complains that his fruit-bearing trees are being they are not being taken care of or destroyed.
Lord, they are destroyed some food bearing trees and
পুরো একদম ঘরেলু ঝামেলা নিয়ে চলে এসছে না? কি বললাম? Is being attempted to be destroyed, and the petitioner is also being prevented from taking care of the said trees. Full stop. Learned advocate for the respondent number Respondent number 6 disputes and denies the accusations so made. The report which has been submitted reflects that proceedings have been drawn up under section 126, 135 of the BNSS for preventing any untoward situation, and information regarding the order dated 14/1/2025 has been brought to the notice of both the parties. Having considered the present state of relationship between the parties, police authorities are directed to continue the surveillance and ensure that no untoward incident results because of the strained relationship. We therefore say 8 observations. WPA 9664 of 2025 is disposed of. The reports are submitted, be kept with the record. A copy of the report be handed over to both the parties. Chalo.
This matter I am led by Mr. Vimal Kumar Sai for the state respondent.
My lord, I am appearing on behalf of the statement.
No petitioner. None appear as for the petitioner.
My lord, please come to the paragraph of the
paragraph দেখে কি করব petitioner আসেনি
whatever he is asking, I have fulfilled the petitioner demand, my lord.
You are for the respondent.
Question number 4 to 6.
I have learned advocate 8 for the petition. None appears for the petitioner. Learned advocate 8 for the state, as well as the respondent number 6.
4 to 6.
4 to 6 is present in view of the aforesaid. Lists the petition in the monthly of July 2025 under the same heading. Chalo next.
Deeply obliged, my lord.
Lordship, I am led by Mr. Dipanjan Chatterjee praying for not.
An accommodation has been সবাই একই কথা বলবে petitioner. An accommodation has been paid for on behalf of the petitioner.
Usual practice.
Learned advocate for the state is present. Lists the petition under the same heading in the monthly of July 2025 under the same heading. ফাইল করে রেখে দেবে হাইকোর্টে আর কি সই হতে গেছে Just wait, it has gone for signature. Just wait. I'll call again. ওটা বার করো সই হয়ে চলে এসছে হবে হ্যাঁ বার করো
142.
Yes. একটু পরে রাখবে একটু পরে রাখবে
This is the matter.
Just sir 1 minute, nobody is appearing. কোথায়
42.
I am for the petitioner.
Ready? Yes.
So the petitioner, young man, dreamt of a higher lucrative service on the basis of advertisement quoted by Asia.com. He applied to the same, then he was said that you have been selected by the Deloitte, which is the office at Calcutta, and also in America.
Where is your complaint, sir?
Complaint at
Page?
158. Page 72.
Yes.
First I went to Calcutta, then thereafter I went to Cyber Cell Lal Bazar. Page 72. Then my lord, can you see next Lal Bazar? Calcutta told me that you go to Lal Bazar. Then I went to Lal Bazar. Can you see my lord, Lal Bazar? I went to the Lal Bazar.
So they have registered a case.
Page 76.
75.
Lal Bazar recorded.
Huh.
And I have given the names in the particular my FIR, which was treated as FIR, the names of the persons to whom I paid, account number, everything. Page 76, capital A.
Thereafter?
Then my lord, Lal Bazar recorded Page 78, the synopsis of the case. This is a fraud in respect of 26 lakhs 50,000 for the purpose of service. Deloitte, as an office in Solving, they are in collision with this particular income through this Indeed Asia. This is a particular scam is there. Then Lalwada said the case has been started, page 78. Subsequently, my lord, when I started visiting Lalbazar for the purpose of progress of my case, the people of Lalbazar said that they don't approach us. We'll do our thing in our own way. Subsequently, I received an intimation from Taltola that we have recovered only 42,000. I do not know, and also Taltola say that you go to the Shialda court and get the order, such and such, all these things I have stated. Now, my lord, now my submission before his lordship. Lal Bazar did not take any steps till today. The Commissioner of Police has closed the case. And moreover, from whom, where from this particular 42,000 and odd has been recovered by the Lal Bazar, no intimation was given to me, no assistance was taken from me. I do not know from whom they got this particular information and want to give me back 42,000 and all. As Sarmalo, there is a serious scam between Lal Bazar and the Deloitte company, which is situated in Calcutta and having office at America. Now, Deloitte and another person saying that you will get the job at USA at Assistant Vice President of particular scheme, particular project. By this process, my lord, I have given the details of payment. Every payment, or payments made by the account paycheck, payments were made by the ATM with a particular person and the account number. And then payment was made by MobiWik. Payments were made by the ATMs from Axis Bank, ICICI Bank, and all these reputed banks. Still, Narmada said, and I can't.
No, your investigation is going on, so
Everything is closed.
your investigation is going on. Who says close?
No, I do not know how
Yes, his investigation is going on.
I have not been told why the investigation is going on. On the other hand, Taltola said, can't you see?
No, Taltola is immaterial. Investigation is in
Paragraph 37.
investigation is in full swing. See,
Taltola said, you take back 42,000.
that is a different aspect. That is taking back, but the investigation is going on still. They have been able.
There is no evidence because I have
Investigation, you cannot have evidence.
I have been told that you don't approach the Lal Bazar. Will Lal Bazar.
Cyber, what will you
taking
do?
any assistance from me.
What assistance? What assistance you will be able to give? Acha, tell me one thing. Third page of your report. To submit a progress report. See the bottom page. Bottom of the page.
Last paragraph, man.
All right. Do it. Come after the vacations. Keeping this matter pending for progress report. They are about to get an answer, sir. They are about to get an answer. They are about to. They have already squared down. Some working is going on. Case is in investigation stage, not closed.
Yes. Investigation, my lord, is a very, with regard to this particular crime,
Very difficult.
investigation is very shaky one.
Because people were not ready. Prior to that, the banks have become all computerized.
So bank and all these things and names of the persons
to whom they received
Are
money
they
from
they
me.
don't sit in one place, sir.
Till today, Lal Bazar
Fro-
is not doing anything.
Fraudsters don't sit at one place. They are being traced. Their movement are being traced. চলে আসুন। Petitioner is aggrieved by the progress of the investigation and has approached this court. State has submitted a report. A part of the report reflects that certain persons are being kept under surveillance, and the police authority would uh, take steps uh, within close proximity of time. Full stop. In view of the aforesaid, further progress report be submitted by the state committee. Release the writ petition under heading 4 orders in the month list of June. 1 month time I am giving to them.
Grateful, man.
দাঁড়ানো এটা শেষ করে নিই তারপর ডাকবো এই পাতাটা শেষ করো একটু
I'm for the private respondent.
Time period.
Yeah, I'm hearing for the state respondent.
I'm for the private.
I was the professor. At present, I am residing alone. In the year of November 2024, I made one sale deed in favor of the private respondent number 4. As on date, the original Aadhaar card and PAN card are in the custody of private respondent, and police is taking no steps. I have intimated the police. Kindly see my annexure. I am unable to walk. I have been the wheelchair. Very much.
no your complaint is for recovery of 30 lakhs.
45 lakhs I have got from the
45.
private respondent.
They have given their bank account statement at page 33.
Today's 13, we have registered a case on 9th May, Your Lordship.
9th
Just 5
May.
days back, Your Lordship. 4 days back, Your Lordship.
The case has been registered. Trace out দেখি কি আছে
The only thing, my lord, they have themselves disclosed a bank account statement which states that those 30 lakhs have been given to somebody else, not to
Last
me.
paragraph, Lordship, at page 2. Next
petition was added to a complaint that out of the amount of money used.
They have asked for a post-mortem report. I do not know. Let's see.
Copy paste করে দেন
They have met the Tamtam police station, but actually it falls
নাগেরবাজার পুলিশ স্টেশন
First of all, my lord, I am saying that my original Aadhaar card and PAN card may be
that in connection with that case you inform the police authorities case has been registered. You understand case has just been registered. So the petitioner approached the court as no action was taken on the information furnished to Tamdam police station on or about 17th of April 2025. State has submitted a report wherein it reflects that the jurisdiction would fall within the domain of Nagarbajar police station. Accordingly, Nagarbajar PS case number 93/25 dated 9/5/2025 has been registered for investigation. Petitioner intends to have return of certain documents. Petitioner would approach the investigating officer of the case for tracing out or recovery of the same along with the subject matter relating to the financial dispute. Full stop. Learned advocate for the respondent number.
Private respondents, my 4 and 5, my lord.
Private respondent number 4 and 5 submits that no case has been made out. However, wherever the informations were furnished regarding the bank account, the same has been deposited in the same, and there is no question of DCV in the petitioner, be that as it may. Since the criminal case has already started, and investigation of the case is under progress, the respondents would be at liberty to take steps in accordance with law. Police authority is next paragraph. Single line. Police authorities would take steps and take the investigation of the case to its logical conclusion. With the forces of the WPA 9692 of 2025.
Firstly, there is no case made out in the complaint.
কেসই হয়নি তারপর আবার কি করে জানবে সেট করবে তো উঠতে হবে in court you have come to know case has been registered না চলো no. Next. Is it there?
Private respondent.
I am for the private respondent.
Private
Not before the vacations anymore. After vacation you come.
My lord, one of the respondent has also died, my lord.
Huh?
Respondent number 8 also died before filing of the writ petition.
No, sir, then you should not have filed. Sir, I will tweet different councillors at different platforms. You tell me. No kindness. That's a favor, not a kindness, sir. Other councils are getting same order. You expect a special order. Then I have got to do it to all the lawyers concerned. Petitioner prays for an accommodation on behalf of the learned senior advocate, 8 representing the petitioner, learned advocate for the state. Who is state? Your state?
For the private respondent 7. Private respondent number 7.
Respondent number 7, 9. And the respondent number 9 is present. List the writ petition in the monthly. So July
respondent number 8 has died, my lord, before filing of the writ.
Afterwards, sir. Let them keep their submission silent. July, same heading. Yes. State.
State. I am for the Kolkata Municipal Corporation.
Who is for the state? Mr. Basu?
My learned.
Yes, what happened?
রিপোর্টটা কোথায়?
Now thereafter the specific case was started against my wife. And the petitioner was married to the respondent number 8 first. Thereafter the respondent number 8 left my residence, started living with somebody else. But there are with the petitioner, a son was born about the now thereafter, when the wife abandoned me, he started with somebody else. There a son was born to that then also. Now thereafter, she filed a 125 application claiming maintenance wherein she used a fake birth certificate against me. Child. Now, once that came to my notice, I applied to Kolkata Municipal Corporation. Kolkata Municipal Corporation reported that the birth certificate name of the so-called second son is fake. Now thereafter, I wanted to file an application filed. The FIR was there. The charge was filed. I have filed a Nara for my prayer. Currently, accused persons are considered accused FIR against my wife. Now what I was saying. Wife could not have manufactured that birth certificate without the assistance of the KMC officials. Now, none of the KMC officials have been included in the FIR. Because FIR is at page.
So that's FIR. Charge sheet in the charge sheet?
No, charge sheet also against the wife.
Who is for the state? You?
My lord, I am for the state respondents.
Yes.
My lord, a petition has been filed before the learned court below. Learned court below passed directions for registration of FIR. My lord, certain persons have been, allegations have been met. So, my lord, it is the specific observation by the learned court below that substantial material is there against the wife, but against the others, there is no substantial ground for registration of FIR. That is the order passed by the learned court below. Now, my lord, be that as it may, my lord, the FIR was registered under section 420, read with 406, charge sheet has been submitted. Against that, my lord, on the self-same cause of action, my lord, Naraji petition is pending before the learned
How
court below.
420 with a forged document? I don't understand.
My lord,
if a document is forged, that is 420.
420 and 406 the FIR has been registered. But be that as it may, charge sheet has been filed against that. They have filed Naraji petition. The learned court below is in scene of the matter.
Charge sheet is under which sections?
My lord, charge sheet is under 420, 406. My lord,
Forgery
my lord, kindly 420, 467. My lord. That is the charge sheet. My lord.
This is Shialda Court.
My lord, the ACJM Bidhan Nagar, Shialda. My lord, it's ACJM Bidhan Nagar, not Shialda.
There was a maintenance case at Shialda Court earlier. Carry on, Mr. Rai. One thing is this: the involvement of the officers would come provided the KMC machinery was used. Is it that the KMC, so far as the signature in the seal in the certificate is concerned, that is original?
Lordship, the main certificate, but what we heard, your Lordship, the complaint has none of the complaints has been relating to any of the official of the Kolkata Municipal Corporation, your Lordship. So
May not be. But the thing is that what is the degree of forgery? One is that one herself or himself can prepare a forged document. That is one part. Another is that on the basis of forged fake information, a document is prepared.
Lordship, this document is not incorporated in a register itself.
If
my Lord pleases, I can file a report, your Lordship.
My lord, kindly seize the.
That is the only thing I wanted to know. How is the complicity of the officers coming over here if the same is not available with the KMC records? The KMC records must have something. If it is a manufactured document, somebody has supplied misinformation. On the basis of that, a document is prepared. The seal of the KMC is original, but on the basis of fake documents, it is prepared. I understand KMC officers somewhere, somebody is involved. But if the document anywhere is not available in the KMC itself, how can a KMC officer be involved like this? All right, when is your date fixed before the trial court? Right, I'm telling him to dispose of your further investigation prayer within 1 month from the next date so fixed. Petitioner has approached the AS court being aggrieved of the outcome of the investigation relating to Bidhannagar South PS case number 311 oblique 2024 dated 8/12/2024. Full stop. Petition has already preferred an application under section 173(8) CRPC. The main grievance of the petitioner is with regard to complicity of the officers of the Kolkata Municipal Corporation as the investigating agency on conclusion of investigation did not implicate the AM in the case. Be that as it may, if the materials do or do not support the findings, the learned magistrate will consider the issue as the prayer for further investigation is still pending. full stop. Let the ACJM Bidhannagar, who is
My lord, ACJM Bidhannagar.
the learned ACJM Bidhannagar would,
Naraji diyeche to.
in the circumstances, try to conclude the hearing and dispose of the application under section 173(8) CRPC within a month from the next date so fixed. With the aforesaid 8 observations, WPA 9755 of 2025 is disposed of. Reports are submitted. Be kept with the reports are submitted by the state. Be kept with the record. Server copies. Fine.
Right.
My lord, I am appearing for the petitioner in this present petition. The petitioner is a 23-year-old student who was arrested in connection with a social media post made in response to a tragic and widely publicized incident of Arjikal. My lord, the petitioner liberty has been curtailed on the basis of emotional driven post,
Which was the same.
which was not made.
You are with him.
No, my lord. In this matter, I am not with him. My lord.
You are in the.
Without any criminal intent, she has suffered several consequences. She is not academically.
Carry on. Carry on. Yes, carry on.
My lord, she missed her CAT exam and been and unable to pursue her higher. My lord, she is not only academically affected, but she missed her CAT exam and been unable to pursue her higher education. But she is now professionally suffering irreparably as her name is associated with the pending criminal case. As a result, she is been outrightly rejected by reputed company despite having a scholar and a merited student. Her career stand effectively destroyed, my lord, or because of one emotional post.
I don't understand. কি করেছি এটা? What are you wanting before this court? Yes, madam, what are you wanting?
My lord, I request to quash the petition.
My lord, if I may intervene, my lord, I'm also appearing for the petition.
Your 5 counsels can't appear at a time. Yes, what is the stage of the case? You have registered the case in the year in August 2024.
Yes.
Today we are on May 2025 report. You have done nothing.
Main grievance of the petitioner, my lord, that before he started the case, my lord, no notice was served. But it
No
is not
notice.
required at
Where
all.
from are you saying that they have prayed for quashing of the FIR?
Prayer, can you see, my lord, prayer, my lord, ensure compliance with procedural safeguards under section such and such.
Next page. See.
It in nature of issue of for quashing the FIR.
So what is the stage of the investigation?
But actually,
9 months have passed.
Yes.
Now ask him to appear. Not today. Ask him to
Yes,
appear. Who is
it would be better, my lord.
না সুবিন নাও তাতে নট টুডে দেখে দাও কালকে দেবে ফেরত দিয়ে দাও যা ফেরত যা যা নিয়েছে ফেরত দিয়ে দাও ফেরত yes
petitioner for your lordship is a mother and husband, my lord, has.
No, this is a fight between the father and the son.
May I submit? Has gifted a property in the year 2023.
And he wants to take back that
Let me
property.
speak. Whenever I appear, you usually start beforehand the petition.
There is nothing.
Now, always I have seen. Now, my lord, what had happened? The mother has gifted as part of the property. Subsequently, she realized that entire property has been gifted. Now, when she raised objection, now, my lord, she has been ousted. Your lordship, kindly come to just page 36. Now, they have been forced to reside in a
cow shelter house where dogs are usually residing. And this is the situation, my lord. Time and again I have filed GD. I have informed that I have sold part of the property, not gifted the part of the property, but entire property has been written off.
Kindly see his
Kindly see
complaint.
the paragraph, page 36, paragraph 6. বর্তমানে আমার ঘর থেকে বার করে দিয়ে খাটালের কাছে একটি ছোট ঘরে কুকুরের সাথে একই সঙ্গে বসবাস করি।
তো lawyers drafting.
My lord, kindly see the GDs prior to that.
দেখি আর কতগুলো কুকুরের আগে আছে দেখি।
5 GDs are there.
So where are the contents?
Page 20.
Where are the contents? Show me. Contents of the GDs.
The contents of the GD oral whenever again or oral it was reported.
আমি আমার সঙ্গে
There must have been some reports, my lord. All GDs have.
Yes, report has already with me, my lord. Not only thing, my lord, I could not collect, but report is with me, my lord. Kindly see.
কি আছে এগুলো রাখাও যাবে না রেকর্ড
Nothing.
কাম টুমরো
My lord.
মানে কি বা হার্ড কপি রেকর্ডে তো রাখতে হবে আমাকে
And recorded. May I give it after completion of
কাম টুমরো আই এগেইন কল দ্য ম্যাটার আর কি আছে এই প্রিন্ট আউট না থাকলে অ্যাপিল কোর্টে কি করে ডিসাইড হবে ম্যাটার
Tomorrow, man.
48.
The land loser should be dispute eliminated with exemplary cause.
Yes, after my submission.
Yes.
The petitioners are the land owners, that their land has been used for the purpose of setting up the industrial park in the district of Paschim Medinipur. What happened, my lord? There was understanding before the my lord taking the land of the petitioner that they will be provided with an employment. And for that reason, my lord, state was approached, state was initiative, my lord. Save and accept the two my lord, units, that is Grasim Industries and Indian Oil Corporation. If all the units have my lord, provided employment to others.
So what will police do?
No, we want to see the
Paragraph 11 and 12, kindly read. Kindly read 11 and 12.
Sit on hunger strike. That is our prayer, my lord. My lord, we have, my lord, in advance, we have informed them what happened, my lord. 2 days before the my lord, proposed date of strike, my lord, they returned us, my lord, my lord, illegally, and they took us to PS, my lord, and thereafter they, my lord, released us without, my lord, recording anything, my lord. That is the petitioner number 2, 3, 2 and 4 was unlawfully detained, my lord. I have stated in my at paragraph 23, my lord. Paragraph 24. 23, my lord.
So what support you have got?
Paragraph 11 and 12, kindly read.
They did not issue any paper, my lord. Without producing any paper, they detained us. And thereafter,
Sir, see, come to your prayers.
yes, my lord.
Lord, kindly read Lord, paragraph 11 and 12. I am drawing your lordship's attention. A matter of 2008, land acquired. Now in 2025.
25 we are praying for sitting on strike, my lord.
Are you tell me what will police do?
Yes.
Police will not, my lord, disturb us by we shall sit on strike, my lord. It is our right, my lord, to sit on strike.
So go.
No, law and
How
order
can I give a blanket order?
Yes.
I am saying, my lord, I shall opt that all the.
On and from 7th April. And today is on and from 7th April. Yes. They have stated.
Where is your representation to the police authorities?
At page, my lord, 63. 69, my lord, kindly see.
Yes.
That is
District magistrate.
Concerned police station.
69.
Dated 24th March 2025. This is to inform you that there are about 26 numbers of
7
69 page
7 that is the 7th April 2000.
Yes.
What I am saying, my lord, earlier occasion when we proposed to sit on hunger strike, they prevented us. What we are saying, my lord, before lordship.
On this I cannot do so.
Lordship's condition.
So I am over here an administrative authority.
They cannot prevent us.
Blood,
They want to sit on hunger strike.
So you go and sit. Whatever you do is your right.
Disturbing us. They are
But
not allowing us.
2008, land was taken, acquired, LA case. And
No, I am not
Who
here
are
to
they?
receive
and this court will decide.
petition.
This court will decide.
That court will decide 7th of April to. You are unnecessarily coming to a court of law, sir.
Yes, yes.
Administrative.
Sir, kindly, blood is wastage of court's time. It should be dismissed in limine with cause.
in the month of April, we propose to sit on hunger strike.
Ah.
This is not allowed. For that reason, we have come to your lordship.
That I will give you a protective cover to do
Yes,
whatever
yes.
you like.
Whatever grievance they have to agitate before the appropriate authority. Yes, yes.
Sir, after
That is
7th,
why.
after 7th of April, have you
What we
informed
have
your
learned-
consequences to any authorities? Where, whom? Where is that? Where is there?
That is oral.
Oral.
Oral
Arey,
approach.
oral could be reduced into writing and informed to the authorities concerned.
That I have averred in the petition. That we
Petition. That is what I am saying. I am not the authority.
23 and 20 paragraph 23.
Lord, Lordship, kindly pass the order. Lord.
Our conduct, my lord, we approach the authority, then we
Petitioner ends to
and my lord, on a previous occasion,
sit on a hunger strike.
so the petitioner to sit on my lord strike and also hold rally, my lord.
And a straight jacket formula. Then it would be a straight jacket formula. Everybody.
I have allowed also. I have rejected also. Ask
Yes, my lord.
ask him whether I have not
Yes,
rejected.
yes. That.
Sir, you complete whole of the paraphernalia.
I have completed my lord.
That is your understanding, sir. I am telling you complete whole of the process.
Yes.
They refuse. You come to this court.
My lord.
Sir, they are not refusing, they are not allowing. That is the difficulty. Instead, we can come up before your lordship. They are not allowing us. That is the difficulty.
ये मुश्किल है cause of action. Petitioner কি বললো?
How the court will decide? The rank
The
trespasser
dates which
or
have
the land
the
loser?
dates which have been proposed in the petition have already expired. Learned advocate for the state opposes and submits that the petition is not maintainable. Full stop. Petitioner is granted liberty to approach this court in case the administration refuses by way of a written communication or for an unreasonable period of time do not communicate to the representation of the petitioner. Chalo. With the aforesaid observations, WPA 9765
Lordship, kindly will record my submissions also that it is not maintainable. And my lord, the allegations made against the police, my lord, since I have not used the affidavit.
And needless to state, needless to state, since the affidavits are in use, the accusations made in the read petitions are deemed not to have been admitted.
I'm deeply obliged to your lordship.
141. Passover matter 141.
149 never.
Just one Passover matter.
I'm for the state, my lord. I'm led by Mr. V.K. Shai, my lord.
Where is he? Yes, have you got the case diary?
Yes, my lord.
Passover matter.
Is the report WC?
My lord, he is appearing online, my lord. My
Yes,
senior.
where is the report? Oh, Janvi, report of the IO is there.
I was there.
Report of CWC, which page? This page is not matched.
I was there, my lord.
Huh?
IO is there, my lord.
So you have said over here. Din. You see page 53, second last in the serial number. You have said there is a CWC report. Where is the CWC report?
CWC report my lord, in page number 52, there is CWC report.
Then that in the code.
Mute kora.
Madam, the medical reports are overwhelming. There's been no offense. Difficulty is that CWC is advising the investigating officer. There is a report. That's what I have checked. CWC is asking not to get the statement recorded because the victim is traumatized now.
Lordship, if I may submit, Lordship, past 1 week back, I visited the victim personally. She is very scared and she has stated in front of her mother that my father is not related to this offense. I want to get back to you. She is not comfortable. She is being brainwashed by the officers of their
My lord,
home.
I
She wants
object.
to.
My lord, please come to the page number 2 of my report, my lord.
You are appearing before the special court. Who is appearing before the special court? Special court, there must be a lawyer on behalf of the victim. Who is appearing?
Yes.
You make your application because right now, overriding, you have your personal experience that I cannot now interfere. But it's categorically written over here in the report. That is what I intended to check, whether it was a garb or it's this has been signed by the counselor of the home concerned where the child is residing. And it has been categorically stated regarding this, not to disturb the child regarding the incident. She is still traumatized and shaken. It's almost 25 few days after.
My lord, may I allow to submit, my lord?
Yes.
My lord, please come to the page number 2 of my report.
2.
Page number 2, paragraph number 3, my lord.
Yes.
Last 5 line of paragraph 3. As per patient, she has allegedly stated in front of her mother, lady police personnel, lady nurse, lady doctor, that this incident has been done by her father. Now patient is being transferred to the government hospital for further investigation and treatment as per the government protocol and format. And right now petitioner is trying to save the victim, no victim, accused person, my lord. That's why she approached, petitioner approached before your lordship.
Good. Mr. Shai, one day or the other, You have got to get the statement recorded.
My lord, I agreed.
So this particular report was prepared by the CWC on 25th of April.
My lord.
So that is 5 and today we are on 13th.
13th May.
So almost 18 days have passed since then. I'm not from the date of incident. I'm not saying. So you get a second.
My lord, keep it in next week. In the meantime, I will record the statement before the competent
Answer
court.
of the investigation, the truth will come out, Lordship. As because 161, the police have halted the investigation process itself. 161 are not being recorded. Almost 50 to 100 witnesses are there, Lordship. Who
So witness
and
medical report is sufficient.
And all witnesses are lying.
Lordship, because test identification parade in this kind of offense, the girl is very little. She is literally scared. She wants to come back to her mother, and she have already stated in front of her mother that the mother is stating me through affidavit also. If your lordship may permit, I will draw through affidavit also that father have not done this. Father have recovered the child.
But tell me, where is she now? In a home?
Lordship, she is now in home, Lilua home.
Why is she in a home?
Child and welfare home, my lord.
The mother is not taking. Why have you kept that? Father is in custody.
Yes, father is in custody.
Why have you kept her in a home? That's why I'm asking. What is the age?
6-year-old, my lord.
Why have you kept her in a home? I'm asking you. She's a victim. She's not an accused. The child is a victim. Why have you kept her in a home? There must be some reason. Why have you kept her in a home?
Right now, she is in trauma, my lord. That's why she is in child and welfare home, my lord.
No, but then the mother is there. Why are you taking her away from the mother? That is what I want to understand.
Right now, mother is trying to save the accused person, my lord. Father of the victim.
No, Lordship, completely deny.
Who lodged the complaint? Complaint was lodged by whom?
Complaint was lodged by the mother, Lordship, mother of the child, who is the petitioner in this writ petition.
Sakina Devi, mother.
Of my writ petition will substantiate, Lordship, that the mother have authorized.
First page of the case study, my lord.
Where from the name of the transpired?
Name of the accused.
Medical officer Narayani.
FIR এর নাম
কথা।
এখানে না? এটা আমার page number of my report, my lord.
Report a case diary.
Report, my lord. কোথায় বলে নামটা কোথায়? নামটা কোথায়? নামটা তো দেয়া নেই। নাম জানতে চাইছি।
Have you recorded the statement of this doctor?
Record
statement has not been recorded, my lord.
of this doctor?
Doctor, yes, my lord. Doctor এটা করেছেন। Doctor এটা কোনটা দেখো? Case diary থেকে।
What is the name of this doctor?
এটা না? Page number 7 of CDR, my lord.
Dr. Mohammad Mohsin Rehan. Who has recorded this? Page 7.
কে কে রেকর্ড করেছে? কে রেকর্ড করেছে এটা?
ইনি করেছেন
রেকর্ড কে করেছেন?
উল্টো পিঠে সাইন আছে
দেখুন।
Dr. Mohammad Mohsin Rehan.
ডক্টর
My lord, Dr. Asif Mohammed, medical officer.
Where is the statement of Asim Mohammed?
My lord, page number 8, my lord. 8? 7, my lord. Page number 8 of the
Seven,
report
seven of-
and 7 of the CDR, my lord.
My lord, page number 7, page number 8, page number 9, page number 10.
Who took her to Narayana? Narayana is a private hospital.
My lord.
Huh?
He need-
Who took the victim to Narayana?
um, he needs you. Her mother, her mother, lady police, lady constables were there.
There is cost involved over here. Then why, if you see over here, this you have taken at 147 to Narayana Hospital. Then why did you take her to the government hospital at 3 p.m.?
My lord, now the patient is being transferred to the government hospital for further investigation and treatment, my lord. For better treatment, she has been transferred to the government hospital and
So finally the treatment was to be given by the government, or why did you take to Narayana?
My lord, initial stage she was taken to the Narayana. That was very close to the.
Patients to Narayana.
No, my lord, there is a Narayana hospital in Havra near to the Sakrai PS, my lord.
let immediate first aid.
Very close. That's why they went there, and thereafter they went to the Havra district hospital, my lord.
Have you recorded the 164 of the mother?
164 to record করলেন? Not yet.
So how are you going to reconcile the two stands of the mother before Narayana Hospital and before the government hospital. You are building up a case. One, in the letter of complaint, name of the father is not there. Number one. Here also, this is in a third person language. Page 6. There's a statement of the father. It's almost in the nature of a hearsay. Hmm. Here they say who said, in mother, lady police person, lady nurses, lady doctors. They have said. So Asif statement goes. Now here at 3 p.m. when this medical is being prepared, the statement of the mother, see, it's your document only, sir. So why didn't you record the statement of the mother? She's changing her stand. You see over here, your statement is your doctor have written that. It एक तो दिन तो नहीं आया है. Left top left hand left this side this page. Mother in the letter of complaint did not say. Mother before the doctor said this thing. Two statements. Now how are you going to substantiate this?
My lord.
Huh?
My lord, the victim's statements be recorded thereafter, everything will be clear, my lord.
So that is one point. Second is this. Have you
Sorry, my lord.
custody?
Father is in custody, my lord.
Have you got the medical checkup of the father? Any injuries are there?
My lord.
এখান থেকে করেছেন তো কোথায় রয়েছে কোনটা পেজ পেজ নাম্বারটা দেখান
Page number 43, my lord.
my lord page number 43 my lord. কিভাবে কি করা যায় কাজ
Have you collected anything? FSL, have you sent anything? FSL?
FSL আছে না FSL টা কোথায় 67 68 my lord last page of CDR.
Get the statement recorded. Almost 20 days are over.
My lord.
I'm keeping the matter pending. Because 25th of April, 5 plus 13, 18 days are over. Substantial time is over. Record the statement. Let them come back. Because FSL report would be the standing point, nothing more than
Yes, Lordship.
FSL where? Have you sent that? Convent Road?
Belgacia, my lord.
Belgacia. How much time they will take?
কতটুকু সময় লাগবে? Pass on direction, my lord. To that extent, my lord.
22nd, I'm keeping that matter, pursue them. Acha.
Lordship, if the child can be just if the child can get back to her mother.
That it is
Oh,
not.
my lord, I strongly opposite.
You make your prayer before the special court, then make a prayer before me. Make a prayer before the special court and then make before me.
Okay, Lordship.
In the meantime, police authorities will take.
Yes.
Make a prayer.
Yes, I will.
Thereafter, make a supplementary.
Yes, I will.
and pray before.
Yes, I will.
Petitioner is agree action of the police authorities. As produced the case diary, I have produced the case diary. The FSL report is still pending, although the same was sent by the investigating officer on 8th of April 2025 and received by the said office. কবে পেয়েছে? Not written. When did you give it? On 8th?
On 8th April, my lord. FIR date is 8th April, my lord.
8th April?
Yes, my lord.
কি বললাম? Of FSL on the same date. Since more than a month have passed, the FSL is directed Forensic Science Laboratory, Belgacia. The director, who is the director? Who is the director? FSL has got a director.
Director, my
The
lord.
director Forensic Science Laboratory, Belgacia, Kolkata, would at the earliest submit and hand over the reports required in connection with Shakrail PS case number 287 of the 825. List the in the meantime, since more than 17 oblique 18 days have passed, police authorities would check whether the statement of the victim at this stage can be recorded. Full stop. Petitioner would be at liberty also to make applications before the learned special court already insisting of the issue. List the writ petition under the heading to be mentioned. Get the FSL report because that's the only clinching point now.
My lord.
FSL report on 22nd to be mentioned. 22nd of May 2025 under the heading to be mentioned. Case diary be returned to the learned advocate appearing for the state. The investigating officer along with the case diary should be present on the next date.
Deeply obliged, my lord.
About him.
Grateful, my lord.
149. 49 Lord, I appeal for the
My lord, I'm for the respondent number 8, my lord, wife.
এর মামলা কাছে যোগাযোগ কি হলো কি আছে এটা what are you wanting
But of the
So,
the petitioner
ঠিক আছে
bar and the other all the petitioner.
charge sheet submitted
But charge sheet not not yet submitted.
No, my lord.
Investigation progress notified the fee.
2016
Yeah, handed over the fee.
That actually কি বলছে কি yes Mr. Banerjee what happened just started.
Kindly see the report during investigation on 15 January 2025. The IO seized these 3 articles from the complainant's husband, Patto Kundu, and deposited them in Kolani PS, transport PR number 12. Subsequently, 9th March 2020, the IO handed over these articles to Tonima Kundu on execution of Jimana. Notice under section 35 CBNS was issued to the accused Patto Kundu, and on 30th January 2025, he surrendered before the Ranjit Kolani, was granted bail upon furnishing for corporate. It is an immense to various.
Who are who? My lord, I'm for the wife, my lord. Respondent number 8, my lord. My
If
lord,
your lordship kindly see the reputation.
2016 কাউকে বাড়ি থেকে তাড়িয়ে দিলে 498 এ 2025 এ হয়
Only not only that, your lordship kindly see the report. That the quarrel between the husband and wife and fate of the girl, minor girl kindly see. During inquiry, it has come to the light. Second page. That on 2016, the petitioner and his family allegedly forced Tonima Kundu to leave the matrimonial home while the child initially remained with father. In 2017, the minor child was admitted to garden school at Aizer, Kolkata campus, Faringata, following mutual understanding. The petitioner allowed the child to stay with her mother on weekends and later on weekends as well. Between August 2017 and April 2020.
so ask your officer to complete the investigation whichever way is concerned.
It is further revealed. Let's say, kindly see the second paragraph. It is further revealed that due to financial constraint, Tonima Kundu admitted the child to Kolani, Kanso district. The child, now a student of class 6, has since been residing with her mother at blood active petition has been filed by the husband.
it dropped.
For blood the custody of child, but I do not know drop, but no order was passed.
It was dropped, my lord.
No, I understand that they dispute
Investigation going on. Your lordship kindly will
2016 investigation. I mean, there have been some wife and the daughter were, suppose I presume, thrown out of the house in 2016. After 9 years, 498 yes, sir.
That's why I'm looking. So lordship kindly
Keeping this matter pending after.
lordship kindly dispose of we shall
My lord, investigation is still going on, my lord. There was no mutual understanding, my lord. They have not
That is
challenged.
2025 investigation.
My lord,
but we shall file within a month. Your lordship kindly dispose within a month.
বুঝিও না কিভাবে investigation
Nothing is there. Nothing is there. Everything has been done. Our charge sheet will be filed within a month or 1.5 months. Your lordship kindly.
all right, I'm granting after charge sheet come, I'm granting you liberty. Only because investigation is going on, I'm just
Report I have filed.
petitioner being aggrieved. Petitioner and petitioners being aggrieved has approached the AS court.
এটা তো কোনো লিবার্টি দিচ্ছে যে চার্জশিট থাকে ওই আসতে পারে
Useless. আমি পুরোটা আমি জানি 2016 মামলা করে 2025 হয় এই ইনভেস্টিগেশন only the legal parameters are comprised, that's why they are fighting.
Only to compelling petitioner number 1 to give consent on the mutual divorce, all these things has happened.
That is a separate
it
issue,
is not
but
recorded anywhere. That is not recorded anywhere. There was no mutual understanding.
Not the case of the petitioner in the writ petition also.
I petition this court as it is admitted that the wife and the daughter of the petitioner number 1 were allegedly thrown out in the year 2016. Now the case has been registered in under section 498A, 406, 34 and sections 3/4 of the DP Act in the year 2025. Full stop. Mr. The said case was registered on 5th of January 2025. लिखे बोले
15th of January 2020.
just one.
Page 18.
15th of January, no? on 15th of January 2005, no, 15th of January 2025. Having considered that the investigation is in progress, at this stage, I am reluctant to appear, reluctant to interfere. Petitioner would be at liberty to approach the court after if any charge sheet is filed. I don't think others against others charge sheet would be filed. Not necessary. Full stop. Mr. Banerjee submits that the investigation is at the verge of completion. As such, petitioner is granted liberty. খালি করে দেবে। ঠিক আছে, report so submitted, we kept with the record. तो ये accordingly WPA 9768 of 2025 is disposed of.
No.
I cannot keep it because I made an observation.
Report file.
Lordship, I want to offer the petitioner, led by Mr. Umar Kazi. Lordship, the petitioner got brutally attacked and molested on 1st March 2025, and in such a way that the petitioner got serious scalp injury and head injury. After being attacked, the petitioner's brother went to Amta police station and an FIR was lodged, being Amta police station case number 30 of 2025. Lordship, the representation has been in the page number 21. Lordship, kindly see paragraph 7 to paragraph 10.
What are you wanting?
Lordship, the prayer is that the accused person has still not been arrested and they are continuously threatening the petitioner by going to the petitioner house and again and threatening to attack again and threatening the petitioner to withdraw the petition so that the petitioners may escape.
No, charge sheet submitted, my lord. Charge sheet has been submitted on 23rd April 2025, my lord, against all the FIR name accused, and at present the accused are on bail.
Accused are on bail. Petitioner is aggrieved by the progress of Amta PS case number 30/2025, dated 1/3/2025. The principal grievance of the petitioner is that neither the accused persons were arrested nor the police authority have taken steps to trace out them. Additionally, it has been submitted that the accused persons are threatening the petitioner. Full Stop State has submitted a report. Report reflects that charge sheet has been submitted on or about 23/4/2025 before the learned ACJ AM Ulubedia. The report also reflects that accused persons have surrendered and they have obtained bail from the concerned court. Having regard to the prayers so advanced, if the petitioner is aggrieved by the issue relating to bail, she would approach the jurisdictional court under the relevant provisions of law. So far as the issue relating to threats are concerned, petitioner being a witness, if she files an application before the learned ACJM, Ulubedia, what is this? Is ACJM what? ACJM Ulubedia. ACJM Ulubedia. He would conduct an inquiry, thereby calling for a threat perception report from the concerned police station. On receipt of such report, the learned magistrate, if he deems fit and proper, would pass necessary directions under the Witness Protection Scheme 2018. With the aforesaid observations, WPA 9771 of 2025 is disposed of. Reports were submitted. We kept with the records.
Careful. For the state. I beg to appear for the headmaster of the school.
151, my lord, I am appearing for the petition, my lord. Yes, madam, my lord. Allegation against the headmaster, my lord. First, financial irregularities, my lord. Then, defalcation of fund of rupees above 26 lakh, madam. My lord, kindly try to page 41 first. That is the complaint which has been lodged before the local police station, my lord.
Any FIR registered?
Lord, this is an internal infight between the managing committee. Lord, there was the
No,
Lord,
but the
books of
amount-
accounts,
amount-
Lord, then an audit team from the audit team visited the Lord, school to inspect the books of account, Lord. But at that point of time, the private respondent failed to hand over, failed to produce and hand over the books of account to the audit team, my lord. On the basis of that, my lord, the complaint has been lodged by the secretary of the school, alleging that there has been some misappropriation of the funds from the part of the principal, my lord. But unless and until the audit team finds out whether there has been irregularities or not, my lord, that
without documents, how they will find out?
But there is a
Custodian of the books are secretary of the managing committee. My lord, I am the
but
headmaster.
it is an internal fight, my lord.
May I
Please,
Register FIR, everything will be all right.
Madam, may I apprise one thing? Madam, may I apprise one thing, my lord? He's secretary of the school, my lord. He did not allow me to join in the school as the headmaster. I filed the petition. Thereafter, my lord, he allowed. Then, my lord, he went before the appeal court, my lord. He
Very good.
dismissed.
Very
One
good.
after
I am
another
not
litigation,
bothered
my lord.
about that, sir. I am
2022 October, Malat, you are
asking a
appointed.
simple
3
question.
years, Malat.
I'm asking a simple question. Who is having the books of accounts?
The secretary of the managing committee. He is the
You
custodian.
understand the difficulty now?
I got it.
Madam, the
My
DI
lord,
is
ask
the
the officer
appropriate
to come.
authority.
My lord, kindly then direct, my lord, we shall proceed with the case.
Yes. Not registering on a FIR. I am a serviceman of the school. Well, let the DI investigate into the matter.
মানে বড় করব না আমি ছোট আমার ক্রিমিনাল
Let the DI investigate the matter.
35 এ নোটিশ চলে যাবে অসুবিধা এটা 35 এ নোটিশ যাবে চিন্তা করছো কেন
আমি তো I appeared before the police authority.
Last statement by headmaster maintain করে কিছু হ্যান্ড ওভার দেয়
দেখা যাক
20 years he is the secretary of the school. I'm just 3 years I joined as the headmaster of the school. One after another litigation he is filing against.
3 years.
Very good. Last year, books of audit are with whom?
Malat, paragraph 16, kindly see, Malat.
No, I'll see it. Last year, you are 3 years.
3 years.
None of the years you have.
For 2 years, my lord, I have deposited everything. The current year, my lord, I could not deposit the money because the valid managing committee is not there. I repeated occasion approach before the DI kindly look into the matter and the money I have collected from the students that is with me.
করলে মুশকিলে ফাইলে এফিডেভিট
My lord, I sir.
Let them file the affidavit, বাট করে আমি একটা অর্ডার দিয়ে দিলে কার সরকারি কাজ করে
Lord, kindly consider this.
This is a
Registered paper, Malat. Paragraph
is only
my lord, if your lordship comes to page 34, my lord, page 34a, my lord, it will make it very clear, my lord, that this is a notification, my lord. Calcutta, my lord, it was published in the Calcutta Gazette, my lord. My lord, this says with all books, records and registers relating to the school may be open for inspection by the members of the school committee or any person authorized by the education department of the state government.
Yes.
So the books of accounts has to be kept open for inspection.
Yes. And now, who will keep that? Difficulty is that one is managing committee, one is secretary, and one is the headmaster.
Headmaster. So either of the if either of the parties don't keep the books for inspection, my lord, they both of them are at fault, my lord.
Both of them. That is what I am on.
That is what.
Let them file the affidavit, thereafter I'll decide. বাট করে একটা অর্ডার দিয়ে দিলে এক্ষুনি কাজ চাকরি
My lord.
চলে যাবে আমি জানি না।
This is his only intention to lodge FIR against me.
And my lord, the accounts of
Paragraph 16, Malat, kindly read it. Malat.
On
and my lord,
paragraph
after that, my
16,
lord,
Specific allegation, Malat, above 26
It
lakhs.
is
only on allegation, nothing can be done. Bring more documents.
and moreover with regard to the my lord,
As per audit reports, Malat, kindly see, Malat.
bole de.
That report.
But with regard to the accounts, my lord, it will be operated jointly by the secretary and the assistant secretary of the
So
school.
both of them are spilling over each other. This is
Secretary and
all
assistant
schools,
secretary.
all schools. The petitioner alleges that the representation made on 14th April 2025 to the inspector in charge, Bhatpara police station was not acted upon. Learned advocate for the respondent number 5 submits that the books of accounts are in custody of the petitioner. Full stop. State has submitted a report. Reportটা কোথায় গেল বলো তো?
My lord, I have not handed over it.
All right, state has submitted a report report reflects that there is an internal feud between the petitioner and respondent number J আছে, having considered the nature of the accusations, and primarily there are allegations relating to defalcation of funds. Opportunity is granted to the respondent number 5 to file his affidavit in opposition within a period of 4 weeks. Affidavit in reply, if any, be filed within 2 weeks thereafter. Matter be listed under the hearing in the month list of July 2025. No,
not at this stage.
দুজনকে দিতে হবে, ঝামেলা হয়ে যাবে তখন। Report submitted be kept with the record. কি আছে?
July.
My lord, in 152 I am for the petitioner, but for some of my personal reasons I could not service the copy on the respondent.
Alright.
I crave for the fortnight's time to serve.
Done an advocate appearing for the petitioner prays for an
My lord,
accommodation.
I have also one matter listed with you.
As service has not been completed, please the petition month list of July 2025 and at the same meeting next.
153. 153.
Hey, Yes, Mr. Manna, what happened?
What happened is, my lord, kindly come to page.
Police will keep a strict vigil, will suffice.
My lord, come to page 60.
Police will keep a strict vigil.
It's the petitioner is the bona fide
Owner of the land.
Always bona fide.
And not only this, he got the land, my lord, for the decree holder. There is a, my lord, civil court judgment and decree.
Petitioner
names. Kindly look page 60 and then matter pending before the WBLRT. My lord, at the instance of the petitioner, my lord, prayers for
They are coming to
disturbing you.
Prayer for cancellation of patta.
Ingress all right or no?
My lord,
Ingress all right.
Ingress. ঢোকা বেরোনো।
Lordship, the private respondent forcibly come to the land for construction of building. For construction of building materials, my lord, purchased and stock there.
On the
my land, my lord. This is my land, and there is a civil court judgment.
The
and
land
decree.
which is according to the, my lord, according to the report filed by BLRO before the land tribunal they initiated that proceeding and said that it's a vested land, and after that, my lord,
Vested land, my lord, I got the my lord, the judgment and decree. Judgment and decree. But how they
All right.
the
Petitioner is aggrieved by the fact that the private respondents are trying to encroach upon the petitioner's property and thereby raise construction. To that effect, information was issued to the police authorities, but no action has been taken. Petitioner further claims that there has been a decree in his favor from the civil court. Learned Advocate 8 appearing for the stay 8 submits that the proceedings are pending before the
page 57 order is there.
WBLRTT
the only correction of
records.
Record, my lord.
ভালো কথা, having regard to the fact that the civil court as well as the WBLRTT are insisting of the issues.
LRTT will pass this order directing the tribunal to dispose of the pending.
So far as the right title and interest of the property is concerned, the same are to be considered by the tribunal and of the civil court. So as the police authority is concerned, they would ensure that there is no breach of the peace and or tranquility and or any untoward incident resulting from the inimical relationship existing between the parties. By the aforesaid observations, WP 9787 of 2025 is disposed of several copies. Chalo.
The police report down.
Report নেই, কত লিখে দেবো?
May it please your lordship. I beg to appear on behalf of the petitioner.
Yes.
Journalist, my lord, he also has a YouTube channel. He has, my lord, received a notice from Malda under section 35 subsection 3. My lord will find the notice at page 22.
Yes.
There are
The memo of arrest. Arrested.
41 in
Only 41 a notice.
35.3.
Where is that?
Page 22. Annex P2.
22.
Well,
Cause conference. মানবপুর আমি বুঝলাম না এটা কি where is the complaint
well, there is no complaint. I have checked up, my lord. Even now, my lord, it has not been uploaded.
Well, this is the complaint, Lordship. Kindly see my report.
It has not been uploaded, my lord.
report in the report
Page 5 of my report.
In terms of, my lord, youth bars case, my lord, it has not been uploaded. And on the second limb is, my lord, there is a
let me see the
notice.
complaint
What is preventive from appear before the police authority?
আমার একটা কপি দেবে FIR এর?
question নাম দেখিনি তো
Well, one copy of the FIR is unbeatable.
Great.
মানবপুর check করব
এই বুঝলো তো তুই এটা নিয়ে আমার কথা
এটা একটু দেখে নি একটু।
একই আছে এটা আমি একটু দাগ করা আছে
থ্যাংক ইউ।
what are you wanting
I have come, my lord, for quashing of this particular notice. And but since, my lord, there was no FIR, interim order was, my lord, for staying of the notice. And my lord, the primary relief also claimed for, my lord, is quashing of this particular notice, my lord. Prayer B, page 15. And that apart, my lord, there has been a non-compliance in so far as our notification, my lord, the notification of the Honorable High Court at Calcutta is concerned. I have annexed a copy of that also. But that notification mandates, my lord, in terms of the law laid down, my lord, in Ashfaq Alam's case, my lord, that it has to be served 41A within 2 weeks. If not, then an extension, my lord, has to be taken from the superior police officer. Here it has been done, my lord, even beyond a period of 3 weeks. Page 41, my lord, I have annexed it.
25/4 বলেছে কবে আসছে বলেছে
But FIR was registered as per them, my lord, on 4th of April, and they have issued this on the 25th of April.
ঠিকই আছে তো
I received it sometimes on the 28th of April.
you are staying where
But I am staying in Kolkata, my lord, under the jurisdiction of Golf Green Police Station.
meet virtually 35 virtually কি করবে থানায় নিয়ে গিয়ে meet virtually later I will see acha petitioner was served with a notice give the email address and everything police will send you 35/3 through mail accordingly by virtual mode you appear before the police authorities আর এগুলো ফেলে দিকে লাভ নেই কোনো এমনি গেলে বেল পেয়ে যাবে হাজার হাজার পারবে আমার যে কিছু
But not more than once a week, my lord, or twice a week.
যখন বলবে তখন may not be also
Very good.
this is not a condition precedent for the sake of investigation they will serve you notice under section 35 by mail and you attend by way of virtual mode
I'll do. And my lord, kindly, my lord, protects me, my lord, from my lord, saving my right, my lord, to challenge the FIR. Now that I have a copy, my lord, no, right to save.
that you have, sir, always have.
So if my lord, an observation can be
As a
made,
petitioner, observation.
I'll direct the lordship only, my lord, filing a writ petition.
There is a Mohan Singh's case, repeatedly you can come. You understand?
This will not dissuade me, my lord, from pursuing the other remedies available.
Obviously, that is.
If my lord, that observation can be
petitioner with a notice under section 35(3) of the BNSS, petitioner is a resident of which police station? Resident of.
Well, this is I stay under Golf Green Police Station.
Petitioner is a resident of Golf Green Police Station. Petitioner has been served with a notice from সাইবার ক্রাইম পিএস
মালদা
মালদা সাইবার ক্রাইম করছে কেন? এগুলো কাজ নেই নাকি?
মুতাবাড়ি কেস লর্ডশিপ তো
হ্যাঁ, তো that is for different persons. Cyber crime will do different job. Trace out the money. Everybody is complaining. ব্যাংকের টাকাগুলো যেগুলো যাচ্ছে এবার এগুলো করছে ডিজিটাল
I lost my money. Cybercrime did not do anything. I booked my ticket for Kedarnath.
প্রবলেম হয়ে যাচ্ছে। তাই এদেরকে দিয়ে এই কাজ করালে কি করে করবে? আর কি বললাম?
এখন হচ্ছে কেন কোন থেকে আর বসবে এখন থেকে আর বসবে জিজ্ঞেস করুন
In connection with cyber PS case number 09/25 dated 4/4/2025, full stop. In view of the now without going into the reasons so assigned and the nature of the complaint, I am of the view that if the petitioner is required for the sake of investigation, petitioner will be communicated to his available email address, which the petitioner will serve. Will make which the learned advocate for the petitioner will
I'll supply it to Mr. Devroy right away.
will furnish to the learned advocate appearing on behalf of the state. The same be informed to the police station, police officer, investigating officer concerned. Investigating officer by way of mail will send notice under section 35(3) of the BNSS and also fix a time for appearance of the present petitioner in virtual mode. Full stop. Petitioner undertakes that he would make himself available for being interrogated or making himself available within 48 hours of the receipt of the notice in virtual mode. So far as the other issues are concerned, petitioner is at liberty to exhaust the statutory remedies.
Mala report kept on record, Mala. I have also handed
I have also received a copy, Bernard, containing the FIR, which I'll be challenging.
Under the law. With the aforesaid observation, WPA 9801 of 2025 is reports are submitted. We kept with the records, several copies.
And also handed over to him.
Carry a copy of the report here. না একজনই আছে petitioner.
But the other matters, Bernard, which were fixed at 3:30, Bernard, where the learned advocate
Where
general
is
was
he?
to make
Mr. Banerjee is there. Ask them to come. আমি ঘুরে আসি।
155 Milord. Milord 155
fixed matters. There is one matter which will be going long.
Milord, both the parties are there.
Milord, what I was only playing 156. Milord will just I will take 5 minutes.
না 155 এখনো হলো না।
দাঁড়া আমি বলছি Milord, tomorrow there is a
difficulty.
Tomorrow there is a
I am keeping all the matters in the list until and unless.
But what I am only praying, your Lordship will kindly consider this. Tomorrow I am in difficulty, Milord, I will be in Delhi. Milord, kindly then on that event, Milord, fix it on Thursday.
I'm not fixing any matters. These matters will be there in the list.
Otherwise, your Lordship, you are not there.
Not July. You ask your junior to remind me. I will definitely.
Your Lordship will fix it in July then.
Ask your junior to mention the matter. বাকিগুলো কালকে করবো। এই ইডি ম্যাটারটা খুব বড় আছে অ্যাকচুয়ালি।
Then, Milord, I'm so grateful.
Milord, we're taking up the leave matters, Milord.
Huh?
Leave
matters. Other side are there.
In one matter, Mr. Jetmalani is waiting.
So who is for the state?
Milord, the learned advocate general would be appearing, I believe, because there's a tagged matter.
So without
Mr. Shishana Bandyopadhyay, I'll inform him, my lord.
I don't know if they come, then I will. Huh? So where is the ED council? A junior will not address the court.
The rest of the matters are released for the day.
My lord, release.
I will take the leave matters.
My lord.
Just organize the council.
I'll
be there.
Item number 1.
I shall do that. Deeply obliged. I shall do.
My lord, 3:30 matter will be taken up.
Only leave motions.
My lord, 3:30 matter will be taken up.
Ask the advocate general if he comes. I will take up the matter.
Very dicey.
This matter also advocate general is going to come.
Very dicey.
No, when the matter is for, you have to be there. And you tell them that kindly keep it tomorrow. Or otherwise, if I'm
So one matter, that ED matter will take whole of the day.
if हमको मिला chance.
Who is the council? Tell me. Only leave matters. Councils, please stay. Whoever is there in the leave matters, rest of the matters you leave. And fixed matters, one fixed matter hearing I'll be taking up.
But I'll call the learned
Ask the learned advocate general to come. Yes, 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 yes.
Item number 165, kindly day after tomorrow, I will not present for medical emergencies tomorrow.
Keep somebody this way not possible.
That's also the fix.
ET matter I'll be taking up. আর কি আছে? Ask the advocate general to come, I'll take up.
Obliged.
Just coming back, I'll start. Ask the leave matters, 3 leave matters, and this matter, I think date will be fixed basically.
Yes.
And the ED matter I'll be taking up. These 6, 7 matters I'll be taking up. Rest of the matters you can take your leave.
My lord, may I? But I called up my lord, the learned advocate general, my lord, but he was unavailable. I called up his junior. So she informed that someone, Mr. Banerjee will be there, my lord. But possibly the learned advocate general is out of station.
Item number 330 was fixed for today is fixed for hearing.
My lord, here, my lord, for these item numbers 233, 235, and 242.
242, huh? My lord, 233. As for registration of the FIR, despite my complaint being lodged, no FIR was lodged. Instead, my lord, another FIR was lodged where we have mentioned two persons, the suspected accused, they were cited as witness.
Is a matter.
Which matter?
This is the matter where since witness the same complainant as FIR note number 230 where his writ petition, which we discussed yesterday, that writ petition is not maintainable now.
Not possible this side of
वो infectious होगा या 226 नहीं होगा.
Two grounds. And they have submitted charge sheet.
Not against.
You file a supplementary affidavit and argue the matter. Submitted. Hand it over to them. To do it after the vacations.
My lord, efficacy of the case will be lost, my lord, so far my case is concerned. Despite the complaint, no FIR was lodged till today, my lord. Kindly appreciate, my lord.
But on the same, that's relating to the death of the same person.
Yes. That's absolutely, my lord, a new version was taken up. But our case is, my lord, that the two persons we have mentioned in the FIR, they are the author of the crime.
Today, kindly mark it as harding part, my lord.
Yes, harding part.
No, harding part.
Several locations.
It is no written order, my lord. It has only been.
Regular bench cannot take up the matter, a different bench will take up.
But then kindly take up tomorrow, my lord.
Kindly take up tomorrow, my lord.
Kindly take
Tomorrow
up
not possible actually. Tomorrow there are meetings in the committee meetings actually. Tomorrow.
Then day after tomorrow, my lord.
Day after tomorrow already matters fixed.
Prior to the vacation.
Prior to the vacation, every day is fixed. Sir. Every day is fixed.
Our anxiety, my lord, if FIR is not being lodged, the entire efficacy of the case will be, my lord, laid to astray.
মামলা যা হবার হয়ে গেছে আর 24 জনের যা প্রোটেকশন হয়ে গেছে হয়ে গেছে
Simple direction, my lord, kindly lodge the FIR, register the FIR.
I understand, but then all on a certain thing. হবে না আমি রাখলেও হবে না এগুলো
Any day, my lord, next week, my lord.
Next week, don't burden me. Next week, I've got to complete the motions, new motions. Every day, people are wanting leave. You can understand. Just keeping it after the vacation.
We appreciate our hardship, my lord. In the event, my lord, there is any change in
Harding part, my lord,
has to be, my lord, argued afresh, my lord.
But then kindly keep it as spotted, my lord.
Harding part, you will be in a better zone because now the charge sheet has been submitted. Mr. Dave argued at a stage when the FIR was there.
Both the cases, my lord.
And the charge sheet has been submitted. Those charge sheets were not there when your arguments were concluded. That was at the FIR stage only.
Yes, during the pendency of this case, charge sheet was submitted.
That is exactly the reason, my lord, why we are praying, my lord, for marking it as harding part.
Harding part.
And my lord,
it just took, my lord, a fraction of a second, my lord, to appreciate, my lord, about the development. Since, my lord, has harded, my lord, at length.
But kindly appreciate, my lord, the fate of my complaint, my lord.
I'm there after the vacations. I'm there, sir.
Then, my lord, may it appear, my lord, under the same heading tomorrow, so that, my lord, our time can be fixed, my lord.
Regularly, this problem will be going on, a recurring problem, sir. This is becoming a headache. I've got to address each and everybody. I'm keeping this after the opening.
Yes, yes. On the date of reopening, my lord.
I will not be there the date of reopening.
My lord,
Friday, my lord.
Friday শেষের দিনে হবে এগুলো Friday you tell me চলে আসুন এই তিনটে আছে আলাদা আলাদা অর্ডার করে 233 235 242 233 যেভাবে আছে 233, 235, 242. Learned advocate aid for the petitioners present state praise for an accommodation on the ground of the learned advocate general. List the read petition under the same heading in the monthly list of June 2025.
Kindly post it on any day in the daily supplementary list after the vacation. Yes, my lord. Kindly fix a date at least, my lord, after your opening.
ওই এ করে দিন, ওই 10th জুন করে দিন তাহলে।
10th June.
না কবে মান্থলি কবে হবে? তো 10th এ করে দিক না তারপর। তাহলে 23 তারিখে করতে হবে।
10th June.
10th June list will not be published, sir. I will not be there. Then 23rd of June, I am keeping the matter. This is difficulty. Let it be in the monthly list. You can take your chance before another bench.
My lord, kindly, my lord, do not, my lord.
All the chances before your lordship.
I am keeping these matters mentioned. I will fix it up. I am keeping this matter in the monthly list. Mention 3 matters. I'll definitely fix up the
Under
matter.
the same heading.
Under the same heading, yeah.
10th June. 10th June.
No, monthly list of June 2025 under the same heading.
9th of June.
9th of June.
Specially fixed matter, my lord. This matter has been mentioned before your lordship. Your lordship was pleased to direct me to give them the notice and take up the matter today. This matter is item number 328. After this, my lord.
ED matter, after ED matter, wait.
But I can wait, my lord. The only thing is that it was lordship fixed by your lordships today.
The ED matter has also been fixed.
But
সব কটায় একই অর্ডার হবে।
I will be waiting.
Wait.
Yes, my lord.
কি আছে?
Down ছেড়ে করিস নি।
না এইটা আছে কি হলো আর লিভ ম্যাটার্স গুলো ডাকুন কে কে আছে?
সবে তুই বলছিস দেখো
মোশনে লিভ ম্যাটার্স যেগুলো দেওয়া আছে পাগল হয়ে যাবো। 214
Number 214.
And 321, whether we had mentioned.
214, who is appearing for the state?
In this matter, lordship, the private respondent has
private respondent means
আমি private.
না ওকে বলছি।
321. Your lordship had called for a report. That report is important to understand what are the other cases against
That report, my lord, is not available with us today, my lord. Very well.
Sir, आपको बोलिए आप ये क्वेश्चन कर शीजिए आप।
As far as the 214 is concerned, that I have got the report.
very well. 214.
My lord, there's an urgency in these petitions in as much as, my lord, there's a threat to arrest. There are FIRs filed in 2 police stations. One is Iqbalpur and one is before the cyber crime. Now, my lord, frankly speaking, this is only, my lord, to put pressure on the petitioner, who's an anchor of Republic Bharat, Republic Bangla. Now, my lord, this is a factual report. There are no assertions which in any way disclose the offences which are alleged, which are under the new BNS 196, 197, which correspond to the old 153A. There's been a factual reporting of, my lord, what happened in Murshidabad and nothing else. No aspersions are cast on any religion. And still, my lord, an FIR has been filed against against an anchor. My lord, factual reporting without trying to create any communal disharmony can never amount to the offences which have been alleged in this FIR. So, my lord, and the other point is, my lord, that there's a number of FIRs. We don't know. We've got 2 at the moment, but we've had threats that there will be 100 FIRs.
1,000.
Sorry, 1,000 FIRs. I stand corrected. So, my lord, this kind of, my lord, disproportionate recourse to the law and unwarranted recourse to the law, my lord, I respectfully submit needs some intervention by your lordship to protect somebody who's done no more than his job of reporting factual events which are serious events. Now, there are threats of murder, there are threats to burn the petitioner's office.
No, so far as that is concerned, Advocate General has assured the court that will not be done. But so far as the FIR is concerned, where is the letter of complaint, which is the genesis?
Yes, no, the two. One is at page
69 capital A.
Yes, 69 capital A is the Iqbalpur one. And the other one,
Page 125.
Page 125. But the assertions are the same. They arise out of the same broadcast on Republic Bangla.
So far this 125 is concerned, this is by my client, who has also filed another writ petition which is pending before this court, madam.
Supply the number. Supply the number.
I will supply the number so that it will tag to it.
রিপোর্ট দিয়ে নাম দিয়েছি ওইটা তো নাম দিইনি সরি ওই আগেরটা নাম দিলাম ওই যে 237 ম্যাটার ফিক্স হলো মান্থলি লিস্ট অফ জুন এইগুলো
explain किया है body
जानी पापा जानी का prayer ex-commando cannot be a practicing advocate.
No, weightage
125 125 and translated 125 you just read it 125 on the period. Another one is 125.
No, why will be আমি বলে
this translated.
What I'm agreed by is page number 126. Get the instance number 3 being obtained.
Secular part.
June হলো monthly list of
the translation of this.
ওরা মেনশন করবে তোমার যদি মামলা বলতে শুরু করেছিল আমি যা আটকে করে দিয়েছি বুঝলি এটাতে যেটা বললে এফআইআর হ্যাঁ
This is the translation of
traffic or something.
No context. This provides the context for.
I was just going to put this open রাখা হয়েছে যদি পরে কোর্ট কি অর্ডার দিচ্ছে তার উপর
Who is there? You were there, Mr. Banerjee?
Yes.
The report has been prepared as if they want prompt action. The de facto complaint is not the petitioner over here. The report is in the nature that the de facto complaint wants prompt investigation.
No,
you see the contents of the report?
I've seen that. I've seen that. I'll come with a further report. But Lordship, kindly consider after perusing the Lord, he's anchoring. Everybody has seen through Malad media. He's anchoring, he is pose of anchoring, and he is a provocator. Lordship should not entertain this application. Should not.
Every news channel.
Yes.
You will say right to comment on the
they are quoting the his anchoring should be seized by the authority.
You want to scuttle my anchoring. That's the entire point.
That all secular should
get out of freedom of speech should go to. So,
this is called reporter.
The reporter
is a very same
secularism should be out of the constitution.
And who is he? Why weightage will be given?
We are hard.
No, weightage will be given. 35(3) notice has been given. Let him go. Let him go to the investigation. Cooperate with the investigation.
Ingredients not made out. Ingredients not made out. On this cyberbullying violation.
But kindly, Milord, your Lordship, kindly see.
Today, কিসের কুসুম লজ্জা লাগে না গান্ডে পিণ্ডে আপনি এই মুহূর্তে গিলবেন গান্ডে পিণ্ডে ভারতের খাবেন ভারতের থালা ফুটো করবেন বেরিয়ে যান যদি আপনার মনে হয় আপনি সেকুলার আর জবাব চাই বাংলা থেকে বেরিয়ে যান কাল দেশ থেকে বেরিয়ে যান Isn't this a threat?
And he is saying before the court that he has been threatened by the
job of the reporter.
He has been threatened by the police.
But what is the threat? I'm not able to understand how they're threatened by this.
Let's go out of the
He has
country.
only said that if this is the kind of secularism you leave, he's not said he's going to throw you out. He doesn't have the power to throw you out like the state of West Bengal.
And he will get up advantage. No, certainly not. They're proud to be Indian. And his anchoring, his reporting should be ceased. Eliminate.
So what is difference between Iqbalpur case and the Bidhannagar case? Tell me.
So it's the same, my lord, this same allegations.
Before your lordship, when he has come before this honorable court, the 35-3 notice.
No, but you cannot. One thing, on the first day when the first application was moved, on the same contents, if there are thousands or lakhs of FIR, I said that give it to the centralized agency. Let them do that. You cannot expect.
But your lordship should not give any protection to him.
That I will consider.
My lord, my lord.
Then
he is the person. Everybody.
That I will consider as a hearing matter. As I will consider. But then from
we want to learn secular from that Moikaranjan.
You tell me one thing. I have.
Nobody should not appear for him. Nobody should not appear.
All right. You do.
Yes. Please don't do that. That's contrary to the Bar Council for you to make that statement. It's contrary to the Advocates Act. Don't say nobody should appear for you. Everybody has the right to appear.
Thank you.
Challenge the constitution.
Nobody should appear for him.
Not adding these sections.
He should be thrown out. He should be thrown out from India.
That is your intolerance. That is precisely your intolerance.
Yes, Mr. Malani.
You can't take a converse opinion to yours.
Can't help him. Who is actually
that is the poverty of your thinking. That if somebody says something that this is not secularism, all he has said, in sum and substance, what he has said is this is not secularism, and this is the secularism. You should leave the country. There's nothing else, and that's an opinion which he's entitled to have. You may not like it, you may not be able to swallow it, but that is the law of this country. There's freedom of expression, and you can't throttle it, nor can the government.
Which an expression protects.
So you are spoiling the court, sir. All of you are spoiling the dignity of the High
Court. Kindly consider one aspect. Can this,
sir, you cannot on the same incident 1,000 FIR.
No, I'm not on that, my lord. I'm asking whether this is an cognizable offense or not. I am on that.
That I will consider. I have said finally, but the thing remains: if there are 1,000 FIRs, bring it to one central point.
That your lordship can.
Regarding the intrinsic
that is my
of the letter of complaint afterwards. There's a simple thing I said on the last occasion.
But without giving any protection.
And first bring it to a centralized wherever.
Let me first bring the information that how many FIRs are there.
And
now they have themselves come to know of there may be one or two more. There will not be 1,000. I understand it's a ballpark figure you're referring to. It will be something.
That happened in Vinod Dua's case. Earlier date I gave.
Case.
It happened in the same petitioner's case earlier. In Bombay, from the Bombay High Court, the same thing happened.
No, that is another habitual offender. Habitual offender.
Yes. Sir,
no.
I have said.
Arnab Goswami. It's not Arnab Goswami.
Under one umbrella.
Arnab Goswami, not my opinion.
One umbrella. Then we will check whether, according to the background of Kedarnath's case, whether this is an offense.
Yes. Yes.
That is a separate testing I will do. That's a separate part. But first organize that, because prima facie it reflects on the set of events which were covered. All the FIRs have been registered.
Right.
So let one particular officer or one agency, a central place, try that. 35-3 notices, if required, you issue from that place. A person cannot be roaming and hopping around each and every police station.
We are with your lordship.
When can you inform? Tomorrow, Mr.
Tomorrow, day after tomorrow, kindly take it according to lordship.
Tomorrow.
At the same time, my lord, I request your lordship also to examine one aspect. That what should be the ambit of this anchoring. By the name of anchoring, somebody can propagate this kind of things, which is basically nothing except altering the position of the constitution.
Mr. Jetmalani is appearing in this matter only, 214.
In 10,379 of 2020.
Mr. Jetmalani, learned senior advocate, appears on behalf of the petitioner.
10,000
Mr. Banerjee appears on behalf of the state. You are appearing for whom?
I am appearing for Lordship Sujoy Mondol.
He is respondent number 6.
In this matter?
The de facto complainant in the Bidhan matter.
Mr. Chatterjee appears for respondent number 6. There are other writ petitions which have been filed, and earlier it was informed. Earlier it was directed verbally by this court, so that all the FIRs which are registered against the petitioner and
other officers of ARG Outlier Media Private Limited.
And other officers of ARG Outlier Media Private Limited, in respect of the same incident complained of, be investigated under or within the jurisdiction of one police station or investigating agency. Whatever you please, sir. Tomorrow or day after, which will be convenient?
Either way,
Later report appeared on 14 of May 2025, 1:15. Will go. 4 p.m. I have got meeting at 4:30 tomorrow. And also take 45 minutes, sir. This is a difficulty.
1 p.m.
Huh?
1 p.m.
At 1 p.m. At 1 p.m. tomorrow, sir, I am keeping the matter.
1 p.m. tomorrow.
Yes, sir.
I'm grateful. I'm good. Well, I suppose till then they won't take any action, any of the police stations. Well.
No, they will not take it.
I am objective to
that. Huh?
No protection.
But this is not the French Revolution, Manoj. I don't know what they're doing. This is the rule of law. I'm entitled to protection till consolidation takes place.
Mr. Malani, you are appearing. Kindly learn him. Rule of law.
Learn him means what?
No, he doesn't know rule of law.
Let the writ petition be listed under the same. Let the writ petition be listed under the same heading. No, not now. Tomorrow I'll change the heading.
Because Mr. Bondopadhyay is appearing in that matter.
Yes.
No, that
matter. The other one may also be posted, that is 9623.
Lordship, another thing, Lordship, tomorrow your Lordship will be taking up the matter so that we can prepare our arguments also.
No, only centralize.
Okay, on the issue of centralized.
Right. Agency, but may not be central agency.
If you pray for that, we'll see.
Not at all.
আচ্ছা কি তাহলে এই পরোটা যে দিয়ে দাও একটা সময় করে থাকবে দুটোই হ্যাঁ ওই পরোটা যে দিয়ে একটা সময়
Malani will be making some prayers for interim orders then tomorrow.
Yes.
9623 may appear along with this.
For orders, both the matters.
Your Lordship, kindly take note of it, but the interim order, I am objecting to that.
Tomorrow,
or today or tomorrow, I will object. Yes. Because no weightage should be given to a person who is coming with Jetmalani or somebody else.
Make names in the councils that judges. This is a new habit coming over here.
If you're allergic to me, I'll send somebody else. I don't mind.
Come tomorrow at 1 o'clock.
I'm obliged, sir.
Next.
Leave matter 250.
This is come. Who is for the state? অরিজিৎ এসছে আসেনি এখনো তো
The way,
ও এসে গেছে তো হ্যাঁ
the way, Miller, the complaints, because I have categorically stated, Miller, in paragraph 6, 8, 9,
urgent
14
request
and
of police
15.
protection.
Miller, I raised objection with regard to Miller, to disbursement of a salary in respect of a particular person, Miller, whose appointment was found to be irregular.
You are who, the finance officer?
Yes. My appointment, Miller, I said, Miller, this a particular person. Now,
No,
hereafter, Miller,
your this is what page 64. What are you relying on?
no, I'm saying, Miller, now I Miller, made a, I said, Miller, that the salary cannot be disbursed. Kindly sees first, Miller, page 23rd July 2024.
No, what are you wanting now?
Now, Miller, I'm questioning, Miller, the order dated 2/5/2025 against Miller the stalking and Miller the threatening. The threat
2/5.
kindly see page 63. 28th April
63 is
2025.
a FIR. So the genesis is 64, letter of complaint.
64 is the Miller ultimate response, Miller, which is a sequel to the Miller. It is a knee-jerk reaction to the letter dated page 63, page 20, dated 28/4/2025, where I, Miller, narrated the entire incident. Kindly see only one page, Miller.
64 is something. This case was registered on 19
Miller,
to 2025. Where is the letter of complaint of this?
Miller, dated 28th April 2025, and last, Miller, that is 2/5/2025. The reaction of the authority. The response, the last page, Miller, dated 2/5/2025, which is a sequel to the letter dated 28 April 2025. 65, 64, sorry, 63. It should be 64.
Yes, now
Miller, 65 is the answer to this, Miller, by the administrator.
What have you done actually?
Now, Miller, I tell you, Lordship.
Just 1 minute. What have you done?
Followed, stop, and he was in. On 24/4/25. Came to the draft of the. Have inquired to the man. Found that the person was assuming that a person was following him, stalking him, and on assumption, confronted that person. There was some hot altercation between the person.
So who is the person?
We have found out the person. His name is
But who is he actually? Who is he actually?
He is somebody who happened to be on the same Toto which was being used by the people. Now, people assume that he's being followed by this person.
No, but they, wait. But you have the accused persons you have named in the formal FIR.
That is a different aspect. I'm not doing that. That is not the prayer before. Prayer before you notice is that he is seeking protection since he found this person to be following. This is his case in this situation.
So according to your report, what is there? Nothing is there.
We have complaint of the teacher, and we made inquiry with someone who happened to be the same Toto. It was just coincidence. He was traveling to Para for his personal, and the teacher also happens to be traveling same Toto. Now he admitted that there was a verbal altercation between him and the complainant inside the toilet. Only after complainant confronted him with stalking allegations. Why are you following me? Why are you stalking me? This is the
Millard, I don't want to.
On the basis of this, Millard complaint, Millard, PDK has come up with your seeking Millard police protection.
Yes.
Millard, this man is a politically blessed person, my lord. Sanju Samanta was present at an unofficial, my lord. I want to file because, my lord, there is absolutely, I was not suffering from any hallucination. Question is, my lord, the moment I raised this objection against the disbursement of a salary one, the DM, my lord, has taken a step in pursuance of, my lord. The other persons were, my lord, they were also, their salaries were stopped. Now, my lord, the inside, my lord, they organized a turmoil. They, my lord, organized the movement, and they, my lord, put a pressure on
who?
They means, my lord, the other employees, that why did you raise objection as an audit officer? And accordingly, my lord, a particular political party, this person concerned, he was so powerful, he is so powerful, my lord, in every meeting, my lord, in the office of the municipality, my lord, inside or outside, my lord, he is omnipotent, omnipresent. Here, I want to see this, my lord, his report. Question is, my lord, no. Lord.
So why have you allowed the Sanju Samanto to enter?
No, not only that, my lord. Page 63 in your lordship's brief, details of known, suspected, unknown, accused particulars, Tinku Mukherjee, Somnath Samanto, Mohit Das, Pradeep Mondol, Akash Verma, son of Gopal Verma. This FIR also, my lord, in respect of, my lord, complaint dated 19 to 25. This was there. Kindly, I will also, my lord, my lord, I will show your lordship, my lord. From 2015, my lord, the particular municipality is running without an election. This is one of the, my lord, important morsel proof, my lord, how the democracy prevails in that particular area. No. I put this question. No. Question is, my lord, the moment I, my lord, raised an objection with regard to the, my lord, the record shows. I appreciate, my lord, his courage, my lord, in the Kurial combat that he says from 2015 to 2016, my lord, it is absolutely beyond record. I am armed with this photograph, which consistently shows, my lord, that the presence of these persons, my lord, how powerful. The moment, my lord, my lord, I raised objection against, my lord, this illegal disbursement of salary as a whistleblower, my lord, the person concerned, my lord, they became infuriated.
So that you have taken a decision, they have become infuriated. That's all right. I understand. But then what are only
Question is, my lord, the lady, my lord, who is acting as an administrator since from time immemorials, my lord, she also happens to be a SDO. Now, my lord, she has an administrative power in addition to what she has been discharging as an administrator of the municipality. The question is, my lord, right to life and liberty, my protection. Yes. No, my lord, no. The question is, my lord, the
case has not been made out.
My lord,
The
63
case has not been
complaint.
made out.
I have made a complaint. I said, my lord, by reason of my protest, my lord, my life is at stake. And this is, he said, my lord, in the Toto, somebody, my lord, he followed me. I was not suffering from any mental illness or, my lord, hallucination.
He should have been made a party, my lord. If he had a specific allegation against him, he's not been made a party over here.
It is the investigating agency, my lord, my lord, my authority, my lord, who is also, my lord, at the helm of all affairs.
So you tell me one thing. So far as the inaction of the police authorities in respect to the case, you have got nothing to say.
No, my lord, I have said, my lord, only, my lord, I have made 4 complaints from 19 to 2025 to 28/4/2025. Only as against 19 to 2025, they registered FIR, which is at page 62 in your lordship, 63 in your lordship's brief. He said only Sanju Samanto. I said details of known, suspected, unknown person, column 8, attached separate sheet, Tinku, Somnath, Obhijit, Mohit, Pradeep.
That is a different case.
Akash. That is only, and as against, my lord, the other complaint, which I have categorically stated, my lord, which I have said, my lord, kindly cease. From 19 page paragraph 5, my lord, may I take my lord's kind attention to paragraph 5, page 6 of your lordship's brief. I am saying, my lord, that in view of the repeated incident of threats, harassments, stalking and criminal intimidation to obstruct the discharge of his public duties as a finance officer, the respondent, despite written complaints dated 19/2, 16/4, 19/4, 21st April, have failed to ensure basic police protection, thereby rendering the petitioner lives. Then, my lord, kindly comes to, my lord, paragraph.
You come up with the Why?
Milord, kindly see paragraph 14 only.
Respondents means your only accusation is against the police authorities.
Yes, as well as the Milord, the Milord, the person concerned, Milord, kindly see.
Person, then you have got to make him a party.
No, the person concerned, Milord, that is the Milord. I wanted a protection from respondent number 4. And Milord also, Milord, the administrator of Bali, she said, I'm
So
not a
where
person.
are they party over here?
The accused persons.
Whoever are you wanting? You have got I have to.
Four is
your
the police authority, Milord. Four is the
administrator
commissioner.
you are representing.
I am representing. He is representing.
My lord,
Administrator of
Administrator, I
Bali.
am representing.
administrator 7.
Administrator is also administrator happens to be a SD also.
That government official.
A government
Now you
official.
tell me.
She expressed her inability.
No, I have said inside the premises. I shall
why should
explain.
it be? Why you did not take
Outside
any
the
steps?
premises, how the
No,
administrator
question
can
is
provide.
no, because as an SGO, you did not lose your position. It
She
is
is
not
not
that
acting as the SGO here. The letter
it is
was
not a
given to
case
the
that you
Milord
changed to be SGO.
Just tell me one thing. This Shonju Shamont, you are administrator. This person entered your office at any point of time. Yes or no?
I am taking instruction. There is no allegation in the writ petition.
You have instruction what this person entered your office.
He is not a staff of the premises.
This is evading answer. I am asking you a simple question, sir. Did this person enter your office?
I have to inquire because no, it's a public place. Not
Conduct
hundreds
an
of
inquiry.
hundreds of persons come, Milord. CCTV footage is there, Milord, but for last 1 month. We shall inquire. If they
Inquire
provide
and
the
submit a
photographs, it shall be very helpful for us.
Inquire and submit a report before this court. Petitioner
let them furnish the photograph that he is handing out to your
up to you, sir.
because the dates have been mentioned possibly. We shall be able to find out. Otherwise, beyond 1 month, Milord, the
You call the person concerned. You will be conducting an inquiry. Court will not assist you, sir. You are an officer. You are holding an office. How you will conduct an inquiry, that is up to you, sir. Achha, state has submitted a report. Let the same be kept with the record. The main grievance of the petitioner presently is related to 682.
I request your lordship to take pain to note of page 57 also.
না অতগুলো করা যাবে না আগে একটা করুন এই সঞ্জু সামন্ত নিয়ে ঝামেলা আমি বুঝতে পারছি কি বললাম the petitioner relates to page 65 of the writ petition, which is a communication of the administrator of Bali municipality to the finance officer oblique the petitioner, which names an individual. The administrator Bali municipality will conduct an inquiry as to the individual who is named in his this is communication.
Yes,
in his communication dated 2/5/2025
কার নামে কমিউনিকেট করেছে
was available at the office premises of the Bali municipality, and whether he has any association with the office bearers as well as the officers of the Bali municipality. Let such inquiry report be submitted on first week of June on
But in the meantime, kindly keep some protection.
protection, witness protection. I'm granting you liberty. Yeah. Okay. Conduct an inquiry on first week of on the first week after the opening of the summer vacation, release the writ petition under the heading 4 orders in the month list of June 2025. Petitioner is apprehensive regarding his protection. Since a criminal case is pending, petitioner will apply before the jurisdictional magistrate, being a complainant and a witness. London magistrate will assess regarding the threat perception and thereafter pass necessary directions upon the police authorities.
And the commissioner of police will kindly.
Grateful.
Matter, I am for the petitioner. In this matter, Lordship, the wife of the particular Lordship committed suicide.
Which matter is yours? সবুজের সাথে কথা বলুন tomorrow not possible. I've got 2 committee meetings.
This matter will take some time.
Where is Shobhushachi? He's not
He
there.
was just sitting.
ওর সাথে কথা who is there in this matter? Speak with
I'm for the petitioner.
state. What is your urgency? এই আগে ম্যাটারটা কোনো
There is no urgency, my lord.
আমি বুঝতে পারছি সবাই আর্জেন্ট বলে বলে
They want police protection, my lord. She is a complainant.
That is not my case. May I submit?
What? Why have you taken leave by over here? You tell me.
I will take lordship 2 minutes.
2 minutes, sir.
Wife of the petitioner lordship committed suicide. Now FIR was lodged with the Rannagar police station under the South Chowbis Pargana. Now lordship, one of the accused lordship was arrested. His anticipatory bail was rejected. And lordship, after the rejection, lordship, I received several threat call, lordship. In my workplace, lordship, I was received the threat call.
Have you informed the local police station?
I am not in a position to. So I am not in a position to appear before the learned trial court through counsel. On the last occasion, on 8th lordship, when one.
You are able to come out of your house? Yes
I
or
am
no?
not staying in this house.
Huh?
Presently, I am not in a position to stay there.
So,
Lordship, I made 3 lordship prayer, lordship. For lordship progress of the investigation, because no.
এইগুলো করে না এই কাল থেকে লিভ বন্ধ করে দেবো এইরকম করলে আমার
My lord, grant
no
leave.
urgency in
My
the
lord,
matter.
no, my lord, grant leave, but impose cost for showing fake. My lord, he wants to appear virtually before the learned court below. He can make the application before the learned court below.
Because lordship, on 8th lordship, after appearing.
There is
Sir, you are unnecessarily spoiling my patience. Regular matter.
Because
Regular matter. Nah, no.
Because lordship, on 8th lordship, I received threat.
Sir, when
We'll add 232 if needed.
Whenever you are making, I am giving importance to the lawyers. It's now 5 o'clock. You will be going tomorrow. You don't have a matter at 5 o'clock. Regularly up to 6 o'clock, I am sitting.
Without urgency, lordship, I.
No urgency in this matter. These are regular matters of this court. Why do people come to this court? You tell me.
Kindly consider lordship, my counsel, and I am not in a position to appear before the learned trial. Kindly give me that liberty such that I can appear virtually before the learned trial.
The provisions are there, sir. You are not invoked.
It is Diamond Harbour Court. There is no provision, lordship, to such that I can appear, lordship.
What Diamond Harbour? The BNSS has granted leave.
There is no facility. That's why, lordship, I have prayed.
Facility.
On 8th, the council, lordship, appeared. Yesterday, lordship, he refused. It is Diamond Harbour Court, lordship. If you, lordship, kindly give leave, lordship, I will appear personally here, lordship, from the virtually. And no investigation regarding because
It will be called just check up whether there is virtual facility available at Diamond Harbour Court or not. I will also take it.
Tomorrow is the date, lordship. 14th is the date.
What is the date? You are a de facto complainant. You are not an accused.
Because I could not appear before the learned. Kindly take it tomorrow, lordship.
No, just tell me one thing. What is the role of a de facto complainant? Investigation is going on. Your notice has been issued upon you to appear. Why? What is the urgency? What is the urgency? You tell me. I don't know. I don't understand, sir. You tell me what is the role of a de facto complaint in criminal investigation. Tell me one thing, sir. Somebody brought a 90 years old lady in my court, and she wants upgradation of the matter.
Some lordship mobile message which is lordship important. I want to submit before the IO. He refused. Now certain things is there, lordship.
I don't know. For that, why date of the court is? You tell me. You understand.
Now,
Under CRPC, where is
step has been made, lordship. I am not in a position to.
this? Is investigation stage or post investigation stage? It has been fixed for your appearance.
No, for the one of the accused is in JC Mullard for his appearance, and he has made an application for bail.
Before whom?
ACJM.
Diamond Harbour.
London ACJM, Diamond Harbour.
The information I have annexed, lordship, which is
Before that, ADJ.
So far, I have been instructed, lordship, there is no facility, lordship, unless the district judge is directed to arrange such facilities, lordship, we could not appear.
Appear through mobile.
So this cannot be through this writ petition. This writ petition is styled in a different manner. He wants a online facility in a district court. Well, the law Department of Justice has to be made a party there. It will be provided by Department of Justice. This is Home Department. My learned friend is. If it is a bar's problem, then it is a different department who will cater to the problem.
If I appear from
My problem is that we come and prepared in some other matter. What is argued is completely different matter.
So politically attached, lordship, if I out
That there is no CCTV in the court.
Then lordship, there will be.
How is he connecting the dots? Our person is so influential that CCTV is not there in the
I don't know.
internet is not there in the court.
Understand, sir? Why are you mentioning and wasting the time, court's time? কাল থেকে কাউকে লিভ দেবেন না, আমি বরণ করে দিচ্ছি।
Now only this prayer lordship for
যে লিভ চাইবে সঙ্গে সঙ্গে রিলিজ করে দেবেন।
now whether lordship when
অন্য কোর্ট
progress kindly call for a report progress or lordship arrange for
unless you are pleading, there is no case made out. To the best of my understanding, in West Bengal, there is no person so powerful that in a court of law, a litigant cannot
yes
participate.
that why lordship I have mentioned that
My learned friend can go and appear tomorrow.
I cannot lordship if something is happened because the person is politically attached.
Are
And lordship, what happened lordship since lordship the one accused already has been lordship granted bail.
After 2 months.
In every case, person will be granted.
After
I don't
2 months.
understand your reason.
One lordship is willing to take the brief.
That's something different.
That is lordship only recourse to ask lordship to appear before and pray for lordship for appear before the learned trial court virtually. Kindly consider that. Otherwise, lordship, I will not do anything. Lordship, kindly that prayer may be lordship.
Approach the legal aid. Approach the legal aid.
No one will. No one will.
Approach the legal aid.
Verbal lordship and is lordship truly lordship difficult for anyone from go outside and to appear before the learned trial court.
Don't make all these stories over here, sir.
This is lordship. Kindly consider this is if this is possible lordship to appear through councils, we should not lordship make this prayer before
You
lordship.
understand? You have not produced anything before this court to show. And if in one case I allow this, whole of West Bengal I have got to allow. Whole of West Bengal I have got to allow.
Well, my learned friend will show this case from the writ petition, my lord. I'm sorry to say this, my lord. These are being developed at the bar on the go.
Yes, yes.
There's nothing there on the writ petition, my lord.
চলে আসো
Few days back, lordship, your lordship knows the Diamond Harbour judges quarter case. Her lordship complaint was lost from the judges quarter.
So why are you
So-
bringing that analogy with this one?
Kindly consider to I am praying for lordship appearing.
I think this petitioner is best fitted for a public interest litigation, my lord.
এটা বুঝতে পারছি না, এইগুলোকে কস্ট দিয়ে না করলে অ্যাপিল কোর্টে যান, অ্যাপিল কোর্ট বসবে। These frivolous litigations. This is not within the domain. What will police do? Each and every lawyer will get police protection.
No, not for
No.
Kindly
Then why are you doing it in my court?
kindly
Tell me,
consider
why
lordship,
are you doing it in my court?
page 24, my lord.
No. Why are you doing it in my court?
After page
No.
because lordship
I do not find any grounds to interfere in the writ petition. Accordingly, WPA 10455 2000
page 20
is dismissed.
page 24
কাল
and
থেকে
lordship
dismissal আরম্ভ
21.
করো। চলো, আর কিছু লিখতে হবে।
Grateful, my lord.
Kindly consider that lordship.
Nothing.
There is directly threat representation was made before the lordship SP.
Nothing. Go to the appeal court, sir. At the time of mentioning, you will say a host of lies, and thereafter you will.
I at the time of mentioning lordship, I have lordship.
Chalo, next.
Kindly that prayer lordship,
Nothing.
I am praying for lordship 300. Then lordship, may I came back lordship with instruction whether lordship there are virtual facilities available or not.
কোথায়? কালকে আমি কিছু নিতে পারবো না।
My lord, this matter was fixed today. If your lordship wants this matter to be taken up after completion of the ED matter, I can wait.
না আমি থাকতে পারবো না।
But you kindly take up because my urgency is that on 18/6, the next date is fixed date before the court at Krishnanagar for trial. And the everyday lordship I am mentioning is I am trying to get my chance,
হবে না,
but I am not getting my chance.
Yes.
But kindly take up this after.
Speak with Mr. Banerjee, sir. I have got nothing.
No, lordship, I cannot compel Mr. Banerjee. to
তাহলে আমি
serve
কি করব?
My lord, kindly consider this aspect. At least, my lord, I have mentioned the matter and matter was fixed for 7 to 8 days.
I wait. No, I have not seen anything.
Well, kindly consider this.
I am considering. Wait, I will do it.
No, lordship, I will wait. And lordship, if Mr. Banerjee,
আমি কি করব? কে থাকবে না?
I will be waiting. Lordship, kindly, I will finish my argument too.
হ্যাঁ, ঠিক আছে।
If Mr. Banerjee.
You are threatening the court or what? What are you trying to do? A matter will be called, matter is fixed. What are you doing this, sir? How many courts are sitting now? You tell me in Calcutta High Court. No, but wait. I have told you why you are cross-checking from the court. You are trying to challenge the integrity of the court. Obviously, I have asked you once, Mr. Chatterjee, you sit over there. But I cannot compel somebody, both the parties, to work after the court hours. It is only after consent of both the parties that can be done.
I cannot say that. I cannot do that, my lord.
But if you want to stay, you stay. If you want to leave, leave. I'm here. This is cross-checking.
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 I can only make my request, my lord, since my lord is indulged.
I have said that if he doesn't want to stay, I cannot compel. You want to stay, how can I?
My difficulty, I've got to express my difficulty.
I have got
Somewhere at least I should get a chance to express my difficulty.
Otherwise, you decide. What can I do? You tell me.
I understand, my lord, but at the same time,
Yes, the Chakraborty, start. Not
even I have the problem for this, na?
Your matter afterwards.
My lord, very recently, my lord, I have been briefed in this matter, my lord. Because I was unfortunately, my lord, when my learned friend was arguing, my lord, I was not there. But my lord, I shall place whatever I could understand.
Live streaming, everything is available.
My lord, whatever I could
completely in the live streaming. So
my
that's
lord,
why
what I could understand.
Open so that nobody can come and say I didn't hear the other side's argument.
No, my lord, I am not on that, lordship.
Yes, say.
Lordship, what I gathered, my lord, we have got the case diary. My lord, what I could gather from the petition, the summons substance, what I could understand is, my lord, that there was non-compliance of the basically mandatory provisions of section 19 subclause 1 and 19(2), my lord. Now, my lord, and my lord, all the judgments and other submissions were made in line of those particular. Now, my lord, I am just making my submissions with regard to compliance of those two. Now, my lord, there can be a particular understanding by going through the reasons to believe as well as grounds of arrest that they do not show, according to the petitioner, materials enough to arrest a person. But, my lord, I'm asking a question to myself. Does that, because, my lord, the decision which has been cited by my learned friend itself says that, my lord, when we give a reasons to believe, we have to give grounds of arrest, we have to give. We cannot say that we will not give you reasons to believe because it will put to light other materials which need not be shared with the accused. But here we have given both. Now, my lord, the contention here, what I understand, is this, that my investigation is basically, there is no investigation on my part, which is totally a dark area for the petitioner. What investigation I have made and how I have come to this particular finding, which forms part of my reason.
His argument was that whatever you have stated in the grounds of arrest, that was done by the police authorities. What is there in the grounds of arrest, material in possession, he has equated with that.
My lord, I'll show my lord.
What are the grounds of arrest? Because the necessity of arrest is one of the preconditions.
I bow down.
So that is how he has equated that where is the material with the enforcement directorate. This material was there already with the cybercrime police
My
station.
lord, I bow down.
So what are the materials, and what is stated over there is the materials of the cybercrime police
My lord,
station.
and no investigation per se, enforcement directorate was made for them to come to materials, to come to reasons to believe, to arrest. That is what, as 3 points, my lord, what the ground has been said, one, reasons to believe. So it should be their own indigenous investigation, not verbatim investigation or aping the investigation of of police and then making it into a ground of arrest and then arresting. This is the sum and substance what I could understand it. And then it has been the garnishing on the cake is the series of judgments. Now, my lord, if I can show, my lord, that the reasons to believe, maybe it is not that well worded, maybe it is not that categorically mentioned there, that it is a part of my investigation. If my case diary, which I may produce before your lordship, categorically shows that we had investigation, we had documents to see that this particular person was operating accounts or was involved in making entries, less said the better, my lord. He was involved, who was receiving, my lord, materials, cash, as well as he is the person who is behind the operation of the several bank accounts. Below that forms a part.
SIM cards.
Now, SIM cards are there, live SIM cards being sent
Everything is there in my case diary. Now, my lord, before that, my lord, I will try to very, very briefly, my lord, I would try to place before your lordship the reason we have given the grounds of arrest, that is at page 133. Now, my lord, where we have mentioned, it may not be very happily worded, because, my lord, we are investigating officers. Now, investigating officers may not be that well as far as writing is concerned. My lord will kindly see. We start as far as this gentleman is concerned from page 135. Here, my lord, in paragraph 4, paragraph 3 to be more precise, that investigation under PMLA 2002 is in progress in this case, and several incriminating materials, bank transactions have been identified, which require confronted with the prime accused persons with Chirag Kapoor, alias Chintak Raj, and Yogesh Dua during custodial investigation. So it is, we have said that we have investigated. It may be something which is akin to what investigation has been made by the police, but it does not mean that we have not investigated and found. Of course, we can always take a lead from that investigation, but amplification was done by us. Because the crime is one and same. We are undertaking an investigation with regard to proceeds of crime. That there lies my departure from the investigation of the police. Nothing more, nothing less. Now, my lord, after that, my lord, that the investigation conducted under PMLA 2002 so far reveals that Mr. Chirag Kapoor Chintak Raj, close associate of Yogesh Raj, is the director of various companies, and through these companies, he and Yogesh Dua recruited other accused persons in the instant case for the purpose of extort proceeds of crime from innocent people across. Now, my lord, we are referring to proceeds of crime. It goes without saying that, my lord, we have investigated because our duty is to investigate on proceeds of crime from innocent people across the country by way of cheating and inserting fear and distress into them. It is further revealed that Chirag Kapoor and Yogesh Dua were in contact with different banking personnel and opened various bank accounts in the name of different persons. It was also revealed that one Chirag Kapoor has been in possession of the credentials of those bank accounts, and he used to collect the proceeds of crime in those accounts. Chirag Kapoor, Chintak Raj, and Yogesh Dua used these bank accounts and bank accounts of the said companies to acquire proceeds of crime upon further investigation. It has been revealed that large sum of money were transferred into the bank account of Chirag Kapoor companies and into accounts opened by Chirag Kapoor. Subsequently, those amounts were transferred to various other bank accounts on the same day. After the transfers, the funds were withdrawn either in cash. Here, my lord, I would have not amplify at the bar, my lord, but case diary, my lord, I will produce, my lord, where my lord will kindly find specifically where investigation has been in and how my investigation forms support as far as this reason to believe is there. Withdraw either in cash or through checks. Check means, my lord, here, my lord, the wrong spelling is there. Further, various bank account transactions amongst Chirag Kapoor, Yogesh Dua, and other accused persons have been unearthed. During the course of investigation, it is revealed that various complaints have been received against the accounts used and controlled by the accused person. Further analysis of bank accounts indicates that the funds obtained from victims are immediately transferred into multiple accounts in a deliberate effort to layer and conceal the trail of illicit proceeds, thereby facilitating the laundering of criminal proceeds. Now, my lord, if my lord again allows me to come to paragraph 6. In view of the above, an investigation conducted so far, it is found that Sri Yogesh Dua, along with Chirag Kapoor, has acted as main kingpin in the whole scam by way of creating various companies, appointing those accused persons as employees under those companies, opening various bank accounts in the name of those employees and several other persons, forging documents with logos of several reputed government organizations and arranging several other tools required for the above described. Now, my lord, here what is happening is, my lord, when this reason of to believe has been given by us, just because we have added certain other words which was not in our domain, that is, my lord, as far as impersonation is concerned, my lord, making those seals are concerned, logos are concerned, my lord, we are taking, maybe, my lord, we have taken aped certain words from the main chart sheet, but we, amongst those words, we have also said about the proceeds of crime, about the bank accounts, about the manipulation in cash made by these people. To be more specific, the petitioner. And, my lord, when we are saying, I cannot just put in reason to believe specifically, immaculately, those words which are with regard to proceeds of crime, I have to, my lord, showcase it in such a manner that this is the reason, this is the effect, and then I have amplified on that. So it cannot be said that when a predicate offense is there, I will not speak even a single word about the predicate offense while I'm showing my reasons to believe, while I'm specifically saying that these are the materials which we have got. Now, my lord, I am not supposed to, by the virtue of the judgments which have been cited by them, specifically the Honorable Supreme Court says that I am not to be very specific, immaculate, precise, with precision as to who are my witnesses, what are the specific material on record, what are the documents, because that will be compromising with my investigation. Now, my lord, what in my respectful submission, if reasons to believe show that I have got materials whereby proceeds of crime has been generated at the behest of this particular petitioner, then, my lord, I am within my rights to arrest this particular person. Now, my lord, will kindly allow me, if my lord allows me some more time, my lord, paragraph 7. I'll not take much of my lord's time. If my lord will kindly allow me to place before your lordship, paragraph 7. Paragraph 7, the last portion, last but 5 lines. Paragraph 6, I apologize. I apologize, lordship. Last but 6 lines. The huge amounts received by way of deceiving innocent people in the bank account of various companies are transferred in enormous number of bank accounts of several other individuals, and those amounts have been withdrawn in form of cash or through checks on the same day or within 1 or 2 days. By way of this, the accused person, namely Sri Yogesh Dua, has acquired proceeds of crime. Here we have specified that. Now, that based on investigation conducted so far and based on materials in my possession, which I have already given to the adjudicating authority, it is found that Sri Yogesh Dua is involved in commission of offense of money laundering by indulging in criminal conspiracy with several other persons to obtain proceeds of crime. He has knowingly indulged, assisted, involved, is a party to the process and activity connected to the proceeds of crime, including its concealment, possession, acquisition, and use. Therefore, I have reasons to believe that Sri Yogesh Dua has been guilty of the offense of money laundering under Section 3 of the Money Laundering Act 2000, punishable under Section 4 of the said Act. Now, lordship, before I go, my lord,
his guilt is, I have already reason to believe about his guilt. Why I require further?
my lord, I've been assisting, my lord, paragraph 8 also, my lord, I will place. Further, the custodial interrogation of Sri Yogesh Dua is required to ascertain the trail of proceeds of crime involved.
Yes.
My lordship. Custodial interrogation Sri Yogesh Dua is required to ascertain the trail of proceeds of crime involved, names of the further beneficiary of the accused proceeds of crimes involved, 3, role of other alleged suspected persons involved in the above said laundering of proceeds of crime, and to identify the nature and manner of siphoning of the proceeds of crime. 4, to identify the properties, movable, immovable, acquired from proceeds of crime by the accused person and other related persons of the said accused, Sri Yogesh Dua.
This is not to ascertain his guilt as they have submitted. This is because police arrested 12 persons. I have only taken 2.
Now, my lord, to the first submission, my lord, investigation is in progress. I have materials there, and my lord, in maybe very happily worded, but I have stated that what investigation I have undertaken under the PMLA Act for the proceeds of crime, and I have come to a conclusive finding from the materials on record, which I am in possession of, that he is guilty. So, my lord, it cannot be said. Now, my lord, may I place that? Lordship.
You registered the case on 24/3/2025.
Lordship.
You prayed for the production warrant on 3/4/2025.
My lord, third, my lord.
So it's only 10 days.
Lordship.
In 10 days, what were the materials in your possession?
Produce it before my lord. Produce it. Now, my lord will kindly allow me to place the judgment which have been cited by them, my lord. 2025 to onar cite করেছিলেন না? Radhika Agarwal. My lord, the Radhika Agarwal judgment. If my lord allows me to place page 17, my lord, may I read, my lord? Page 17, my lord, it is being quoted, my lord, from Arvind Kejriwal's case, my lord, which says, my lord, last paragraph 67, there is the internal paragraph at page 17, which has been quoted. Error in decision-making process can vitiate the judgment decision of statutory authority in terms of section 19(1) of the PML Act. A decision-making error can lead to the arrest and deprivation of liberty of the arrestee. Though not akin to the preventive detention cases, but given the nature of the order entailing arrest, it requires careful scrutiny and consideration. Now, my lord, the second portion. Yet, at the same time, I emphasize, Lordship, yet at the same time, the court should not go into the correctness of the opinion formed or sufficiency of the material on which it is based, albeit if a vital ground or a fact is not considered on the ground or reasons is found to be non-existent, the order of detention may fail. Now, my lord, so what I am on is that, my lord, sufficiency of material, correctness, the words which have been phrased by me in grounds of arrest or in reasons of belief, if it is not substantiated with the materials which I am going to produce before your lordship, if my lord so deems fit and proper, then, my lord, a case which is being, my lord, championed for by my learned senior friend, my lord, stands. Otherwise not, my lord. Because just on mere reading of reasons to believe and framing a particular notion in the mind that I have no materials to substantiate that an arrest is imperative, or that I did not have proper reasons to believe in my mind, along with substantiated by reasonable materials on record, which have come into existence through my investigation, which is properly done by me in the aspect of money laundering or in the aspect of proceeds of crime, then, my lord, they have a good case. Otherwise, just quoting certain facts from the investigating agency's charge sheet, or what was some others which were there on record, which was a lead to us, and then we tried to amplify on those lead, and we came to a conclusive finding that yes, reasons to believe are there for his arrest, and custodial interrogation is all required. Under these circumstances, this is a nascent stage where a writ petition could have been moved on a particular notion that just because it has not been happily worded, they have come to this finding that because this word is not there, which they are not entitled to do. My lord, I don't find, my lord, anything else to amplify upon, my lord, as far as my argument is concerned. And, my lord, as far as 19(2) is concerned, my lord, we have complied with it immediately, which is the statute in his wisdom says, 19(2) says immediately it has to be complied with. We had complied it immediately. That also forms part of my lordship. So, my lord, in my respectful submission, my lord, at this stage, declaring the arrest to be bad in law, just because the reasons to believe and were not substantiated with materials, will be a tall order. As far as the argument forwarded by my learned senior friend for the petitioner in this particular case, my lord. Case, my lord, my lord knows about the case, my lord, what it is. My lord will kindly, since my junior is saying,
the materials you have collected, let me see.
My lord knows what the case is all about. I need not.
And there are so many flags. So for your lordship convenience, I have marked some pages with blue flag. Your lordship has indicated the period from ECIR to arrest. Between that, what was vital in our hand?
Down, down.
My learned brother may also pass on, my lord, the material which he has sent to the adjudicating authority, though he claims to have sent after 3 or 4 days, but not that immediately part I'll address, my lord, but that material ought to be seen. Was it the same material or not? Your lordship may see that also. What has he sent to the adjudicating authority? Because that material he was obligated to send in a sealed envelope.
That last flag, your lordship will find some serial number. Last flag, your lordship will find serial number 6.
6.
Last part, one flag is the committee who decided to take up the matter. Kindly see the members present in the committee, and this is in the month of January. My blue flag.
Blue done.
Now,
Our blue key is
after ECIR, thereafter your lordship will find the next one. Well, is it an email?
no. It's a cyber email. His email.
Email date kindly my lord will note. Then my lord will kindly go to the whose email and the next page. The next page is folded. Bunch of pages are folded. Your lordship will look into those pages. Next, my lord.
Just 1 minute.
Yes, madam.
This period of digital arrest, the date of this complaint of this data is.
Now, one complaint, my lord. We are today now taking leave of my learned senior.
Yes, my lord.
We are today, my lord, that was a triggering point. My lord,
That
we have
may be
found.
your triggering point, but under the same ECIR, are you doing all the cases?
Yes. More than 100 FIRs we have now located.
So where is that?
Throughout India.
You could have located, but then that is not part and parcel of.
Yes, yes. It is there. I can show.
But your ECIR only.
My ECIR, my lord, ECIR, your lordship knows. ECIR we recorded with respect to one particular FIR, which is having the scheduled offense. But ECIR we can amend and we can add much more FIRs if with the passage of time we get that information.
No, that is today. But on that third.
On that day. That is why I am not referring to that. On that particular day, what was there with in our hand? That is on 4th. It's exactly 100 in number.
This ICICI Bank account has any relation between this Chintak Raj?
This is his account.
Rakesh?
This is his account.
His account, any financial transaction taking place between the two accused persons?
These two?
Huh?
No.
No.
From anonymous bank accounts, which are fraud. We have verified, we have found, your lordship will find, I have given, we have found no existence of that person. These all accounts are being handled, being transacted through mobile phones. These SIM cards are purchased by Chirag in Kolkata or eastern region of India and transferred through DTC courier to Delhi. Another person named Onkar Singh collected it. Onkar Singh is an employee of this Jogesh Dua and Aditya Dua and handed over that to Jogesh Dua. And Jogesh Dua distributed the SIM cards among several other employees who started transaction with these bank accounts. Whenever it goes, cash is withdrawn. This is the cash transactions I have indicated.
Cash transaction, how?
Now these amounts are coming into this account, transferred. Suppose, I am giving one simple hypothetical example, which is a fact in this case. This person have been digitally arrested and he has been asked to transfer.
I'm not on that. I am on the part transfer. Cash withdrawal is by two modes only, check and ATM. There are no other modes. So
this is in his account. But that's why I'm saying, suppose one person has been asked to transfer a particular amount into a particular account. Once he
1 minute.
Yes.
You see over here, at a point of time in this account, money went up to 50. This is what? 54,735 crores.
Maybe.
Or credit. This is crores or credit?
But I need to know credit. Credit. CR means credit.
Credit. So this is his exclusive account.
Right.
This is the exclusive account of this one.
That ICICI, the folded one.
The folded one, even if this is
32 lakh cash.
That is coming from where?
That is what I was saying. Some person transferred into an account, which is in the name of a fictitious person. That amount immediately transferred into 5, 6, 7, 10 accounts. Those are also fictitious accounts. Now the cash has been withdrawn from that account within 1 day by using that ATM card, and that cash amount went to these persons. They deposited it in their account and thereafter they transferred it again. This is the modus operandi in the bank account. Because my lord, my learned senior friend opposite was saying before your lordship.
Date of commission of this 47 lakhs is when?
Hello?
That the date of this 47 lakhs deposit.
20, 12th of June, 2024.
Complaint lodged on
17th of June, 2024.
So wait, that part of the money reached over here by, how are you going to prove?
That we cannot prove before arrest. Today we are before your lordship to show what was in our hand on 4th to satisfy 19-1.
No, this is that particular movement of money must be there over here clear to you. That is why you should arrest a person.
My lord, my learned senior friend was started this argument by introducing his client before your lordship, that he is a chartered accountant. Correct. Now, my lord, a chartered accountant having so much of cash transaction could not be explained where from he is getting this money and where from he is involved using this. A chartered accountant is not a layman.
I understand. That's a separate point totally.
That's the point of starting of our
You are not arresting all persons who are making cash transactions.
No, not at all.
Something to do
Now,
connected
kindly
with this
come to
case.
the order of the Delhi
Connections,
High Court.
Milord. Everybody is doing Milord, but the connections, Milord. Omkar. And then the account, fictitious
Order of
account
the
which
Delhi
he was
High
having.
Court. Order of the Delhi
understand.
High
And Milord, Delhi High Court order is also very, but I'm not on that, Milord, because
You just tell me one thing from here. Have you got a tabular chart regarding the transactions concerned? Receipt of the money? Or you are basically for the time being on the SIM cards which have been in transaction?
So both, my lord, both. SIM cards, ATM cards, courier, linkage between the person. The Kolkata police arrested 12 persons. We have not asked for the other 10 yet because we are not whimsical. What my learned friend was saying.
No, just
It's not arbitrary.
I understand, but you are investigating the proceeds of crime.
The trail of the money.
You are not investigating the intent and all those what the criminal.
Not at all.
Now you tell me. So therefore, there is a difference between a suspect, simple suspect,
Yes.
and a guilty person.
He's a guilty.
So if that is so, what is the movement as of, because 2nd of April you got this.
Prior to that, we got that certified copy of 10th of March. We got the order of Delhi Honorable Delhi High Court on 25th of February. Those are all there.
So Delhi High Court decided.
But kindly come to the Caesar list.
A remand application.
No.
Delhi High Court.
Well, the finding, because what happened, I tell in 1 minute. Kindly allow me 30 seconds.
Delhi High Court.
Kolkata police arrested him. Magistrate denied the transitional remand. Kolkata police went before the Honorable Delhi High Court. The exact submission of the accused person before the Honorable Delhi High Court is what before your lordship today. I am no way connected. My brother may be connected. I am not.
That every accused will come and say.
Yeah. Now the Delhi High Court, Honorable Delhi High Court in the order has given a paragraph saying that
What have you given to the adjudicating authority? What letter have you sent to the legislature?
See, it is there.
Page number?
I need to.
At least I can get some clue actually what is that material.
Everything I have given to you. But if my learned, as my learned senior was saying, that if my learned friend now questions the.
Milord, somewhere we have to, certain Milord, we are an investigating agency, Milord. There is a presumption that we are bona fide. Materials are there, Milord. Now, amplification of there, where it will reach, the ending result, this is a totally different. But my arrest, whether it was with materials on record or not, that we have enough. Now, Milord, maybe linking it, Milord, because such amount of cash transaction, Milord will kindly appreciate that the person who is doing these cash transactions, he takes all the precautions by doing that. Now, Milord, the other circumstantial evidences or the other circumstances where such a huge amount of cash was deposited in his account, SIM cards, the person working under.
What have you attached? What is your provisional attachment?
Well, provisional attachment.
No, not yet. We have identified.
Identified means adjudicating authority. Have you sent anything till today or no?
That 19.2. 19.2 we have sent.
What have you sent?
We have sent all these materials which we were having prior to arrest, including the grounds of arrest, arrest memo, reasons to believe, as per the law and the rule. साक्षर वाला लेटर कहाँ है निकाल लीजिए this is the covering letter I am showing, and your lordship will find everything thereafter, including the index as per the rule. Dada ekটু দেবেন, please. Sorry. আপনাকে বারবার পরিশ্রম করাচ্ছি. Sorry. But this is the covering letter. If your lordship turn it, your lordship will find the index under which we have mentioned all the things as per the rule. If your lordship wants the rule, I can show you. কি কি দিতে হবে
আর কি হবে এখন 6টা বেজে গেছে
না দেখিয়ে দিই না।
দাদা বুঝে গেছে যাও
Mallet, one particular blue flag your lordship might be required to look into. What we have found to be maintained by the accused persons. That was prior to arrest.
Yes.
The Mallet will kindly take those blue markings, blue flag. Your lordship will find one of the blue flag, your lordship will find one color printout. Kindly see. Any color printout. If that is a color printout, your lordship will turn that page. Yes, for three pages there. Well, this is, kindly come to the first page of that flag. Kindly see the only difference, which is the only difference. Kindly turn on. Kindly see at the right hand side, there are 3 logos. That is the only difference with the original one. And this is the management by the persons who are accused in this case was sending these notices. What more do I require to find this person to be guilty of this offense? Well, this is the rule. If your lordship wants to cross-check that what I have sent, whether in compliance to the rule or not.
No, that is all right. But
yes.
The accounts where money has been sent belongs to whom?
Yes, I have identified. I have a trail. I have found that most of them are fake and in the name of employees of this person.
That is what I am. Employees of this person means this person or the Chintak Raj?
No, my lord Chirag Kapoor is basically manager of these 2 Dua brothers. We'll prove in course of our investigation. They want to say Chirag is all. We are nothing. Chirag is nothing. Chirag is manager. We'll prove it in course of our investigation. This is an offense where the Prime Minister is concerned. Every time we call anyone, today we are listening to this. And my learned senior friend trying to show the technicalities of 19.1, 19.2.
These are no more technical, sir. ACS, you have not been successful in the Supreme Court.
My lord, maybe in that particular case, but here, my lord, after that we have also become much wiser. Now we try to emulate because every day everybody is learning. My lord, to our resume.
Much more bigger stature escape.
Even my learned senior was showing from that order of the Honorable Supreme Court. Supreme Court has said sufficiency of the material cannot be questioned.
Well, there will be investigation is going on, but we
are not
neither our officers or orators nor writers. So, my lord, as far as reasons to believe it, they are not very happily worded, but that does not mean investigation.
Either. Yes.
May I take my lord's leave?
না না জোড়া কিছু একটা বলবি,
Yes, Mr.
কিছু একটা বলবে, এক সেকেন্ড
আচ্ছা ঠিক আছে
এক সেকেন্ড রুক যাইয়ে স্যার।
That, my lord, there is a form provided for 19.2. Entire material is sent to the adjudicating authority. That, my lord, they have not shown. I don't know what is so secret about it. At least the compliance should have been shown. But, my lord, whatever it is, your lordships may just take into consideration.
Look,
19.2, they admit that they have sent, my lord, the entire material to the adjudicating authority, which formed the reasons to believe. So please have a
It
look.
was on that date.
On that date.
On that date.
On that.
On that date, I have seen.
My lord, the 3 days later, they have sent it.
Yeah,
So, my lord, please have a look.
it was a holiday.
Just a moment. My lord, I'm just telling you, lordships, the format. There is an index that they make and say that this is the material I'm appending and the append reasons. So your lordships may just have a look at that document. I don't know whether your lordships have seen that particular document where they've shown compliance with 19.2. That your lordships may see. I don't
have
want to
seen
see
that. I've seen that.
all of it.
But the format part will not fit that. They have just typed it out.
My lord, I'm saying, so my lord, exactly what they've sent. This is a case diary, my lord. Nobody, God knows, my lord. There is no judicial oversight here. Your lordship knows, my lord.
I have seen just now. I have seen that.
Please, my lord, that day, my lord, judicial, this case diary is produced before your lordships today.
The case, this is not of today. This is of the month of April.
Correct, my
April.
lords. But April case diary was not shown to any court.
Yes,
Only
it was shown on 8th of April. My learned friend is senior
please
friend
allow
is
me.
not aware.
It is not countersigned by the judge. Is it
It
so?
is not required.
A case diary is, my lord, the case
What?
diary is countersigned. my lord. Allow me,
Present.
allow me just a moment. my lord.
I was present.
What I'm submitting is, my lord, when 9 Vairis was upheld, I read your that paragraph of Vijay Madan Lal Chaudhary to your lordship's lord. The Supreme Court said, instead of a judicial oversight, there is an oversight of the adjudicating authority, because whenever they arrest a person, they are obligated to send the entire material immediately in a sealed envelope to the adjudicating authority. So, my lord, your lordships may have a look at that particular document. That's what I'm saying. my lord.
Dispatch.
I'm not doubting, my lord, their case diary. I'm only authenticating it further. That, my lord, if it was so in existence or whatever material was there, it ought to have been sent. So your lordship may have a look at that. That's
What
all.
is your idea regarding material in possession?
I am not. My brother is
I'm just
absolutely.
asking you. I'm just asking you.
My lord.
What should be
Correct, my lord. I'm
suppose
grateful, my lord.
you have got
As an officer of the court, I will state. my lord.
tappings of the material till
Correct,
now
correct, correct. my lord.
regarding the fact predicate
Please, my lord.
offense,
Please, my lord.
as also they have investigated
Correct,
in the
correct,
case.
correct. my lord.
What should be the material in possession?
My lord, I'll just, my lord, say, if my lord calling upon me as an officer of the court, I'm not taking any sides. In fact, my lord, I'll support my learned brother with his great erudition. He was so right in, my lord, saying that they are not orators, they are not good writers. I will not leave it at that. I'm not asking them to write. I'm asking them to index. It's, my lord, the requirement of law. Unfortunately, requirement of law that your material should be of that quality which should lead to guilt. So, my lord, when in Arvind Kejriwal for the first time, the Supreme Court was asked to interpret what would be the meaning of the expression material. I'll borrow from them, my lord. The Supreme Court said, look, sufficiency of material and prerogative of lies with the officer. The court cannot substitute its opinion. Your lordships are not sitting appeal. I cannot possibly argue, and I have not argued. Let me clarify to my learned brother. He was not here, so I must clarify my position. I absolutely support his stand. I am not here to argue, my lord, that please check sufficiency of material. I am only, my lord, on two grounds. One, Supreme Court has used the word that, my lord, material ought to be visible in evidence. My lord, Supreme Court uses that line which I'm using. My lord asked, what will be the material? They said it could be in the form of documents, and obviously, my lord, documents admissible, or statements. Now, statements, my lord, can't be any other forum of statements recorded by them. So within those 5 days or 6 days, when they, my lord, moved for production warrants and my arrest, what statements had they recorded under 50? I do not know, my lord. They have not stated that. Unfortunately, that, my lord, the entire grounds of arrest and reasons to believe are in the form of a factual narrative by the officer. It's like an essay. It's his story. So I just showed that, my lord, that order of the Supreme Court the other day, that
But
they write.
I believe in the affidavit in opposition, they have said they have got the statement of Omkar Singh.
No, my lord, I'll just explain.
We have not yet.
No, that you may not have you recorded.
We can
Well, I'll
statement if your lordship
in
want.
rejoinder,
If
I'm going to.
The petitioner's wife herself admitted in the statement that without any commensable business in this regard, everyday cash was coming through courier and being dealt with.
All right, my lords. When was that statement recorded?
And now he I have not showed that.
I'm
That is
talking
what-
of arrest.
Because we are up
Is
to
is she my wife whose statement is recorded? I'm not married. What are you saying?
No, my lord, the elder brother.
Elder brother.
The sister-in-law. Sister.
So, my lord, this my brother's wife, who's according to them the principal accused, I'm just, my lord, a scapegoat here because he's not available. So his family is, my lord, whole family is doomed. I'll demonstrate, my lord, from there. I am not, my lord, going into any contradictory fact with them. I'll read their ground of arrest. I've reproduced, my lord, in my rejoinder. Just point out that. And what is their stand there and what is their stand in the affidavit. You can't collect the material later. The statement of the wife of my brother is recorded probably a few days back, just before during the course of the hearing. Everybody is being summoned. My eldest brother was called a few days back. My father, who has undergone a bypass surgery, was called a few days back. I'm not on that. I did not bother your lordships with those facts. Their prerogative is to investigate. They must investigate. That's their duty. What I'm submitting before your lordships is they can't put the cart before the horse. The statute provides a thing to be done in a particular manner. All other modes of manner are forbidden. You had to have material to arrest when I'm guilty. You could not have arrested me for the purpose of investigation. You could not have said, look at the, my lord, fervor with which these investigating officers' sentiments were conveyed. We will prove it that he is the ultimate beneficiary. Everybody else is there. What is this, my lord? Is this the investigation which is objective, which is scientific? Or is it the ipse dixit of this officer? How dare you file a writ petition? How dare you challenge my authority? How dare you question me? How dare you say that my action would be covered under 62 of the Act for a vexatious arrest? This is the manner in which, my lord, things are happening. So your lordships will judge us nowhere else, but purely on the scope of the documents. So grounds of arrest, a story without referring to any date on which anybody's statement is recorded, without referring to any document on the basis of which it is recorded. How English is nobody's mother tongue, my lord. Language is nobody's constraint. I give full marks, my lord, to my learned friend's argument, and in fact, I will, my lord, vouchsafe that he's spoken better than me on that subject. I acknowledge it fully. He very well said, my lord, I'm not looking for an English language from the officer. I could not have, and I shouldn't be. What I'm expecting from him is an objective narration of material on basis of which he has arrested me. Otherwise, what is the fun of giving me reasons to believe? When the Supreme Court says give him the reasons to believe and communicate him, is it a formality? Why would you do that? You are still, my lord, violating the spirit of the Supreme Court judgment. In, my lord, actually, it is violation of the spirit. It is an affront. And in affidavit, I'm astonished. It is filed before the highest court of the state. And again, a factual narrative. He doesn't say, no, my lord, there is complete deviation. Your lordships read that. My learned brother tried to cover it up by saying that, my lord, he may have used some other language. There is total deviation. I created this account. I created persons for stamps, judicial notary, etc., recovered. Everything is said in the grounds of arrest. Everything taken back in the, my lord, in the affidavit filed before your lordship because it was not true. So where does he write from? And how is Chirag Kapoor's antecedents or his conduct or demeanor relevant to me? He even goes on to the extent in grounds of arrest saying that based upon narrative from me, whatever he disclosed from me by the, my lord, police at that time, the Chirag Kapoor was arrested. Contrary, my lord, it is totally to the contrast. Chirag Kapoor was arrested way back in January 25. Where was the question of, my lord, that? So I have, my lord, made a table there, and I'll just point out so that your lordships can objectively decide. Today, my lord, the question is, my lord, I'll humbly beseech with the age-old criminal jurisprudential principle that is, my lord, that your lordships will dispassionately analyze as best to the spirit of the law has been, my lord, followed or not. History of liberty is history of procedural safeguards. That's what I'm all about. If, my lord, I'm able to demonstrate even prima facie that some extraneous material, my lord, I'm carefully using the word and borrowing it. If some extraneous factor, of which I call it material, has gone into the mind-making formation of this officer, the, my lord, arrest is vitiated. If something, my lord, relevant has not gone into his mind-making formation, the arrest will be vitiated. So on both the counts. That's what my endeavor is, and I'm borrowing nothing but from, my lord, Kejriwal's case, where, my lord, I always say it, my lord, it's a great leap forward. So, my lord, the Kejriwal's case relies upon, my lord, Khudi Ramdas. My friend, my lord, saves the officer by saying something he may have written, he could have worded it better. because that's factually incorrect. It should have been attributed to somebody else. It's being attributed to me. I will not go with a 4 judges bench, my lord, of the Supreme Court, Khudiram Das, because Supreme Court has equated, my lord, Article 22(1) and 2 as akin to 22(5) in the realm of preventive detention. How does a human mind works? Just one paragraph. I just wish to read, so that your lordships would, my lord, relate with the resonance in which, my lord, Arvind Kejriwal now resonates it. But this was the age-old law. Khudiram Das. Para 15, my lord, if your lordships would have. It's 4 judges. Honorable 4 judges. Now the proposition, my lord, this is at page 20 of the judgment. Pagination is on the top left. Your lordships have it. Now the proposition can hardly be disputed that if there is before the district magistrate material against the detenue, which is of a highly damaging character and having nexus and relevancy with the object of detention and proximity with time, when the subjective satisfaction forming the basis of detention order was arrived at, it would be legitimate for the court to infer material must have influenced the district magistrate in arriving at a subjective satisfaction. And in such a case, the court would refuse to accept the bald statement of the magistrate that he did not take such material into account and excluded it from consideration. It is elementary that human mind does not function in compartments. When it receives impressions from different sources, it is the totality of impressions which goes into the making of a decision, and it is not possible to analyze and dissect the impressions and predicate which impressions went into the mind making of the decision and which did not. Nor is it an easy exercise to erase the impression created by particular circumstance, exclude the influence of such impression in the decision making process. Therefore, in a case where material before the magistrate is of a character which would in all reasonable probability be likely to influence the decision of any reasonable human being, the court would be most reluctant to accept the ipse dixit of the magistrate that he was not so influenced. And a fortiori, if such material is not disclosed to the detenue, the order of detention would be vitiated, both on the ground that all basic facts and materials which influence the subjective satisfaction of the magistrate were not communicated to the detenue, as also on the ground that detenue was denied an opportunity of making an effective representation. I just pause, my lord, and borrow that line. My learned brother said that, my lord, if you ignore this, we have said about proceeds of crime just now, my lord, before 5 minutes before me. My learned brother said, we have evidence about proceeds of crime. We may have said something which is not happily worded. They are not good orators, good authors. Taken, my lord. But if you mention something which is wrong, which is not supported by material, that means, my lord, that your subjective satisfaction of arrest, because you are passing an order of arrest in this case, unlike, my lord, CRPC, where arrest is made. Here it is an order of arrest. So when you're passing an order of arrest, if something is percolated in your mind which is not factually correct, or which is not borne out from the materials, you can't say, eschew this line, consider the others, because it is the totality which would work. And therefore, my lord, I'll use the word, my lord, used in Ram Narayan Singh. I read, my lord, from that judgment of Madhu Limai the other day, 3, my lord, lines, where, my lord, an officer of this stature, a premier investigating agency, feels, my lord, compelled to take away somebody's liberty, then, my lord, he must comply with the forms and rules of law in spirit and substance. He has no luxury to say that this man is very bad. I am telling your lordships, don't even entertain him. He should be thrown out of the court because I feel he is very bad, and I will prove it in the court of law that he is the worst existing person in this country. Therefore, don't, my lord, consider his case as of now. I'm sorry, my lord, that argument is unknown to the basic tenets of criminal jurisprudence. Your lordships will judge me on the first standards. Yes, I don't want your lordships to sit in appeal. I cannot say that. Your lordships will never sit in appeal. Officer's prerogative. But, my lord, if I'm able to demonstrate prima facie that, my lord, this was a witch hunt exercise, this gentleman appears to have exercised his powers without, my lord, following the rule of law, then, my lord, the consequential orders ought to follow. So, my lord, I'll demonstrate from, if my friend is done, I interjected because, my lord, there is only some part of the rejoinder from which, my lord, I'll show. I have compared their, my lord, their grounds vis-a-vis, my lord, their affidavit before your lordship. And I find them to be totally at variance and contrast. Please, my lord.
No, I'm going to hearing it, Weapon. Millet, just Millet, nothing more, Millet. I have already concluded, Millet. The only thing is, Millet, again, I'm coming, Millet, with the judgment which was cited by my learned friend as far as happily wording is concerned, Millet. Millet, under 226, Millet, the scope is very limited. My lord will have to see that whether whatever we have stated is being substantiated by our case diary and materials. If it is not there, and my lord, as far as the case diary is concerned, it was taken into consideration by the trial court also on 8th. And that is forming part of the order. And secondly, my lord, again, Arvind Kejriwal, I'm saying, because that is the judgment which is on this particular act. And the 4 judges bench judgment, which is being cited of 1975 of Khudiram, is on a entire, the horizon is much larger with regard to the general law. Now, my lord, as far as Arvind Kejriwal, paragraph 42 is concerned, it says that we would accept that in one-off case, it may be feasible to reveal all materials, including names of witnesses and details of documents when the investigation is through. This will not be a position in most of the cases. So, Millard, it is said, Millard, that we are not supposed to disclose all the witnesses and everything. But what caution is there? DOE may claim redaction and expulsion of specific particulars and details. However, the onus to justify redaction would be on the DOE. The officers of the DOE are authors of the reasons to believe. So, Millard, whatever I state, I am not supposed to give the names. I am not supposed to disclose the witnesses. Nothing in that. It is only at the later stage that I have to justify that. Not in this jurisdiction, very respectfully under 226.
Lord, in a comparison, in a lighter way, my lord, I did that in Pankaj Bansal. I happen to be, my lord, the counsel. I showed, my lord, how grounds of arrest are served across the country. And that's why, my lord, that finding came that they have to serve grounds of arrest with consistent. I must show to your lordships, my lord, grounds of arrest in at least 5 different states, including Delhi, Bombay, Gujarat. Not only statements, name of the persons, my lord, the documents, the materials are completely referred to in the reasons to believe and grounds of arrest. As my lord Kejriwal says, they could have claimed redaction. But here, my lord, this gentleman thinks everything is his prerogative. I will not tell you anything. I am not supposed to disclose you. It is my prerogative. You will influence the witness. That's, my lord, his ipse dixit. On what basis is he concealing from the court also? Because he makes a writing. He is, my lord, denying me an opportunity to rebut. What if the statement is recorded of a person who is a dead man? And I can prima facie demonstrate that. What if a person who is stated to be a male happens to be a female? Why are you denying me that opportunity? You are arresting me. How am I supposed to defend myself on day one? Because you write an essay that, my lord, I'm a very bad man. I have committed X, Y, Z, and therefore I ought to be arrested. That's, my lord, with utmost respect. So, my lord, as I said, it's a narrative. Please go to, my lord, my rejoinder. And that's, my lord, my short rebuttal before, my lords. I won't take much time. I'll circulate a written note, my lord, subject to your lordship's leave and liberty. Please have a look at, my lord, paragraph A10, my lord, at page 29 of my rejoinder. The affidavit, my lord, we call it affidavit here, my lord, in opposition to their affidavit. Reply, my lord, in opposition.
Yes.
My lord, page 29, your lordships have it. In order to expose the falsity. Paragraph 10, my lord, starts at page 29.
Yes.
My lord, I've extracted in A, my lord, this is to expose the falsity, hollowness, and lack of substance in the case set up by the ED. In both the reasons to believe and affidavit in opposition, following aspects are apt to be highlighted. The, my lord, averments in 2.4 of the grounds has been entirely omitted. Please mark this, my lord, they have omitted this allegation. And what was the allegation? My learned brother read that. During the course of investigation, several incriminating items, including bank passbooks, checkbooks, in the names of various companies, banking opening kits, judicial notary agreements, company lists, phone numbers with attached SIM cards, activated SIM cards, keypad phones, smartphones, hard disks, and routers were recovered, seized by the police, and subsequently a total of 12 persons have been arrested by the CBI till date. Now, my lord, this aspect has been completely taken away. Now, my lord, please see, and how is it relevant, Kwame? Was any recovery made from me? Zero.
Nothing, my lord.
My lord,
Nothing
may I
seized.
take my lord's leave for just 30 seconds, my lord?
See, my lord, Nabi. Apparently, there is nothing to substantiate the said averment, and therefore the ED conveniently eschewed the reiteration of the same in affidavit. In para 2.7 of the grounds of arrest, at page 3, it was stated, therefore, from the above it is seen that Mr. Dua and Chirag Kapoor are the key accused persons who are involved in commission of cyber frauds. Please mark this, my lord. However, in none of the subsequent paragraphs 2 to 6 could the petitioner's role or involvement be even remotely traced. Now, my lord, I refer to paragraph 2, Roman 2 to 6 of, my lord, their grounds of arrest. Please refer to, my lord. Who was the proprietor of Brainburst? One Miss Burney, not me. Searches conducted at the premises of accused resulted into seizure of incriminating documents, checkbooks, etc., various entities. Last line, my lord, of Roman 2 of mine. None of these was seized from petitioner's house. Number 3, cyber team revealed that there are more complaints registered against this account. No, my lord, I'm nothing to do with the account. It is not against me. During investigation, bank passbooks, checkbooks in name of various companies, opening kits, my lord, the same thing, were recovered. Last line at page 31, my lord, on top. None of these were seized from petitioner's home. Then, my lord, apparently wrong sequence of arrest of petitioner and Chirag Kapoor has been mentioned in the grounds of arrest. Yogesh Dua was arrested from East Delhi by Cyber PS Kolkata, and further, based on financial and technical information, one more accused person, namely Chirag Kapoor, was arrested from Bangalore. Now, my lord, it is an undisputed fact on record that Kapoor was arrested on 9th January. I was arrested, my lord, on 23rd February. How petitioner who was arrested after 45 days can provide information in the past? Now, my lord, G. In the grounds of arrest, Chirag Kapoor has opened a company named Legacy, through which he recruited other accused. Therefore, my lord, how the petitioner was implicated remains a matter of imagination of this officer. This is my comment. And he had, this was his allegation that he had, my lord, opened a company and recruited other person. See, my lord, my lord, I on page 32. Original reliance on incriminating bank transactions as stated in para 3 of the grounds of arrest has been significantly altered in the affidavit, which now refers only vaguely to articles stroke properties. This radical change not only dilutes the specific financial allegations originally made, but also tantamount to lack of substantive evidence to support those claims. In para 4 on page 3 of the grounds of arrest, petitioner was initially alleged to be a close associate, active collaborator of Chirag Kapoor, allegedly involved in recruiting other accused persons and coordinating with banking personnel to open and operate fraudulent bank accounts. However, in stark contrast, the affidavit attributes all these actions solely to Chirag Kapoor, creating a significant inconsistency in the ED's narrative and rendering the credibility of the initial grounds of arrest and reasons to believe to be non-honest. Further, the averments in the grounds of arrest, on the next page I'm reading, that bank account transactions among Chirag Kapoor, petitioner, and other accused persons were unearthed during the course of investigation have been conveniently omitted. My lord, may mark this, my lord, because there is none. This omission itself leads to potential inconsistency and blatant exaggeration in the allegations made at the time of arrest, thereby eroding the very basis of arrest. In the grounds of arrest, page 3, para 4, line 3, Chirag and Yogesh recruited other accused in the instant case for the purpose of extort proceeds of crime for innocent people across the country. They were in contact with different banking personnel and opened various bank accounts in the name of different persons. In contrast, para 2.6 of the grounds of arrest, it clearly states Chirag has opened a company named Legacy through which he recruited other persons and committed different bank offenses. In the next page, if you lordship go to ground N. In fact, what is stated in para 2.6 of the grounds of arrest is the version in the FIR and charge sheet submitted by the cyber team. Also, no accused persons has ever implicated the petitioner in their statements. They only named Chirag Kapoor as one of them. Your lordship may omit this factual part. I'm just not stressing on what is their own inconsistency. My lord, see O. In fine, the averments made in para 4 of the grounds of arrest, placing Chirag and petitioner on the same pedestal, tantamount to fabricating accusations just to justify blatantly illegal action of arrest. Para 4 in the grounds of arrest states, upon further investigation, it has been revealed that large sums of money were transferred into the bank accounts of Chirag Kapoor's companies and into accounts opened by Chirag Kapoor. Now, my lord, this allegation, my lord, ED itself thus concedes
that it has never been found or revealed that petitioner was at all involved in any of those companies, coupled with the admitted fact that no financial transactions or cash deposits were ever made into or from the petitioner's account into any of the person's company's accounts. I am not vouchsafing it. Where is the evidence of my personal account having been ever traveled? What is, my lord, is a figment of, my lord, imagination. Why imagination I'm saying, my lord? Because you had yet to, my lord, record credible evidence. Gather it. You have, my lord, put the cart before the horse. Because now you have to justify arrest. You will, my lord, nail him down in every which way. That's, my lord, a different, my lord, prerogative. Whatever is collected till date, I'm not bothering your lordships to read. I'm, my lord, bothered is whether on day of arrest was this material in existence from which, my lord, he is making these inferences. These are all inferences, what, my lord, is mentioned in the grounds of arrest. But whether they were, my lord, justifiable. Lord, please go to the next page, page 35. Para 5 of the ground arrest. Investigation under PLA has further revealed account transactions among Abhishek Sharma, Laltu Heather, the other accused, and several cash deposits in the accounts of Chirag Kapoor, which are incriminating in nature and arises suspicion. It is respectfully submitted that relevance of this point as a ground for arrest of petitioner is questionable, as it makes no mention whatsoever of petitioner's involvement in the transactions, including this statement in his arrest grounds appears to be both misplaced and misleading. So what you do is, my lord, you will write everything against everyone. You are arresting me. It's my guilt which is the subject matter. Tell me how this allegation corroborates with, my lord, this person called Chirag Kapoor. Have I ever met him in my life? Or have I seen him first time in the jail now? My lord, that's a different question. I am, my lord, bothering your lordships to see, my lord, at pains to see, my lord, that nobody ought to be arrested in a fashion where, my lord, the officer believes him guilty. It's a sacrosanct duty to conduct investigation, but not to judge. It is his duty to be fair, impartial, free from bias, free from prejudice. Here, my lord, it is totally to the contrary. Now, my lord, please see para number 8 of my rejoinder. In para 6 of the grounds of arrest, in view of the investigation conducted so far, it is found that Yogesh and Chirag has acted as main kingpin. Now, my lord, please mark this, very important. In the whole scam by way of creating various companies, appointing other accused persons as employees under those companies, opening bank accounts in the name of those employees and several other persons, forging documents with logos of several reputed organizations, and arranging several other tools for above described scam. Now, all this was, my lord, only with Chirag. They took my name in grounds of arrest. Now, grounds of arrest allege, this, my lord, I've tried to write, and I'll put some, my lord, soul into it. They allege that petitioner, along with Chirag, acted as the principal kingpin in the alleged scam by creating so-and-so forging documents, components, fraudulent scheme. However, just skip one paragraph, my lord. However, in stark contrast now, the affidavit filed by the respondent ED, para 7.2, page 7, attributes the creation of fake firms, opening of bank accounts, handling of documentation, training of account holders solely to Chirag Kapoor and his staff. The affidavit clearly describes the entire process, that is from formation of firms to account management, was carried out by Chirag Kapoor, with the bank account kits eventually being handed over to petitioner merely as beneficiary. Now, he, my lord, claims that it was given to you as beneficiary. Now, my lord, that's also a debatable issue, my lord. If it was, my lord, in whichever capacity. I am, my lord, here again, my learned brother would be right in saying that, my lord, probably I'm drawing your lordship's attention to sufficiency of material. That's not my aim. My aim is to point out how this officer can vacillate. How can he contradict himself? How can he eschew something which he had written now? Was there any justifiable material? All right, my lord. That's for your lordships to decide, my lord. In this case, one of the other questions is, my lord, irrespective of the fate of my case. As to, my lord, what should be the nature of grounds of arrest and reasons to believe? What broad portion of the material ought to be redacted? Whether 19.2 ought to be withheld from my gaze? Why, my lord? It had to be sent immediately. That's a judicial oversight, my lord, comparable to judicial oversight. That's why 19 was upheld. We said, we argued in Vijay Mandal Chaudhary, my lord, that happens also to be my case. We had argued that it should be like an FIR. There should be 24 hours. There should be judicial oversight. Supreme Court said, no. There is a word that immediately it has to be sent to adjudicating authority in Delhi or wherever it is, my lord. Therefore, my lord, there is an oversight. Why are you, my lord, not telling the court? So you took my remand without even sending the material to 19.2, under 19.2. What is the veracity of that case diary on that day, my lord? He should have frozen his case diary on that day, sent the material in sealed envelope, to the, my lord, adjudicating authority on that very day. That's the law I showed, my lord. Punjab High Court approved by the Supreme Court. Maximum 24 hours, but in any case, before the remand is granted. You have taken me next day to remand court. You take 3 days or plus to send the material. That itself vitiates the arrest, my lord. It's mathematical here. 2 plus 2 has to be 4. If you don't do it, you lose it. That's, my lord, the law. So in matters of personal liberty, my lord, your lordships have said, it will always be construed liberally in favor of liberty, not against it under any circumstance. So, my lord, therefore, I said, my lord, yet your lordship, when I was, my lord, telling your lordships to, my lord, see that, I just wanted to point out that he took 3 days to send that. I don't know what he showed to the court on that day, because it was not me who was seeing it at that point of time. So, my lord, your lordships may consider it from that angle. Now, my lord, if paragraph T at page 37.
No, just you tell me,
My lord.
what is the role of an adjudicating authority under the PMLA Act?
Oh, that's very, very interesting, my lord. In fact, I am very grateful. I've been confessing this, my lord, all along. And this is, my lord, nothing to do with the case. And I'll tell your lordships, my lord, what has happened here. And I'm, my lord, pained to say, and I don't know, my lord, how far my brothers will endorse this, because I'm arguing this in the entire country. And I believe something has borne out from Calcutta itself. And, my lord, which is that, what is the adjudicating authority and what is its role? So, my lord, money laundering, your lordship saw that the other day. Definition of money laundering is as given in section 3. And what is section 3, my lord? Offense of money laundering. So eventually, if somebody has to determine money laundering, even adjudicating authority is determining the offense of money laundering. So adjudicating authority, my lord, was a 3-member body. One of them, my lord, is from the field of law. Other one is, my lord, from the field of accountancy or finance. And the third one was, my lord, from the field of administration. Today in the country, of course, there's a raging debate, only single member body and member from administration, not even from field of law. And he's functioning as acting chairperson. So we are arguing, my lord, that entire, my lord, proceedings of attachment of properties are bad. And this entire, my lord, arrest being sent to that person who would, my lord, who's not qualified even to be a lawyer, would be, my lord, I would say, my lord, a travesty of justice. So it's become an empty formality. And that is why, my lord, your lordships will keep in mind 2 aspects, and I say it with utmost responsibility. 4 issues are pending before the Supreme Court. The first one is complete review of Vijay Madan Lal Chaudhary. It was listed, my lord, a few days back. We have been asked to make our submissions in writing. Matter is kept for July on reopening, my lord. A special bench has been constituted. This is the 3rd time a bench is constituted. This one would survive because the honorable judges would have some time to deliberate. Second issue, my lord, pending is adjudicating authority, what it should be. So, my lord, that is a special bench, a different special bench constituted, whether, my lord, it has to be a 3-member alone, not a single member, and whether, my lord, in any case, my lord, member from the field of law is necessary because he performs very critical functions, whether it is arrest, whether it is search, my lord, under 17. Material, again, 17.2 is akin to 19.2. 5, my lord, attachment of property. 5.2 is akin to 19.2. Immediately he has to send the material. So, my lord, in this fashion, your lordships are right, my lord. Maybe Vijay Madan Lal Chaudhary is re-looked at in view of the exigencies of the situation. And I told the Chief Justice of Punjab yesterday, and I'll quote him, my lord. I said, my lord, please have a judicial notice and just watch the proceedings before this adjudicating authority. And your lordships would be appalled. It's all, my lord, on, there is no physical hearing now there. It is all, my lord, online. And I can tell your lordships, my lord, there is no interaction. Just make your submission, send your note, and the order of confirmation will be posted the next day. So, my lord, there are several writs pending, and I happen to be the culprit there. Almost in every high court, writs are pending, but now matters are consolidated in Supreme Court, my lord. The batch is hearing. So, my lord, I have, my lord, my serious misgivings on an arrest and, my lord, adjudicating authority. Because, my lord, there were plenty of other aspects which we could not argue before, my lord.
That is what I'm asking.
Well,
Do the adjudicating authority has got any business with the arrest issue?
yes, my lord, because that material, which is, my lord, material word, your lordship will see the arrest.
Material is a subjective satisfaction when a judicial authority.
But, my lord, material is defined. Let me show you, lord. Give me the arrest. The lordships have which book, my lord? My brother has professional law, universal.
Lordship has that occasion to see that definition in another matter.
Yes, yes. Must have seen. My lord, please have a look at the arrest rules, we call it, my lord. Lord, in fact, I've quoted that in my petition itself.
2G.
Yes. So that you have another copy of any other act you have with the pair. Go to my petition, please. Take out my petition.
It's over here.
My lord, your lordships have the material. Right. Now, my lord, in Kejriwal, shall I show your lordships that line?
That I've seen.
Documents and statements. That's what Kejriwal says. That we have dwelled on the expression material, and that is how they dwelt upon it. Now, my lord, I would say, if your lordship would look at Vijay Madan Lal Chaudhary, what occurred to the Supreme Court at that point of time was that there is a safety valve, adjudicating authority. It will retain the material with it. It will retain with itself. There is a form prescribed, Form 2 and 3 under the arrest rules. I showed to your lordships, I think, during the course of my arguments, that this has to be acknowledged. It has to be sent. And then there is an acknowledgement. It is sealed so that nobody can tamper with that material that formed the basis of my arrest. That's, my lord, the necessity, because Supreme Court introduced for the first time the word necessity in para 322 of the judgment, my lord, while upholding section 19. And they also said that it could be vexatious. See, my lord, for a moment.
The only thing is that the rules do dilute the act basically.
Yes, act. And
because
19.2, my lords, may have a look at 19.2 for a moment. And I'll tell you, lords, something very interesting. 19.1 uses the word, my lord, material in possession. Please have a look at 4 words there in 19.1. Material in possession, reasons to believe, to be recorded in writing. Third is guilty. And fourth is, my lord, inform him of the grounds of arrest. It does not use the word order. But in 19.2, please have a look at 19.2 for a moment, my lord. My lords, have, my lord, 19.2. The director, deputy director, assistant director, or any other officer shall immediately, after arrest of such person under 1, forward a copy of the order along with. Now, order is never there, and order is not defined under the act. So, order is defined under that arrest rule, my lord, and order includes grounds of arrest, and that is what was looked at by the Supreme Court. I pointed that out before, my lord, the Supreme Court in Pankaj Bansal. That, my lord, order includes grounds of arrest. You have to send the grounds of arrest along with this to the adjudicating authority. And that is why, my lord, I said that order, definition of order is, my lord, under section 2. Under the arrest rules, my lord, your lordships will find the word order is 2H. The material is 2G, and, my lord, the order is 2H. Order means the order of arrest of a person and includes the grounds for such arrest under subsection 1 of section 19 of the Act. And then, my lord, there is a form prescribed for arrest order. So, adjudicating authority is definitely performing a function, was intended to perform a function. It may not have, that's a different matter, my lord. But, my lord, my only repository is that tomorrow when I go there, because if he confirms, and my lord may see, my lord, how intricate this is. Because whatever action this officer takes, he sends everything to the adjudicating authority. Search, seizure, freezing, adjudicating authority. Attachment, adjudicating authority. So, my lord, what happens is, because everything finally boils down to the adjudicating authority to confirm, ultimate aim of the act is, my lord, to confiscate the proceeds of crime. The arrest was, my lord, I would say, my lord, a power which is adjunct, which is my lord, corollary, but the legislature was very conscious. It abhorred arrest. It said, don't arrest a person. That is why, my lord, guilt, and I vouchsafe, my lord, I did this earlier, so I can say with some sense of responsibility, first enactment of such kind, at least to my knowledge, in the entire country. Today we have 1 or 2 more. We have SFIO of the same powers. But, my lord, in 2002 or 3, when this act was enacted, and 2005, when it was actually brought into force, 1st July 2005, only enactment in the country which said guilt. That's why, my lord, legislature said, don't arrest unless you've gathered material and it's necessary to arrest. That's the reason, my lord. And therefore, my lord, your lordship will see adjudicating authority material is how sacrosanct. because if the adjudicating authority confirms the attachment or, my lord, confirms the seizure, then, my lord, the confiscation can't take place there. The confiscation, now the goalpost will shift to the trial court, which is going to try the criminal offense. And that court will eventually decide under section 8(5) whether to confiscate the property or not. Somebody it is involved in money laundering or not. So, my lord, that's another feature. So, my lord, it's an intersect connection between, my lord, the adjudicating authority and, my lord, the criminal courts in the PMLA case. Even the scheduled offense seat will get changed, my lord, now. The moment, my lord, they file a complaint and cognizance is taken by a special court under PMLA, the, my lord, proceedings before the scheduled offense court will stand shifted, my lord, they have to be committed to this court. Because, my lord, all over the world, and I, my lord, happen to do few cases from US and, my lord, Netherlands, 2 countries, my lord, and of course UK, 3 countries, my lord, and the fallout in India. And I must tell you, lordships, my lord, one investigating agency held them accountable for, my lord, cheating, forgery, fraud, and money laundering. Every aspect included, including corruption. So, my lord, one investigating agency. But India, my lord, we have a federal structure. So, my lord, it could be different police. We have one central agency, which is, my lord, again, a reconciliation. Tomorrow, my lord, I have a patch to argue, where, my lord, the Supreme Court is looking into another feature, whether, my lord, they're finding in Vijay Madanlal Chaudhary that the moment scheduled offense person is acquitted or discharged, PMLA will fall. They want to revisit it. But, my lord, it's an honorable 2 judges bench. I don't know which way the ball will swing. They are looking at it tomorrow at 2 p.m. Even that batch is kept. So, my lord, it's an evolution, work in progress. These few paragraphs, my lord, if your lordships would read, what I'm trying to make out is, my lord, that if I'm able to show, my lord, that the arrest is not based upon any either, my lord, material. I'm not saying, my lord, it is not based on any material. If he has not shown that material, or it was not sure of the material, or it was not the material on the basis of which an inference was drawn, or an inference was wrongly drawn, which was, my lord, not based on material, then any other inference which may have been based upon some material can't, my lord, save the, my lord, illegal action, because, my lord, it is like, my lord, a bad fish. It will spoil the entire pond. One factor, my lord, that's why, my lord, I was read Khudiram Das. I just read for one purpose, brother, which was to demonstrate that, my lord, the human mind does not work in compartments. Whenever you gather impressions in totality. I leave these thoughts to your lordships, my lord. I have, my lord, only one submission to make, and that's, my lord, a fervent appeal, and that is, my lord, that let, my lord, in the pursuit of justice, let, my lord, none should seek salvation, and that is, my lord, Shakespeare's quote, not mine. I leave it at that, my lord. I'll file a written note if my lords would permit me, or, my lord, if not required, I won't do that.
Notes you file, let me, because one thing, what is pending now? Which point is pending before the Honorable Supreme Court?
My lord, one review is pending.
Not in this matter.
In this matter, my lord?
No, in the arrest part.
No, nothing in arrest part. In arrest part has, my lord, taken a leap forward after Kejriwal necessity to arrest. 2 questions were referred. Just see Kejriwal's para 85.
No, this one has been referred. Bihan Kumar has been.
No, Bihan Kumar is clear, my lord. And so is Ashish Kakkar. It's a PMLA case. Did I give you lordships Ashish Kakkar? My lords know that?
No,
Ashish Kakkar is one of the latest by my lord Justice Sundaresh judgment.
Mihir Rajesh Shah. That is a matter which I think is being reconsidered.
No, my lord, which matter are you lordships referring to, my lord? Probably I would know, but there is a possibility that I may have eschewed something. But my lord,
Rajesh Shah versus State of Maharashtra, CAV is there.
Oh, that's right. That's, my lord, on a different footing. I argued that, my lord. I happened to argue in council in that. I argued that posh case, my lord, that posh Pune case. I told you lordships the other day. In this case, my lord, the issue is whether grounds of arrest, where, my lord, Prabir Purkasta says in every case, in every offense, then grounds of arrest have to be served in every case, number 1. Number 2, if they have to be served, then have they to be served at the time of arrest, or have they to be formulated prior to arrest, or there is some time for the officer to, my lord, give those grounds of arrest. That's the issue on which we argued. Court, my lord, granted leave, heard us, reserved the judgment, and I must say, my lord, all, including Mihir Shah, everybody is granted bail by the Supreme Court, while reserving the judgment, of course. So, my lord, I can circulate that order also, my lord. I'll do that. Just now. You understand? Shivani Agarwal. I am, my lord, for Shivani Agarwal in this case. It's a second matter in that batch. And, my lord, that's a posh. She was the mother of that young minor child who was driving the car, which resulted in death of 2 persons. So the allegation against her that she swapped, my lord, her blood sample with that of her son to save him. So she remained inside for considerable time, but no grounds of arrest were served on her. And my lord, after Purkastha, she also filed a writ in Bombay High Court. Bombay High Court referred the matter to a larger bench, saying that we have to reconcile this position. It doesn't appear logical that in every case you will have to serve grounds of arrest, etc. It was doubted. That's how, my lord, we filed SLPs. Matter traveled to the Supreme Court and the judgment is reserved. But my lord, that has nothing to do with this one. This one is more than clear. From Pankaj Bansal's case clear. Thereafter, my lord, I showed your lordships Ram Kishore Arora, my lord Justice Bela Trivedi's judgment, which said that this is prospective from the date of Pankaj Bansal case, that is 3rd October 23. That's not a debate in my case. They're not saying I'm not entitled to. They are saying we have complied with it. I'm saying, my lord, this compliance is only a paper formality.
Your case is a bit different.
Absolutely different. I'm totally covered, if at all, by Arvind Kejriwal. If I'm able to make out a case, my lord, within those parameters, I ought to succeed. If I do not, my lord, of course, I have to meet my doomsday. So whatever way your lordships would take it, my lord, I'll circulate a quick short note, my lord, and I'll try and incorporate whatever my brother has argued also for, my lord, what I understand. But my lord, of course, my brother is at liberty to file his own note.
My lord, hearing concludes today.
You want for time, man.
My submission is very limited.
You want, you can file a bullet points. Another day I'm giving you. Anybody can file.
Correct. By tomorrow, my lord, we'll circulate.
My lord, we shall file. How tomorrow ki karenge?
Day after tomorrow, I'm keeping them only bullet points. Don't give long.
My lord, give us time only till tomorrow evening to circulate it. That's it. By tomorrow, before the court hours, we'll circulate.
Day after tomorrow
morning. Please, your lordship. All right. Deeply obliged.
So should I?
My lord, may we get time till Friday, if it be my lord's pleasure, because
Friday morning then you submit.
Friday ho jaye. Yes,
Lord, should we then, my lords, are not closing it then, my lord? Is it still open?
Arguments closed.
Keeping it open, hearing is concluded, but I'm fixing it for filing your
notes.
Notes.
Only notes, my lord.
Only
Then I need not come, my lord. I'll circulate the note, my lord. I'm grateful, my lord. Grateful. It was a privilege to appear, my lord. Please, my lord.
Hearing concluded. The petitioner as well as the state Directorate of Enforcement intends to file a written notes of argument. So I'm keeping it under to be mentioned. Morning you file that.
Are you filing it?
হবে না তাহলে।
4 I will come and at 4 I will come and file it because from morning, my lord, I have.
Or your lordships may keep it on Thursday at 4, my lord.
That I propose that he
I won't be able to finish. Thursday I will do it because tomorrow and day after tomorrow.
Government infrastructure is also challenging. Na? Government infrastructure is also challenging.
That's right, my lord. I bow before that. I was told by my lord none other than at that time the Solicitor General of India, Mr. Gopal Subramaniam, my lord. He met me at the airport and I said, sir, leave this, come back to private practice. We are missing you. And he said, Vikram, you don't become a complete lawyer unless you represented the state. I remain an incomplete lawyer, my lord.
On the 16th তারিখ, on 16th of May 2025. This will be there in the list.
At 4:30
3:30, if you call resolution, nobody is there.
We have to file only the notes of submission. Just notes of submission. No.
Let's settle at 2 p.m.
Even if there is,
The matter will be there in the list. Up to 4:30, I am there. You file it.
Yes, because
well, my landed friends will also come, my lord. Keep it 4:30.
No, they will not come.
Yes, will be there, sir. They are also busy in other matters. I cannot ask them to wait for me.
List with petition. Another heading to be mentioned on 16th of May 2023. It will be there in the list to be mentioned. Whenever you come, you give the.
Deeply obliged.
I'm grateful.
Grateful.
Sure.
My lord.
Who is your other side?
My lord, still it is continuing.
He wants
7 o'clock.
Who is your other side?
That's from Kolkata, my lord, half a second. My lord, Justice Supreme Court. I went out from his court almost on 12 occasions at 8 p.m. in Supreme Court. I think your lordships are taking your lordship.
Who is your other side?
My lordship.
Has he appeared earlier?
Yes, my lord, appeared, my lord, matter was 6:40.
Other side appeared.
He was here, my lord, first. But now he's.
Oh, the Shopunda আছে. You come, your matter. You come tomorrow, then bring her. Tomorrow, day after you come. Tomorrow I have got urgency. I've got committee meetings. Day after tomorrow you come.
3:30.
তো কি আছে দেখি চলে এসো চলে এসো
At 4 p.m.
হ্যাঁ এসো 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 শুনি না কি আছে নিচে একটা বেশ কালকে কিছু দেখো না কালকে কিন্তু আমাকে গালাগালি করবে সবাই ড্রাগ ডিসপোজাল কমিটি সব জজেরা বসে থাকে
তোমারটাই বলছি সাপ্লিমেন্টারি দিয়েছো ওখান থেকেই বলে দিচ্ছে
কি হয়েছে
আমি তোমার বলছি না
আমিও কিছু আপনার
টেস্টটা করে দিই but he has a grievance lot in the writ petition and has filed a supplementary giving certain names who have been examined or not examined. That is the his grievance. But I had a talk.
These other sides don't remain, you take resolution, bring the other side, I will do the matter. Both the sides there, I will do the matter. After court hours, after court hours, I cannot pressure both the sides. Both the sides must be there on their own.
I'm not the, I had a talk with him, not the inspector in charge, Krishnanagar police station. Supplement affidavit din. If your lordship kindly takes up the supplement, বলছি বাবা তোমার কথাই বলছি তোমার supplementary নিয়ে but supplementary affidavit lord if your lordship kindly see the instant case is an example of intentional deliberate so and so that opposite party in order to search then lord relevant there are several paragraph 5 page 3 several vital witnesses in the case who have been deliberately left out both the investigation so and so. Father of the petitioner, namely Ashish Kumar Kundu. Ashish Kumar Kundu, who on so and so went to the house of the alleged accused persons, namely Rahul Babu. But we have no objection, Lord. If your lordship can grant us, Lord, the 30 days time, but we shall make it further investigation and file the report before the appropriate court.
Further investigation?
No, not further investigation, charge sheet, subsequent. But this has to be examined. Ashish Kumar Kundu. And then Lord Sumon Chando, who is a neighbor. But we called them. But since he has stated that now nothing, I know nothing. That's why we have not recorded his statement. Sumon Chando. We can also not record his statement. One Ullus Kumar.
দেখি এটা কি একটু ক্রস এক্সামিনেশন আরম্ভ হবার কথা আবার ওপেন করে দিলি তো
that is the whole difficulty. That is the whole difficulty.
Trial is going to
because when charge sheet was filed, investigation, there was no Naraji petition or nothing else.
So this is not change of the PP.
No, not change.
This relates to the unfortunate death of an 18-year-old.
PS case is of which year?
This is of 2024.
24.
This is Krishnanagar matter, right?
And one sent to Sannal.
এটা তো নেবার কথা ছিল না তো পিপি ম্যাটারটা নেবার কথা ছিল
This matter. Sutopa আছে আচ্ছা
ফাইলটা কোথায় পাচ্ছেন না এটা when was the charge sheet submitted?
Charge sheet কখন সাবমিট হয়েছে 13 December 2024.
Committed already?
Yes.
Case committed?
Trial started. Trial started,
but we have not deposed. It's fixed on 18th June 2000.
All right, what I am doing, Mr. A, you record the statements.
My lord.
And come to me. Thereafter, I will pass the order. Otherwise, the trial will be spoiled, sir.
As your lordship.
Another part. Lordship wanted me to demonstrate these names by filing a supplementary charge sheet in order to establish
supplementary
affidavit in order to make the foundation of this case, because this particular case, my lord, why I have alleged the entire investigation to be the tainted investigation is based on the investigation itself. But you kindly consider several parts of this investigation.
So let them come out.
Then Milord,
What I'm telling you,
Yes,
whatever is going,
but since my learned friend will
even after 3-4 witnesses are done, after that Puja ki case ache single naki Puja single case.
Madam Puja Pal.
Puja Pal. That also I can give
Because
reinvestigation.
there are other part which has to be.
Other part other part I will look into. Let them first record the statement of the huge number of witnesses. You have
other part means first scene. First scene. Milord, I've already told him that the who made the complaint, but he said
I am giving
কাজের মাসির কাছে শুনেছি তো কাজের মাসি we shall find out কাজের মাসি
1 2 3 4
but
There is one person who has been remained undetected, the person who first saw the dead body. Kindly, this is from the
না
record.
বাড়াবো না আমি আর six
Milord,
witness-
then Milord-
six witnesses has been named in the supplementary
my
affidavit.
also.
You work on this
yes
and you come up with a progress report.
my lord
Once
and Milord, then Milord, I'll take the point. But when the charge sheet was filed investigation, there was no steps taken.
No, we have come for this court.
No, why?
ঠিক আছে চলে আসুন I am keeping the matter pending. In the meantime,
In the morning, your lordship said that whether read court in every cases can exercise his power.
No, that I.
Assumption of no. Assume the charge.
It's a murder case.
It's a rape and murder of 18 years.
ঠিক আছে ওই ইয়ে করে দিচ্ছি আচ্ছা petitioner has
This
filed
next to the SP office.
petitioner has filed a supplementary affidavit
বলো না
relating to certain non-examination of witnesses. Full stop.
Item number
A copy of the supplementary affidavit has been handed over to the learned advocate appearing on behalf of the state.
করা হয়েছে আছে আপনাদের রেকর্ড নেই রেকর্ড করে নিন
Another part.
State will assess regarding the contents,
my lord,
as well as in the backgrounds of the
Paragraph C also is very important.
as well as the background of the facts of the case, locus of the present witnesses, and thereafter, if the investigating officer is of the opinion, will take steps in accordance with law.
My lord.
Further progress report be submitted before this court. এগুলো হোক না রে বাবা নষ্ট হয়ে যাবে মামলাটা
By this time, Lordship, they should not take any step in.
না ট্রায়াল আর
আরে ভাই এখানে আমি আছি কথা দিচ্ছি কত আইসি দাঁড়িয়ে আছে তারপরে বলবো আচ্ছা তো দোকান নাকি কিনে নিয়ে চলে যাও
The witness is fixed on 18th of June. That's what you said. What will happen? Examination in chief to আর কি হবে? What will happen?
Cross-examination.
Cross examination আরো ভালো হয়ে যাবে কিছু এগোয় না দেওয়ার করে
Kindly come to one paragraph, paragraph C. Subparagraph C or paragraph 5.
হ্যাঁ ঠিকই আছে
That the as
Bullus
the
Kumar,
in
নাকি?
spite of knowledge of the moreover, police authority has failed to find out the person who saw the dead body of the petitioner's daughter.
আরে ভাই
as
বললাম
an
তো করে দেবো
unknown
তো
body.
বলে
It's a
দিলাম
past
তো
person.
বলছি কাজের
That
মাসে
has not been detected.
I will ask your officer to come up with the
Yes,
statement.
yes, I had a talk with I had also told my learned friend also.
Question.
ও এখন মক্কেল আছে
On ওই
মক্কেল আছে ও আমার উপর ধর্ম
কবে রাখবো ওই তো আমি এখন তো হবে না সেই ফিরে আসি This will be in the monthly list of June I am keeping.
And you mentioned
By that time, let me come back. I am not there.
Yes.
I am not there actually.
That's why, Lordship, I request your Lordship to kindly direct them. Only one day trial. If it is delayed, nothing will.
এমনি আসবে না তো
কেন ডিলে কি হবে কেমন কথা বলছো তুমি
তো হয় না ট্রায়াল করতে
তোমারও
অত
ক্ষতি
ভালো
হবে না
তো
ইউ উইল নট বি প্রেজুডিস
কিচ্ছু হবে না চিফও হবে না আমি জানি আরে
কোর্ট ইজ নট পাওয়ারলেস যদি সেরকম হয় কোর্ট
if it progresses I will stall the proceedings.
Otherwise, Lordship, what has happened in that case of Pratima Datta? Everything happened. Everybody got acquitted. Thereafter, everything got reversed.
এই সিবিআই হয়েছে তো প্রতিমা দত্ত তাহলে আমার মাঝে কথা বলছো
সেটা পরে
On
সিবিআই কি করছে কিছু তো করেনি চুপচাপ আছে তো
on the next date fixed for hearing,
হ্যাঁ
list the writ petition in the monthly list of June.
I mean, one person, one main person, not,
Same heading, same
not,
heading.
এক minute,
Mention the
not
matter.
one main person who is in custody. For the delay of trial, he has already preferred an application for bail.
জানি আমি যার জন্য আমি স্টেটা দিতে চাই না
Yes.
গিয়ে দেখালেই বেল পেয়ে যাবে
Ah,
this is the greatest problem in
my
criminal
lord,
court.
your
You're
lordship
going to
kindly
balance all
consider
the
that.
circumstances. Whatever is
But your
being
lordship
done,
kindly will not record that. Otherwise, they will take advantage that court is in session, then trial will be frustrated.
না,
Your lordship kindly will.
আচ্ছা pendency of the writ petition will not deter.
Lordship, kindly do not.
Wait sir, that will be for your better. আসামি
bail হয়ে
বেরিয়ে
যাবে
গেলে
ভাই,
তখন
তোমার
বুঝতে
ব্যাপার কি
পারবে
হবে?
Pendency of the writ petition will not, whatever you do. Papers must be pending. Instead, the writ petition will not deter the trial court to exercise its own discretion for proceeding with the case.
And deeply obliged, your lord.
Lordship, another aspect, Lordship,
আর কিছু নেই, আর
Colin and Mr. Banerjee is there, but we change matter.
এই আমি এখন মানে kindly allow him to rise. Allow him to rise. কি বলছে বলো তো একটা মানুষকে কত রকম